as was the case with all meetings in the Oval Office when the President was there, this meeting with Mr. Dean was recorded. At the President's request, I recently reviewed the recording of that meeting, at which I was present throughout, in order to report on its contents to the President. I should interject here that I also reviewed the recording of the March 21st meeting of the President, Mr. Dean, and myself for the same purpose, and I have made reports to the President on both of these meetings. I have not at any time listened to any other recordings of the meetings in the President's office or of the President's phone calls. The President did not open the meeting of September 15th with the statement that, quote, Bob has kept me posted on your handling of the Watergate, close quote, or anything even remotely resembling that.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. This was one of the most fascinating days in 7 weeks of Watergate hearings. The reputed Superman of the Nixon White House, Bob Haldeman, came on like mild-mannered Clark Kent and then casually dropped sensational news. President Nixon has let him listen to 2 of the White House tapes that the Irvin Committee and the federal prosecutor are desperate to get their hands on. Moreover, Mr. Haldeman listened to one of the recordings just a few days ago, long after he left the government, and he took the tape home to do so. Mr. Haldeman's account of what is on the tapes of 2 important meetings is largely what John Dean said it was, but Haldeman says Dean put entirely the wrong interpretation on it. This dramatic development shocked the committee out of its obvious exhaustion and equally obvious internal animosities. During the last hours of John Ehrlichman's 5-day appearance, there was evidence of open bitterness and partisanship, but all was smoothed over in a session at the end today when the disputants said something nice about each other.
Ehrlichman said after his testimony that he has no fear of being indicted because, as he put it, I've done nothing wrong. NPAC's Peter Kay asked him for an evaluation of his testimony as Ehrlichman left the hearing room.
How do you think you did?
How do I think I did?
Yeah, as a witness.
Well, that of course is a question of what your goals were. My goals were to tell what I knew about a list of subjects, and if you'll remember in my opening statement, I laid that list out as plainly as I could, and I've been keeping tabs as we went along every day and checking off the subjects as we got through them, and by George, we got through the next to the last one about 20 minutes before the end. So I felt pretty good that we had covered the ground. That was my principal concern, that we cover the ground and that I get an opportunity to fully develop the facts as I recall them or have been able to learn them from research.
The committee decided today to push on and finish the Watergate phase of its public inquiry before taking a summer vacation. This means no adjournment this Friday and 6 more witnesses after Haldeman. Former FBI Director L. Patrick Gray, Deputy CIA Director Vernon Walters, the former number 1 and number 2 men at CIA, Richard Helms and General Robert Cushman, former Attorney General Richard Kleindienst, and Assistant Attorney General Henry Peterson. In order to get through all of these people as quickly as possible, the committee is adopting a faster game plan. It will hang in there later in the afternoon, start 30 minutes earlier in the morning, take shorter lunch breaks, try to keep going through Senate votes, and most importantly, impose a 10-minute time rule for each senator's round of questions. The plan would then be to try to wrap up things by a week from Friday, August the 10th. We shall see about that. For the record, the vote on the decision to keep going was the committee's first 4-3 vote, with Senators Irvin, Baker, and Montoya on the losing side.
Tonight's playback is one of our longest and probably one of the most important in 33 days of testimony. To help you chart a course through the words of John Ehrlichman and H.R. Haldeman, here is NPAC's hour-by-hour viewing guide. In hour number 1, John Ehrlichman says he didn't immediately inform the President of the Ellsberg break-in because once it occurred, there was nothing the President could do. Asked about his exit from the White House, Ehrlichman said it was due to appearance problems because he had no legal liability. In the second hour, Ehrlichman is asked if he knew the president had been told that national security burglaries were illegal. He says no, and he characterized as perfectly silly the allegation he ordered Patrick Gray to destroy documents. In hour number 3, Ehrlichman testifies that Charles Colson was on hand when plans were made to open Howard Hunt's safe. When confronted with conflicting testimony from Colson, Ehrlichman still maintained that Colson was there. And in that hour, he says a call to John Dean, requesting him to stand firm on the Hunt files given to Gray, did not amount to a cover-up. In the fourth hour, Ehrlichman labeled John Dean's version about offers of executive clemency nonsense, saying they never took place. And in his closing statement, Ehrlichman took issue with Gordon Straughn's advice to young people. He challenged young people to come to Washington and do better. In the fifth hour, H.R. Haldeman begins his statement, saying that a 1970 domestic spy plan was approved but was withdrawn and never went into effect. He said that Donald Segretti's dirty tricks operation, as originally conceived, contained nothing wrong. In the sixth hour, Haldeman denied that he ever ordered Straughan to clean his files. And in that hour, he admits he listened to the president's tape of the September 15th meeting with John Dean. In the seventh hour, Haldeman reveals that he obtained the tape of the March 21st Dean meeting with the president and played it at home. Also in that hour, he says that Dean's conflicting dates about when he discussed clemency with the president was a genuine confusion. Now to the hearings that Senator Ervin opened today with a lecture to the audience on decorum.
I have on a number of occasions requested the audience to refrain from any action which indicates approval or disapproval of anybody, or of any question, or any answer. And I'm going to have to, much reluctance. It does not assist the committee for people to demonstrate, and I'm going to have to instruct the officers to eject from the hearing room anybody who engages in any demonstration in the future. During the examination of Secretary Stans, he was asked certain questions with reference to the existence of a fund in the Department of Commerce. While he was Secretary, he denied the existence of such a fund. And I have received a letter from his attorneys, this letter, July the 27th, 1973. This letter is another appeal to your committee to act in a spirit of fairness which requires the clearing up of the misleading record made during the appearance of Honorable Morris H. Stans on June 12, 1973 over nationwide television. I addressed a hand-delivered letter to you on July the 5th, 1973, together with enclosures. Copies are attached. As noted in that letter, even though Mr. Stans denied that he had ever seen the Magruder memo, copy attached, and stated that there was no such political fund in the Department of Commerce, the media, based upon your hearing record, erroneously referred to $1 million secret fund which in fact did not exist. In addition to the letter from Richard Whitney and two affidavits from former Secretary of Commerce for Administration, Larry A. Jobe, furnished earlier, we enclose herewith another affidavit from Joseph E. Casson, former Executive Assistant to Mr. Stans at Commerce, stating that he had advised Mr. Magruder's office that no such political fund existed or was contemplated. Moreover, Mr. Casson has told me that he never discussed the fund inquiries with Mr. Stans and that no one else did in his presence. It is abundantly clear that Mr. Stans has never seen the Magruder memo prior to his testimony, and that there was no such political fund. If he had been asked about the memo in staff interviews, he could have clarified the matter. That was not done, however. Mr. Stans was asked to identify a memo he had never seen. Later, your committee had Mr. Magruder affirm he had written the memo but did not pursue any facts of the non-existent political fund. As a result, the public has been misled by Mr. Stanz's damage and embarrassment. Feeling that the only way to correct this matter fairly is a clarified statement in your public and televised hearing, we suggested to Staff Counsel that the record be cleared up without delay in accordance with the enclosures. See proposed statement furnished on July 11, 1973. We again request this action be taken without further delay. Pursuant to this request, there's a great many documents that would take a long time to read over TV, but they state in effect exactly what Mr. Stanz testified, namely that there was no such political fund in his department. He stated that very positively. I, of course, don't know what the news media, he also stated at that time that corroborated the testimony of Mr. Sloan to the effect that there was $1 million which had been spent out of funds kept in safes in the offices of the committee. And I don't know what the news media referred to, but in an effort to be fair to Mr. Stanz, who positively denied the existence of any such fund when he testified, it will assert in the record without objection on the part of any member of the committee the letter from Mr. Stanz's attorney dated July the 5th, 1973, a letter from Richard P. Whitney, or a copy of a letter from Richard P. Whitney to Mr. David Dawson of the committee staff dated June the 25th, 1973, a letter from a verified letter from Mr. Larry A. Jobe to the chairman of the committee dated June the 18th, 1973, a letter from Mr. Larry A. Jobe to Mr. David Dawson dated June the 29th, 1973, and certain exhibits attached thereto, and a statement from Mr. Larry A. Jobe dated to Secretary Stanz dated January the 19th, 1972, and a copy of the Magruder statement next to that letter, July the 28th, 1972, in the form of a confidential memorandum for the Attorney General, and an affidavit by Joseph E. Casson, dated the 23rd day of July, 1973, and a statement for the record which was received by the committee on July the 27th, 1973. All of these will be admitted in the record, and I will state on behalf of the committee that these are documents which tend to corroborate Mr. Stanz's testimony that there was no political fund in the Department of Commerce while he was secretary of that department. And I trust that this clarifies the situation sufficiently.
Mr. Chairman, I have two short matters which are the result of weekend research but go to questions which were asked on Friday near the close of the session. I wonder if I might be permitted to supplement the record.
Yes.
The first has to do with the question of the propriety of the manner in which Mr. Stanz's testimony was presented to the grand jury. It appears that this question has been decided by the United States Court of Appeals in the Second Circuit in a recent case involving alleged corruption in the office of the Speaker of the House of Representatives. It's the case of United States versus Swag, and in that case, Swag, who was the Speaker McCormick's administrative assistant with
was charged with accepting bribes or committing other illegalities as administrative assistant. Representative McCormick, a Democrat of Massachusetts, was asked to give his testimony to the grand jury, and the testimony was taken not by personal appearance before the grand jury, but by 3 assistant United States attorneys coming to his office on 2 occasions. On one of those occasions, taking his testimony in the presence of Mr. McCormick's nephew, an outsider to the proceeding. The defendant in the case appealed to the United States Court of Appeals, stating very much the same kind of objection that was stated here to the procedure. In 441 Fed 2nd at page 114, the court approved the taking of Speaker McCormick's testimony for grand jury use by this process.
I will look into that decision. I have looked in the federal statute. I can find no statute which warrants the taking outside of the presence of a grand jury of the statement of any witness for presentation to a grand jury where that witness is available, is able-bodied, and is available to the grand jury. And I would, so far as I've found, but I will look into that case and see if it reveals any such.
You and Mr. Swag read the statute the same way, but the Second Circuit disagreed with it.
Well, I think that's a different principle. When you get on the trial of a case, the court does not undertake, the trial court does not undertake to review what kind of testimony was presented before the grand jury.
Mr. Chairman, could I ask for the citation
Yes,
of the
sir.
case again?
It's 114 federal, pardon me, 441 Federal Second at page 114.
What, and that was from the U.S. Second Circuit
Second
Court of
Circuit,
Appeals?
yes, sir.
414?
At page 114. 441 Fed Second at 114.
Thank you very
And I
much.
might
It's a
state,
1971 case.
and I might state for the purpose of shedding further light on this subject, I request the staff of the committee to communicate with the Department of Justice and with the United States District Attorney for the District of Columbia and with the Assistant District Attorneys who had actual charge of the prosecution of the case and with the Special Prosecutor, and ask them to furnish to this committee a copy of the statement made by Secretary Stans in the Department of Justice to the prosecuting attorneys. That would clearly be admissible either to corroborate or to contradict Secretary Stans, and it would not fall within the immunity, the exemption provision of testimony before the grand jury because it would be a statement made before third parties. And I ask the staff to ask that.
Mr. Chairman, the other matter that I have...
Before you go on, Mr. Ehrlichman, do I understand, Mr. Chairman, that you're asking for a copy of the statement made by Mr. Stans to the U.S. attorneys that was subsequently submitted to the grand jury?
I don't know whether it's submitted to the grand jury or not.
Well,
I don't know what was submitted to the grand jury, and I have no way to find out.
Or do we make a distinction between what was and was not submitted?
Yes.
Thank you.
In other words, all I want is a statement that was made to in the presence of the prosecuting attorneys. I don't want anything that happened before the grand jury.
Mr.
I'm
Chairman,
not entitled to it.
the other matter I have was in supplement to my answer to Senator Montoya on the subject of tax returns. I've been provided with a copy of the congressional record for April 16, 1970, pages 5911 to 5924, which is a colloquy bringing forth contrasting procedures under the Kennedy administration and the Nixon administration with regard to White House access to income tax returns and other tax records. It appears that the regulations which the Nixon administration imposed upon such access were a novelty. They had not been in effect before. They required requests in writing, and they enumerate the number of such, such White House requests up to this 1970 date, and it's a total of 9 requests. I would point out to the committee also the practice under the Kennedy administration where 6 days after inauguration, Mr. Bellino, special consultant of the President, called on the Commissioner of Internal Revenue and
undertook inspection of many, many tax returns for days at a time. There's an extensive description of Mr. Bellino's examination of the tax returns of various individuals for, quote, days on end, unquote, at page 5913.
Did President Nixon at any time between the time that the break-in of the Democratic headquarters in the Watergate became public knowledge, down to the 21st day of March 1973, ask you to ascertain for his enlightenment how it happened that the burglars some of the burglars caught in the Watergate had funds in their pockets which came from the committee to re-elect the president?
Asked me to personally ascertain that, Mr. Chairman. He did not ask me to personally involve myself in any inquiry or investigation in this matter until March 30th. He did ask me, and the only request of me that might bear on this was a request he made to me about the 6th of July, a matter of 3 weeks after the break-in, where he asked me to direct Pat Gray, the director of the FBI, to make an unlimited investigation and to take no instructions from anyone as to the scope of the investigation. But Mr. Gray alone was to determine that scope, and I did convey those instructions to Mr. Gray.
Now, I may be wrong, but I construed your testimony that the president asked you to talk to General Walters about funds that had been sent into Mexico.
Not specifically, no, sir.
Well, those funds mentioned by you to General Walters?
Those funds were mentioned in the meeting, and I can't recall who raised the question, but that circumstance, not the funds themselves, but the circumstance of there being a Mexican source of money somehow came up in the meeting by one of the participants using that as an example of the kind of thing which might involve a CIA activity.
Well, did you not later learn that those funds were found their way into the bank account of Bernard L. Barker?
Sir, as I understand it, the CIA, about 6 days later, determined that there was no connection with any CIA activity, and they so informed the FBI on the 29th, I believe it was, and that letter of July 6th between the CIA and the FBI gives the date, but I think it was about 6 days later, the CIA told the FBI there was no so-called Mexican connection.
Yeah, that's not an answer to my question. My question was, if you didn't ascertain after that time that those Mexican funds had found their way, at least temporarily, into the bank account of Bernard L. Barker, one of the burglars caught in Watergate?
Well, I didn't have any special knowledge. I believe I read that in the newspaper, Mr. Chairman.
And you also found out that some of those funds that were withdrawn from the Barker bank account were the funds in the pockets and the bedrooms of the burglars.
There again, I believe I read that in the press.
Didn't that suggest to your mind that there was something rotten in the committee to re-elect the president?
Certainly.
Yes. And that was way back in the summer of 1972.
Just about the time that we knew the FBI was all out in its investigation of this matter.
Senator Baker, on my state that having finished myself, I'm going to impose a 10-minute rule on Brother's minutes.
Mr. Chairman, I'll expedite your 10-minute rule somewhat by saying that Mr. Ehrlichman's been on the stand now for his 5th day. We've covered a great amount of testimony. I'm sure there are other questions that would occur to all of us were we permitted now after a recess to go over the transcript and derive and suggest new lines of inquiry. I think, however, Mr. Chairman, in the interest of time, that I'm going to forego any further questions with the full understanding, Mr. Ehrlichman, that if there are other matters, particularly with so-called Phase 2 or Phase 3 of this operation, of this inquiry, having to do with the alleged dirty tricks operation or more in detail about the financial transactions, that I understand you, as other witnesses, would be willing to return and to testify further on that or any other subject.
I would, Senator. I don't believe that I would have a great deal of information on either of those phases to assist you with, but I'm happy to be available.
The point I'm trying to make is if we forego questions now, it does not imply that we cannot ask you questions later. Mr. Wilson handed a copy of the congressional record dealing with income tax practices during the Kennedy and Nixon administrations. Was it your wish that that be examined by the committee or made part of the record, or what was the purpose of the...
I just thought it'd be made part of the record, but if anybody wants to ask any questions about it, make any statement, it's a very long statement.
And relating...
Very long colloquy, rather.
It's your contention that it relates to the testimony of the witness, Mr. Ehrlichman, in response to the queries put largely by Senator Montoya on the examination of income tax returns.
That's the purpose of it, sir.
Mr. Chairman, if there's no objection, I would like to see the document identified for the record and accepted for that purpose. I have no questions, Mr. Chairman.
The document will be identified for the record and received as an exhibit. Senator Talmadge. Senator Inoue.
Thank you, sir. Thank you, Mr. Chairman. Mr. Ehrlichman, may we now study your April 13th, 1973 CC plus Shapiro interview note?
Yes, sir. I'll get my copy. All right, sir.
Will you please proceed, sir? And on the first line, executive privilege, I believe it says.
Yes. I should say that this meeting was held primarily at Mr. Colson's request at the end of the day on the 13th of April. The first thing that he said was that he had some suggestions and points of view that he would like to have conveyed to the President. And that was the purpose of the meeting. But I also conceived of it as some opportunity to develop additional information because I was in the course of this inquiry. That first line refers to RK being Richard Kleindienst's statement to the Congress about executive privilege, and he simply noted that it had the Hill up in arms.
And you'll please proceed, sir.
Then he said that Mr. Hunt, at 2 p.m. on the coming Monday, would once again be testifying, both from the standpoint of hearsay and firsthand. He said his sources were both within the government and Mr. Bittman, Mr. Hunt's attorneys, that he would testify that funds had traveled
What funds are we talking about?
Well, we're talking about these funds for the defendants in the criminal case. That funds from Parkinson and traveled from Parkinson and O'Brien to Hunt to the Cubans, and on other occasions from O'Brien to Hunt to Mrs. Hunt. And I have down the sum of $10,000 in the latter category. He said all of this transmittal of funds information will be coming out. Then he said, with relation to Mr. McCord, as I recall, the setting of this was that McCord was coming up with all sorts of wild stories. His latest story was that Hunt and McCord, and he didn't know whether Liddy had been involved in this or not, had made a trip to Las Vegas. They landed. They had an airplane standing by. They were going to break into the safe of Hank Greenspun, who was a publisher in Las Vegas, and that McCord was saying that this was a maneuver masterminded by Charles Colson. Mr. Colson vehemently denied that he had any knowledge or acquaintanceship with such a maneuver or that he had anything to do with it. And he cited this simply as an example of the far-out kinds of allegations that McCord was making at that time. I said, well, where does such a thing all fit in this whole Watergate business? And he said, well, I don't think that it does fit in McCord's mind that it was some kind of a Howard Hughes operation, allegedly. Now, this, Senator, I hasten to point out, is rankest kind of hearsay, and I don't assert the truth of any of this, but I'm simply describing what Mr. Colson was describing as Mr. McCord's rather extreme charges at that point. Then he went on to tell another version of the inception of the Watergate, which he termed Liddy hearsay, which was to the effect that Howard Hunt opposed the Watergate break-in, the second break-in, that Hunt characterized it as stupid, that Liddy told Hunt that it could not be called off, that Mr. Mitchell had ordered it, and that it must go ahead. Now, here again, Senator, I don't vouch for any of the reliability of that, but that's simply hearsay second or third hand. Mr. Colson said he was also picking up the rumor that Mr. Mitchell had a, quote, blood oath, unquote, to Mr. Liddy that there would be a presidential pardon for Mr. Liddy. He said that he thought that there was a possibility of Liddy corroborating McCord, or pardon me, of Hunt corroborating McCord, and you would have a situation of two people testifying to hearsay, or so-called double hearsay. He then reported to me on information that they were hearing, and again, this is in the rumor stage, about two grand juries who were investigating Mr. Mitchell. In addition to the New York grand jury looking into the Vesco matter, that there was a second grand jury in Washington, D.C., which was looking into money which passed from a man named Klein to Mr. Mitchell in consideration of government contracts for Klein.
Mr. Chairman, I do feel compelled to break in. I discussed this matter, Mr. Hunley, Mr. Mitchell's attorney, and note for the record, in response to a question, Mr. Ehrlichman has now mentioned the Vesco grand jury in New York. He's touching upon another matter that is completely unrelated to this hearing. And I would urge the chairman to rule at this time that there should not be any more evidence taken about this April 13th meeting.
This committee agreed at the start, as I understand it, at least agreed when Mr. Mitchell was here and also when Mr. Stans was here, that we would not go into the Vesco matter. Simply out of while the committee undoubtedly has authority to investigate all campaign contributions, the committee unanimously felt that out of fairness to the Secretary Stans and Mr. Mitchell, and in view of the fact that there was an indictment pending about this, that we ought to refrain from going into it, and I would therefore request that you omit any statement in regard to the Vesco matter.
Mr. Chairman, may I say that I entirely agree with you. It really is probably not a matter of law, but it's a sense of fair play that would indicate that when there is a criminal case pending, when there is an indictment, when there is a trial impending, that not only the witness who may be the named defendant in that case ought not to have to testify on that subject, but I think other witnesses should be cautioned to avoid it as well. I think the statement is well taken, and I commend you for urging that precaution in the interest of fairness. Thank you very much.
And without objection, the committee will strike from the record any testimony thus far given in reference to the Vesco matter.
Mr. Chairman, I might say for myself, I don't feel comfortable about purveying second and third hand hearsay. Yeah. And a great deal of this I cannot assert to be true, but it's simply my notes of a meeting and what someone else asserted to me.
Yes, I think that it's unfortunate that all of those of us who are interrogating witnesses do not confine our questions to elicit from the witness what he has personal knowledge of, or in reference to statements made by parties involved to him. But unfortunately, it seems impossible to enforce that kind of a rule in congressional hearings.
If I may skip then down to the name Mardian
toward the bottom of that page.
Mr. Chairman, in view of the possibility that the rest of this interview might inadvertently touch upon the Vesco trial, I'd like to forego any inquiry at this time and go into something else.
Senator, could I just put one matter in perspective on the last page of these notes? Somehow or another, these notes have appeared in the press, and there are a number of adjectives found on the last page which have been speculated about in the press very unfairly to Mr. Mitchell. I wish, if I may, simply to make clear that these 6 or 7 references to Mr. Mitchell on the last page were Mr. Shapiro's second-hand characterization and did not in any way constitute an evaluation either by Mr. Colson or me of Mr. Mitchell, either as an individual or as a potential witness. And I'm afraid some very cruel inferences have been derived from this last page that are totally unjustified and unfair.
Thank you.
Mr. Ehrlichman, in the last 4 minutes remaining, I have a few questions here which may be a bit repetitious, but just for the record, sir. Did the President ever ask in your presence prior to March of this year for information on exactly how the Watergate break-in came about?
Yes, sir. In this sense, that on repeated occasions, the President asked that a complete and definitive statement of the whole Watergate matter, how it was planned, how it was executed, the whole picture be set down on paper and released. And I have gone through my notes of meetings at which this subject was discussed and can say that on at least 8 occasions the President made that request.
Did the President ever receive satisfaction?
No, sir. And I think one of those occasions was just prior to his sending John Dean to Camp David to set all this down in March of this year. But he asked Clark McGregor to do this back in September. He asked for a statement on a narrow part of this on Segretti in November. Later in the month, around Thanksgiving time, he asked that in response to a letter that he had received from a friend about this expressing real concern about it, he said that he wanted this out and cleaned up before the Congress came back, that a complete definitive statement out. He did the same thing again on December 8th, where he instructed John Dean to do a Watergate summary. He did the same thing on the 11th of December and said he wanted that statement by Christmas. Again, he did it prior to our meeting in La Costa on February 10th, and one of the major purposes of that meeting was to impress upon Mr. Dean the urgency for such a statement. He did it again in my presence in a conference with George Bush on the 20th of March, and again on the 22nd in this meeting that Mr. Mitchell and Dean and Haldeman and I had with the President, where he said that he wanted John Dean to complete such a statement by that
weekend. When were you
weekend.
aware that the President asked Mr. McGregor for information?
Sir?
When did you become aware of the President's request on Mr. McGregor?
On the 13th of September.
Didn't you know at that time that Mr. McGregor didn't have any information to give?
Well, the information had been given in Mr. McGregor's presence and in the President's presence by the Attorney General, Mr. Kleindienst, on the previous day, at which time Mr. Kleindienst assured the Cabinet and Mr. McGregor and others assembled that, in point of fact, no one in the White House was involved, that the investigation had been extremely rigorous by the Department of Justice, that the 7 persons responsible had in fact been indicted, and he gave a total endorsement to the method of investigation and the results of that investigation. The President felt that there were ample facts available at that point for Mr. McGregor to do a definitive statement.
How do you respond to Mr. McGregor's statement that he was, quote, lied to by you?
Well, I think that what Mr. McGregor has done, I saw that in the press over the weekend. Mr. McGregor has said, yes, they asked me to make a statement back in
July, August, and September. But I should have known about the CIA, and I should have known about the special unit, and I should have known about other things that were happening in the White House. It seems to me that if I may say so, that's an irrelevancy. In point of fact, back in the convention and immediately after the convention days and following up on the Attorney General's complete report on the 12th of September to the President and Mr. McGregor and others, that Mr. McGregor was in an excellent position to have stepped out based upon very extensive Department of Justice investigation and made a full and complete statement of the facts as we all believed them at that time.
Won't that have been repetitious? Didn't the Attorney General himself give the President a report?
Yes, sir.
Then why should Mr. McGregor, who was just listening in, give another report?
Well, the thought here was that there should be two reports, one with regard to the White House and White House involvement, which in fact the President did give in August, but the other part of that, and the important part, was the involvement or non-involvement of various committee to re-elect personnel. And that was the report which the President was pressing for from Mr. McGregor in September.
My final question in this round, sir. Mr. Mitchell, in his testimony, suggested that he withheld information from the President. In fact, he lied to the President because he didn't want the lid to be blown off. Did you ever keep information away from the President or lie to the President?
I've certainly never lied to the President, Senator, or at least I hope I never have. Certainly not told him intentionally anything that was not true. Now, as far as keeping things from the President, a great deal of my time was spent in trying to evaluate what should and should not be considered a matter for presidential attention. And certainly I did not indiscriminately just shovel everything that came on my desk to the President. I have made dozens and I suppose hundreds of judgments over the 4 years that matters of information and even matters for decision need not go to the President. That in the hierarchy or priority of how he should devote his time, that this was whatever it was a matter which would needlessly occupy his attention, or that could better be decided by someone else. And so I have on literally hundreds of occasions been involved in a decision of that kind.
Did you consider the break-in on Dr. Fielding's office important enough for presidential notification?
I did not.
That was not important.
It was an event. It had occurred. There wasn't anything that the President could do about it. Wasn't anything he was called upon to do about it. It was in a continuum of investigation, and I simply made the judgment that it would unnecessarily tax his attention under circumstances that really it was something he could do nothing about.
Didn't you consider the meetings involving Mr. Liddy, Mr. Magruder, Mr. Mitchell, Mr. Dean, and the Office of the Attorney General, and later in Key Biscayne was important enough for presidential notification?
Certainly, and I did notify him of that within an hour or two of having learned of it.
When did you learn about this?
I learned about that in my interview with Mr. O'Brien in Key Biscayne, or in San Clemente in the early part of April of this year, on April the 5th.
Didn't you know about this in June of 1972?
No, sir.
You mean to say you were kept in the dark until April of this year?
Yes, sir.
Mr. Strawn never discussed this with you?
No, indeed.
Mr. Dean never discussed this with you? Mr. Haldeman never discussed this with you? Weren't you curious when reports were being made in the press about these meetings?
When reports were being made in the press?
Suggesting that these meetings had been held?
Well, I think those reports, I don't know just when those reports appeared, Senator, but I don't think they were very much previous to my having talked to Mr. O'Brien here.
I thank you very much, sir.
Mr. Chairman, my periscope indicates that the Zweig opinion has been brought to you, and to save some time, it's the last footnote on the last page of the opinion. You don't have to read anything else.
And I was intrigued by this statement in the opinion in requiring Zweig to come before him. It says on page 121, indeed, in an investigation such as the grand jury was conducting here, the grand jury and the government would have been subject to proper criticism if the grand jury had failed to invite Zweig's attendance as a witness. It is altogether in the public interest that grand juries should inquire with care and thoroughness before they file formal charges against anyone.
Mr. Chairman, I might make a statement, if I may, since I indicated when I remarked on this situation on the previous examination of Mr. Ehrlichman that I, too, thought it was improper to conduct the hearings other than before the grand jury. I freely confess I was not aware of the case that you've now presented to me, and I also note that footnote 7 on page 121 lists some 5 or 6 other cases to the same effect, and that the Shepard citations compilation shows that in this case certiorari was denied by the U.S. Supreme Court, which of course has the effect of affirming the Second Circuit Court of Appeals decision. The operative language is footnote 7, which says one such contention, that is that the indictment was defective, is that the indictment should have been dismissed because the grand jury received testimony from Speaker McCormick in an unlawful way. Instead of calling McCormick to testify in person, the grand jury sent 3 assistant U.S. attorneys to interview him on 2 occasions, once in the presence of his nephew. And to make a long story short, the Court of Appeals held and the Supreme Court concurred, inferentially by denying certiorari, that that was the appropriate way to proceed. Now, the question still presented, I suppose, and which this committee ought to reserve, Mr. Chairman, is whether or not the test of inconvenience applied to Speaker McCormick would similarly be applied with the courts to Mr. Stans. And of course we do, or at least I do, reserve that question, but I thank counsel for the case.
Yes, just one other observation on that. When the Supreme Court denies cert, or that is the application for writ certiorari, it makes no decision. It doesn't even express an opinion through it in the lower court is good or bad. Why is it foolish or sound or unsound? It just refuses to take the case. Now, it says here that Speaker McCormick was excused because it was difficult and inconvenient for him to come. That's not the testimony here. The testimony is that it was to spare him the humiliation of having to be confronted with the press. But this is beside the point that I was making. And the point that I'm making is, without regard to the good intentions of the President in requesting that Mr. Stans be excused from a personal appearance, and without regard to your action in communicating the President's request to Mr. Peterson, the fact is that in the absence of an opportunity to cross-examine Mr. Stans, the grand jury might have been denied evidence which would have justified the grand jury in considering whether there should be some indictments returned in respect to persons who were officers of the committee to re-elect the President. It goes to the wisdom of action. I'm not too much concerned about the legality. I think it's very unfortunate for the President of the United States, from even the best of motives, to undertake to make a request which has the effect of obviating an ordinary feature of the judicial process, that is the appearance of a witness before a grand jury, and according to the grand jury, an opportunity to cross-examine the witness.
Mr. Chairman, I'd only say one more thing. I don't want to belabor this point, except to say that as far as I'm concerned, I indicated on the record the other day that I thought it was unlawful to do that. Now I find that it is at least arguably lawful to do that. It was in that particular factual situation when Speaker McCormick was not required to appear before the grand jury but gave his deposition. Now, I think the committee will reserve to the incoming of the report an evaluation of the wisdom or lack of wisdom of doing it that way, but I apologize, and that was the reason for interjection, to the witness and to Mr. Wilson for previously expressing my impression that that was an irregular procedure. Apparently that is not, on its face at least, an irregular procedure, and I have nothing further to say about it.
I think it's irregular in the sense that it's not regular. And I think it's fair unfortunate. We can maybe clear up the fact. We can clear up the matter if we ever get a statement of what he told the prosecuting attorneys. And I certainly agree with the senator from Tennessee that this is a matter to be weighed and considered by the committee later, and not on the spur of this moment. I was merely suggesting some misgivings of mine.
Thank you, Mr. Chairman.
And I have legal misgivings as well as notwithstanding the fact. My experience has been along years of practicing law that I can find a federal decision in one of the circuits that will sustain any point on any side of any question.
Yeah, but it's been my experience practicing law, too, that when the Supreme Court denies certiorari, I'm out of business.
Yeah, and so is the Supreme Court.
Well, that's up to them to decide. I've argued long and hard with them, and sometimes I won and sometimes I lost, and I like it better winning, but that's not always the way it goes.
Oh, Senator Gurney.
Mr. Ehrlichman, on April the 14th, you gave your report to the President on Watergate. On April the 30th, you resigned from the White House staff. Now, in the 2 weeks in between, you had several meetings with the President of the United States. I presume some of these were on Watergate and conversations that led up to your resignation. Will you tell the committee what you said to the President and what the President said to you in these meetings?
Senator, notwithstanding Watergate, the business of the White House went on during those 2 weeks, and quite a few of these meetings were with regard to the business at hand. And I
would understand, and I'm not interested in that.
Right.
Only Watergate matters.
Quite a bit of the conversation during this period of time had to do with John Dean's status in the White House. Henry Peterson became the President's confidant and right-hand man on Watergate following the 15th of April. The President decided that he would work with Mr. Peterson personally. He did. He had a number of meetings with Mr. Peterson. Mr. Peterson gave him a good deal of additional information, which I didn't have, and to which I'm not privy. One of the first things that Mr. Peterson apparently asked the President to do was fire Mr. Haldeman and me.
When was that, do you know?
Well, it must have been very early in the game, shortly on or shortly after the 15th. The President pressed him for the basis of this request. Mr. Peterson acknowledged that there probably was no legal liability, but that he felt that as a matter of appearances, that this is the step that the President should take. At the same time, Mr. Peterson was urging the President not to fire Mr. Dean until such time as the prosecutors had had an opportunity to perfect their negotiations and their interrogation of Mr. Dean. And so there was a lot of conversation between us over this period of time, both as to what our status should be in the White House and what Mr. Dean's status should be. On Monday, the 16th, I believe it was, the President telephoned me and said that he was going to see Mr. Dean that morning. He had decided that Mr. Peterson's desires to the contrary notwithstanding, he was going to request that Dean either take a leave or resign. He asked that letters be prepared that would be appropriate to both of these alternatives, and he more or less dictated what should be in those letters. I say more or less, he literally did dictate what he wanted in them. I had my secretary type them basically from the notes that I took from that conversation with the President, and I understand that later on he did present them to Mr. Dean. Mr. Dean refused to sign either one. So he reported that to me later on in the day. There were those kinds of questions that were going on in discussion. At a point in time,
He asked Mr. Peterson...
Let's stop right there. Did the President tell you why he wanted to fire Mr. Dean or have him resign?
Well, he felt that since Mr. Dean was continuing to come to the White House and apparently had access to his files and to other files, presumably in the central files of the White House, that they had then basically an adversarial relationship, and that it was an unhealthy situation. That there ought to be a clean termination. This obviously did not take place. Mr. Peterson, I gather from talking with the President, Mr. Peterson strongly urged the President, following that, to make no move where Mr. Dean was concerned, and the President acquiesced in that. We became, that is, Mr. Haldeman and I, became the targets of newspaper and other media attention about the 22nd, about Easter, and from then on through the 30th, very vigorous newspaper attack is the only thing I can say. The Los Angeles Times printed a totally dishonest and false story about my intervention in behalf of the Vesco people in some Middle Eastern activity. We were continually finding, I was continually finding myself laying aside the work of the day to prepare press statements or to research documents or things of this kind. And what I'm leading to, Senator, is...
Just a moment, but at that point, I think we should strike from the record, Mr. Chairman. I think we should strike from the record mention of this Vesco case. We're trying to keep this out of
stricken from the record.
Well, it's a...
Mr. Chairman, I just want to state for the record that, you know, the witness is being responsive. He's mentioned his case twice this morning. It just doesn't suffice for Mr. Mitchell's purposes every time it happens to strike it from the record.
Well, we are glad to have your interjection about the Vesco matter, but I believe that's as far as we can go at this time.
In any event,
and I'll ask the witness.
I'm sorry. That was I had a personal interest in that one, I'm afraid, Mr. Chairman, and this was the instance, however, that directly led to my realization that I simply could not do my job there and continue with the denials and the harassment and all that was going on. We began discussing very seriously with the President the need for, and this was separate. I began discussing, and I understand Mr. Haldeman began discussing with the President, the need for a leave of absence about this point in time. And as we progressed into this week of the 23rd of April, that was the subject that was under serious consideration. Alternatives. Who could pick up for me and carry on the domestic side, work the policy questions, move the information to the President, and so on. And by the time the President went to Camp David on, I think, the 27th, after we returned from Mississippi to Senator Stennis's ceremony in Mississippi, I think the President was settled in his own mind, and it was my impression from talking with him on the airplane that he had settled in his own mind that we should take a leave of absence at that point. Mr. Haldeman and I discussed this on the 28th, and it was our mutual view at that point that even the leave of absence thing would be misunderstood and that we should simply make a clean break of it. The President invited us to Camp David on the Sunday, the 29th. We separately discussed with the President our points of view on this at that time. We both had extended private meetings with him, and the upshot of that was that we submitted our resignation.
And in summary, between April the 14th and April the 30th, in these meetings where you discussed Watergate, it was mainly a discussion of how more and more you were becoming ineffective because of the media exposure to Watergate, including you and also Mr. Haldeman. And those were principally the discussions that led up to the resignation?
There were other points obviously being raised. Mr. Peterson was pressing the contention, for instance, that I had urged Hunt to get out of the country and I had urged Mr. Dean to destroy the contents of the safe, and he was playing back to the President in justification of his argument that we should be fired the testimony that was being picked up by the prosecuting attorneys. So I, in turn, was trying to gather such evidence as I could on those points, and as I said before, I talked to the people who were at the meeting of June 19th, and I reported to the President what they had said. Likewise, during this period of time, we consulted counsel and laid out the facts for counsel and took his opinion as to whether or not we were guilty of any legal wrongdoing, and made that report to the President. So we were very much personally involved in trying to indicate to the President what our point of view was, our recollection of the facts, where the truth of this matter lay.
Let me put it this way. In any of these meetings, did the President say to you, John, it's come to my attention that you were involved in the cover-up in such and such a fashion, and I can't keep you on because of that? Did any of the conversations go in this vein?
No, they went in the vein, this fellow is making an accusation against you, meaning John Dean. These are serious allegations. I have confidence that what you're telling me is true, but let's face it, the prosecuting attorney, through Mr. Peterson, is strongly urging that I put you on leave of absence, and I have to listen to that advice.
Did the President ask you to resign?
No, sir.
That's all, Mr. Chairman. In the interest of time, I'm not going to take my full 10 minutes.
Thank you.
In a moment, Senators Montoya and Weicker will have their final questions for John Ehrlichman. Public television's coverage of the Senate hearings will continue after we pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service.
to the President what they had said. Likewise, during this period of time, we consulted counsel and laid out the facts for counsel and took his opinion as to whether or not we were guilty of any legal wrongdoing, and made that report to the President. So we were very much personally involved in trying to indicate to the President what our point of view was, our recollection of the facts, where the truth of this matter lay.
Let me put it this way. In any of these meetings, did the President say to you, John, it's come to my attention that you were involved in the cover-up in such and such a fashion, and I can't keep you on because of that? Did any of the conversations go in this vein?
No, they went in the vein, this fellow is making an accusation against you, being John Dean. These are serious allegations. I have confidence that what you're telling me is true, but let's face it, the prosecuting attorney, through Mr. Peterson, is strongly urging that I put you on leave of absence, and I have to listen to that advice.
Did the President ask you to resign?
No, sir.
That's all, Mr. Chairman. In the interest of time, I'm not going to take my full 10 minutes.
In a moment, Senators Montoya and Weicker will have their final questions for John Ehrlichman. Public television's coverage of the Senate hearings will continue after we pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As we go back to the hearings, Senator Montoya wants to know about recent charges from Clark McGregor former director of the Reelection Committee.
Montoya.
Just have one question, Mr. Chairman. The other day, we brought out that the President in two press conferences, the press conference of April 17th and the press conference of April 30th, 1973, had alluded to the date of March 21st, which was the date, significant date in his mind, when he had really ordered an intensive investigation. Then in your opening statement, you indicated that you had been commissioned by the President to start an investigation, or an inquiry as you called it, on March the 30th. Now, can you tell me what information was given to the President as a result of the intensive investigation which began on March the 21st and up to the time that you assumed your own inquiry on March the 30th?
That was never presented to me, Senator, in any sort of capsulized or organized form. In other words, I didn't sit down with the President and in a situation where he said to me, now here's everything I've learned in the last 9 days. But at the same time, in his reaction to this narrative report, which I gave him, it was evident to me that he had information or impressions, at least, about this matter, which were independent of anything that I was advancing to him. And I know that during the time that I was working on this, on and after the 30th, that the President was not limiting his sources of information to just what I told him. I said the other day that in this meeting of the 22nd of March, the President must have been doing one of two things, either proceeding without any information gained on the 21st, or else he was playing a very cool game and setting traps for people. In my own mind, I'm convinced it was the latter, that the President had picked up enough information to begin to get started on this, and that he was checking a lot of people through a lot of other people. I know, for instance, he had me check on Bob Haldeman, and I'm sure he didn't tell Haldeman that I was doing that.
Well, I assume that when he made the statement at the press conference, to wit, on March 21st, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. I interpret this statement to mean that he received serious charges personally and also through the press. Are you aware of any communication by anyone to the President with respect to serious charges which came to his attention?
Well, I've heard the testimony here that Mr. Dean had this conversation with him on the 21st, and that Mr. Haldeman was in some of that meeting. At the same time, or right around this period of time, Mr. McCord, of course, was making charges both in the press and through a letter to the district judge. I assume that all of those are referred to in that statement, but I don't know.
Well, you're assuming that he was referring partly to the report which Mr. Dean had given him.
I assume so, but I don't know that.
All right. Now, why would not the President come out with this information, and also the information which you imparted to him on April the 14th at his April 17th conference?
Just say, this is everything that I know?
What actually you had imparted to him, and you indicated that you had really given him some very substantial information.
Well, I think in going through the notes here with Senator Inouye and your examination, you see that a lot of what I gave him was hearsay, once and twice removed. I would have felt it very unwise and unfair if the President had simply made a public statement of all of this hearsay at that point in time, it would have very unfairly raised charges and inferences against people that may ultimately prove to be totally false. So I think what it stands for, the whole thing stands for, Senator, is that the President was alerted, he began to move, that he needed a great deal more information even on the 18th of April than he had in order to say definitely this is what happened and this is what happened and this is what happened without being terribly unfair to innocent people.
That's all the questions I have, Mr. Chairman.
Mr. Ehrlichman, when did the name of Judge Byrne first arise, to your knowledge, as a possibility for the FBI directorship?
I believe, Senator, that his name was on the original list of prospects. I don't know when, perhaps back as far as shortly after Director Hoover's death. I'm not sure, but it had always been one of the names on a list of 7 or 8 names.
And you indicated to me in my questioning last Friday that around this period of time of the 7th, 8th of March, there was a certain disenchantment as to Mr. Gray.
Yes, sir.
Would it be somewhere in around that period that other names were being considered?
No, I don't believe as early as that. As the best of my recollection, other names were not really considered until about the time that the President went west, which would have been about the 30th of March. I could be wrong on this, but that's the first that I recall any serious discussion of alternatives.
Well, in that testimony, let's just review certain facts. In the conversation, the taped telephone conversation between yourself and John Dean on March the 7th or 8th, and I'm quoting verbatim now, Ehrlichman, well, I think we ought to let him hang there, let him twist slowly, slowly in the wind. Dean, that's right, I was in with the boss this morning, and that's exactly where he was coming out. He said, I'm not sure that Gray's smart enough to run the Bureau the way he's handling himself. Now, when you were questioned about this last Friday, your response was, and I'm reading verbatim from the transcript, Mr. Ehrlichman, well, Senator, I think you will remember those confirmation hearings and the revelations of the manner in which Mr. Gray responded during the hearings, and I think it is fair to say that there was pretty general disenchantment in the manner in which he handled himself during that time. When I was looking at what I was looking at while you were reading was the various events that took place starting back around the 1st of the month in those hearings and climaxing on the 23rd of March with Mr. Gray saying that John Dean probably lied to the FBI and then later probably recanting that charge to Mr. Dean and admitting that it was an overstatement and so on. At this point in time, there was general disenchantment of Mr. Gray's conduct in the process of confirmation. There is not any question about it, period. Do you recall having an interview with the Chicago Tribune on the 28th of March?
Yes.
Well, let me go ahead and cite to you your responses in that interview. This, mind you, is on the 28th of March, some 20 days after your comments and Dean's comments. And I think they're also, the interview can be taken in the light of what you told this committee last Friday. Question: would the President be unhappy if the Senate refused to confirm L. Patrick Gray as Federal Bureau of Investigation Director in light of the President's repudiation of Gray's offer of raw FBI files to the Senate Judiciary Committee and the subsequent incident in which Gray seemed to tacitly agree that John Dean might have lied to FBI agents? Answer: I don't think that the administration position on Mr. Gray is necessarily related to those two incidents. The President supports Mr. Gray's nomination enthusiastically and has from the beginning. As far as I know, there is no change. Question: is there a backup appointment? No, no one else is under consideration at all. Question: the President made it a point to ask Ron Ziegler, parenthesis White House press secretary, to express his confidence in John Dean the other day. Was the absence of such an expression for Mr. Gray significant in any way? Answer: oh no. Ron, I'm sure, has expressed confidence in Mr. Gray, or he would if asked. I certainly do, and I know the President would want me to. Question: he's still the man for the job as far as you're concerned? Answer: oh, sure. Now, Mr. Ehrlichman, specifically, I would like to know what the version is. Did the White House support Gray's nomination or not?
We supported Gray's nomination right up till the time it was withdrawn. Now, Senator, I'm sure you realize that when a nomination is still up here and still before the Senate, we support that nomination right down the line. What I may say to John Dean privately, the in-house disenchantment with that nomination certainly would never be reflected in statements to the press. Until the President decides that he's going to have to withdraw that nomination, then by George, we're going to root for the team.
Or can we paraphrase it? Or by George, we're going to lie to the press.
We're certainly not going to indicate to the press our disenchantment. That's right.
One last question. I just received this document, and I think it raises some interesting questions. I've not done, and I don't want to impede the time of the committee, the necessary backgrounding on it, except as that I have the document in my hands, and now I'm going to read it to you, and I will show it to you. I don't know if we have a copy or not. It's from the White House, Washington. It's dated October 2nd, 1972. For John Dean, and it is from John Ehrlichman, and it has your initial E on your name there, and I will show this to you. Do we have a copy of it? Yes. Would somebody please give to Mr. Ehrlichman a copy? The memorandum dated October 2nd, 1972, from the White House for John Dean. Herb Kalmbach, thinking ahead to the possibility of the matter of privilege being raised at some time or another, suggested that there should be a written retainer arrangement in existence in advance. He has written out this longhand draft. I'm sure you'll find the basic question of whether or not such a letter is advisable to be the first hurdle. If you think that one may be inadvisable, I would suggest you talk to Herb direct. Otherwise, would you work on a revision, John D. Ehrlichman? Now, the draft which Mr. Kalmbach wrote out reads as follows. Dear Mr. Kalmbach, for your file, this letter is to confirm that you have been and are now acting as legal counsel to the White House on various assignments. In such capacity, as our legal counsel, we expect you to treat these matters as being entirely confidential. We consider all aspects of these assignments to be within the attorney-client privilege, and you are therefore precluded from making any disclosures with respect to these matters. Should you be requested to comment on any of your legal assignments in this regard, we instruct you to invoke the attorney-client privilege rather than respond. Now, this was Mr. Kalmbach's draft, which obviously you read and sent on to Mr. Dean for his comment and or revision. This was October 2nd, 1972, when in effect an attorney-client privilege was trying to be set up in advance. Would you like to explain to this committee as to whether or not, number one, this didn't arouse any suspicions on your part, and why it is that we have to set up attorney-client privileges, attorney-client relationships in order to exert the attorney-client privilege in advance?
Well, as you see from the covering memo, Senator, I'm simply transmitting from Mr. Kalmbach to Mr. Dean a suggestion of Mr. Kalmbach's. I don't relate it to any specific incident or project at all. I can't, Mr. Kalmbach would come once every couple of months and call on me, and we would go down a list of items, and this was one that I recall he left with me at such a meeting. Said that he was concerned about the sort of the informality of his arrangement, and he wasn't vouching for it being a terribly good idea. As you see by the covering memo, I wasn't at all sure whether it was advisable, and I referred it to John Dean. I'm not sure whatever became of this, whether there was any action taken on it or not.
Well, all you say is that whether it's advisable is the first hurdle.
Right, and I don't have
inadvisable, you know, talk to him direct, otherwise with your work on a revision.
I had no, at the time, I had no feel for whether this was a good idea or not.
In other words, you felt this was merely an attempt of Mr. Kalmbach to formalize his relationships with the White House?
That was my assumption, yes. I think that if you take it on its four corners, that's what his handwritten draft says. And I was in no position to judge as to whether that was or was not appropriate under the circumstances.
Well, the whole thrust of his memorandum is to set up this relationship in order that he doesn't have to make any disclosures. Is that correct?
Well, as I say, I think that the basic question, as far as I was concerned here, was not whether there was a relationship or not, but whether this was an advisable thing for the White House to be doing, with an attorney on the outside.
Well, but it's your statement. This is your interpretation. Herb Kalmbach, thinking ahead to the possibility of a matter of privilege being raised at some time or another. This is what you're saying to John Dean.
Right.
Well, why would he be thinking ahead?
Obviously, I'm not in a position at this time, at the time I wrote this, to know what his thought was. As I said, that's something that I asked Dean to get into with Kalmbach direct. I took myself out of it.
And it did not, in conjunction with other matters that you had discussed with Mr. Kalmbach, it has no relationship at all. It's just a matter of trying to formalize his employment status at the White House.
Well, it may have been in connection with something that we discussed, but I wouldn't know.
I have no further questions this time, Mr. Chairman.
It could be.
Mr. Chairman, counsel brings to my attention an omission. Senator Montoya asked me a question about Clark McGregor and his response to my testimony. There is in the committee staff's possession a dictabelt recording of a conversation which Mr. McGregor and I had, which bears on this point, and I would ask that transcription simply be made a part of the record.
Now, the evidence before this committee is that the only things Mr. Kalmbach had done in connection with these matters was that he had raised money and had the money transferred through Ulasewicz to the defendants and their counsel in the criminal action, and that he had disbursed money to Segretti. Isn't this, these documents that Senator Weicker called your attention to, susceptible of the interpretation that it was an effort to cloak him with a specious pretense of having acted in the capacity of counsel so he might invoke the attorney-client privilege?
Well, Senator, I think the first part of your statement is exactly correct, that you're operating on very limited knowledge based on the little bit of evidence that you've had here about what Mr. Kalmbach did. He did a great many other things, some of which he did for the White House.
Now, I don't conceive that money-raising effort to be for the White House, and this attorney-client privilege statement, or this retainer statement, attempts to identify his relationship to the White House, not to the committee to reelect. So I would think just the opposite would be true, and that this would relate to some of those things which he had done in connection with the San Clemente property, or something that was germane to a legitimate White House activity.
Well, there wouldn't have been any necessity for writing out a document to that effect.
Well,
I would respect anything he did as attorney for as a private attorney for the president. I never have heard any evidence here or heard it suggested that he was ever an attorney for the White House. I thought he was a personal attorney to the president.
Well, I hope you'll take the opportunity to take that evidence so that you would have this in proper context.
Well, in the interest of time, I will, if there's no objection on the part of any senator, I'll have these two documents marked exhibit, put it in the record, and we can analyze later what the purpose was.
Mr. Chairman, may I ask that this other document, this telephone transcript, also be included in the record of a conversation between Mr. McGregor and me?
Without objection, Mr. So Alderman.
Thank you, sir.
I have no further questions. Senator Baker. No further questions. Senator Noe. Senator Gurney. Senator Montoya. Senator Wyken. No further questions for senators under the procedure they've turned to the council.
Mr. Ehrlichman. I'm going to be moving on very quickly to the main area of our inquiry, which is the Watergate and the cover-up, but I will just ask a couple questions to get back to the Ellsberg break-in and not getting into the break-in itself. And they will not get into legal questions of legality of the break-in, but the sincerity of your statement that you felt it was legal. Now, the first question that I have to ask in that area, isn't it a fact, Mr. Ehrlichman, that this is the first time you have asserted publicly before any investigating body the claim that the break-in of Dr. Fielding's office was legal for national security?
Well, I think unlike the other investigative bodies, this one goes far beyond mere fact and gets into these associated questions. The other investigative bodies, as you call them, have been basically grand juries where we've not gotten into questions of law, nor, for that matter, the surrounding and sort of collateral questions. So that I've never been called upon, I don't think, to in any way treat of that subject on any previous occasion.
But you have spoken publicly on this subject, have you not, on the so-called Ellsberg break-in?
Well, I don't know what you call speaking public. I've talked to the press.
And you also appeared on Mike Wallace's program, 60 Minutes.
I did.
Do you recall in that interview your statement that there was no way to condone that action? Now, if in fact you believed at that time that it was legal and had as your attorney indicated, the section of the code which gave symbolic basis for the legality, would you be saying there was no way to condone it?
Well, I think you'll remember my testifying here, Mr. Dash, that at the time that it was reported to me, I did not condone it. It was simply beyond my contemplation that there would be a resort to that particular to the break-in in order to do this job that they were assigned to do, this investigation.
But you have testified and spent quite a bit of your time testifying and answered the questions that the break-in was actually a legal act in the interest of national security, that taking your statement that you did not know in advance that that's what they would do, nevertheless, that you indicated that that was perfectly legal under the law in the interest of national security.
I believe that's a sound position.
Now, did you also testify that you spoke to the president in March about it, and that he also indicated to you that he believed that national security required it, and it was justified under national security?
Yes, he did.
Then if he did that in March, you're aware of his May 22nd statement why would it be necessary for the President, in his May 22nd statement, to make a public apology, actually, and take personal responsibility for what he said was illegal means that he was not made aware of in advance? And rather, would he not have stated, as President, if he thought that this was a legal act in the interest of national security, that all acts of the Plumbers Group were legal and in the interest of national security? Why would he feel it necessary to apologize to the people of America and take responsibility and say he had no foreknowledge of any illegal means?
Well, you're asking the wrong person, Mr. Dash, to explain the President's statement of May 22nd. I was gone like 3 weeks at that point and had no part in the preparation of that statement. My statement here, with regard to my understanding of the law, is not meant to speak for the President nor anyone except myself. This is my view based on the advice of eminent counsel, and I think it's a sound one.
Well, when did you first get that view? You said based on advice of eminent counsel. Is it not true that you have recently been advised by counsel, based on the statutes that have been provided for you, that this was a legal act?
Well, certainly.
And that, therefore...
I had no occasion to brief it until I left the White House, Mr. Dash.
Oh, well, then you never really believed at the time or had any viewpoint when the break-in took place that this was legal.
Mm-hmm. Well, I certainly had a viewpoint, and I certainly had a strong feeling of the propriety of the President's actions in attempting to plug these leaks and to
That's not my question.
Well, yes,
that's not my question.
Well,
the question
no,
is the break-in.
Mr. Dash, are you going to interrupt my answers?
No, I want you to answer my question.
Well,
and you've used the questioning for making speeches throughout this hearing.
Let me give my answer, and then if you don't feel it's responsive, why don't you point out to me how it's not? Would that be all right?
Well, I hope you give a responsive answer.
Well, I will do my very best. I understand your question to be whether or not I had a belief or impression that the thing that the President had assigned here in creating this special unit was legal and proper. And my answer to you is that I had a continuing impression that the charge given to Mr. Krogh on the 24th of July was in all respects within the President's constitutional prerogatives. I had then a present impression at that time that this was well within the President's national security powers, and that has continued to be my impression forward. Now, since I left the White House and have retained counsel, obviously they have done some intensive briefing on this subject, and you have seen the fruits of that in the colloquy between the Chairman and Mr. Wilson. That's a much more refined and precise and substantiated position on the law than I had any occasion to make prior to this time.
All right. I'm not, at this point, want to re-raise the legal arguments, because that's not the issue I'm questioning on. Is it also true that you were totally ignorant, Mr. Ehrlichman, of the fact that actually the President and Mr. Haldeman had been informed that surreptitious entries or break-ins for national security purposes were clearly illegal and constituted the crime of burglary prior to that break-in? Were you ever aware of that?
Well, if you're speaking of the Tom Houston memos, of course, the subject there was an entirely different subject, and that was domestic intelligence, domestic security. Here you are dealing in the area of foreign intelligence and national security, and it's quite another subject.
Have you reviewed that document,
no.
Mr. Ehrlichman?
No.
Mr. Ehrlichman, the document deals both with national security and with internal security. And when that document was presented by this committee here in testimony, the chairman, with the support of the committee, excised out those areas of national security. But it dealt with a total plan of dealing with intelligence gathering, both involving foreign countries and national security, as well as internal security. And let me read to you.
What is the document, Mr. Dash?
The document is the so-called Houston Plan. And we have it here with Mr. Murphy, who's been in custody of the plan, which we can show you. The part that has been put into the record has excised out the national security parts.
Before we go on, just to make sure that the witness who I understand has testified that he hadn't seen the document until the witness is familiar with it, why don't we supply him with either the original copy, which Mr. Murphy has here, or another copy?
Well, I can supply him with the copy that appeared in the New York Times, which has been compared by Mr. Murphy with the original, and it is accurate with the original. But we can also show him the one, or let's show him the one that Mr. Murphy has.
Well, to shorten this up, counsel, I'm not aware that I ever saw...
Just 1 minute. I think that Mr. Murphy can show you the original. I think it'd be better than the other.
Is the question whether I'm familiar with this document?
No. I asked you whether or not you're ever aware that the President and Mr. Haldeman had been informed prior to this break-in that such break-ins for national security were in fact clearly illegal and constituted the crime of burglary. Now, Mr. Murphy can show you at least that section I'm talking about.
See, this is what they left out. And what he's talking about is this. You know, you can be heard on glorious color.
Let me see it, Mr. Murphy. Counsel see it, please. Let me see it.
Yes, of course, counsel can see it.
I should assume so.
I just did this.
What are all these pasted pieces on here?
The pasted pieces, Mr. Wilson, were pasted on to cover up areas which the committee believed involved national security.
Well, I don't want a thing handed up here which has expurgated portions from it.
Underneath is the actual document.
Well, the committee excised those in the interests of national security.
But they deal with national security. And I'm going to read a statement in this report which refers both to national security involving foreign powers and internal security, which was the rationale of the persons who prepared this statement.
Are you going to leave out any part of that document, Mr. Dash?
No, I'm reading right from the document now.
Whereabouts?
The one that Mr. Murphy just showed me?
Yes.
Verbatim and complete?
No.
We are not that document. These documents related to both the methods to be employed in gathering international intelligence and domestic intelligence.
And this was a
the
finding.
Same thing we left out at the instance of the security agents of this country. And because of our own conviction that we did not want to expose methods of obtaining international intelligence, we excised that.
Mr. Wilson, the content, and I think in the interest of national security, the content of what the document says about national security is not relevant to the question I'm putting to Mr. Ehrlichman. But the fact that it dealt with national security and involving foreign powers is relevant. And I want to read the statement that was given to all the parties who were planning this and ultimately presented to the President of the United States. And I quote, "Use of this technique, meaning surreptitious entry and breaking in, either for national security or internal security purposes, is clearly illegal. It amounts to burglary."
Wait a minute. Mr. Chairman, I object to reading portions of this document. I ask for the time that it takes for me to read verbatim everything that Mr. Murphy holds in his hand before this examination continues.
This committee has some regard for preserving the inviolate any information that relates to the methods of gathering international security, international intelligence.
Mr. Chairman, Mr. Dash has just given his own...
Mr. Wilson, your motion is overruled by the committee, unless somebody objects.
And I have a new motion, and that is Mr. Dash is paraphrasing this document.
I'm not.
You just did.
I'm not paraphrasing. I am saying, and I think the committee found, by the very fact that it excised out portions, that this provision that I'm now reading dealt with both national security and internal security. But I'm not referring to the specific items of national security for the reason the committee excised it.
Well, Mr. Dash, I just looked at what you contend you paraphrased, and I must strongly disagree with your description.
Well, the chair would have to say the chair is quite familiar with these documents. And the chair is not going to divulge anything about the methods by which our various security agencies of foreign intelligence, and they were excised from the thing by the unanimous consent of the committee.
At the advice, by the way, of the various security agencies which reported to this committee that they dealt with national security.
I don't quarrel with their advice. I quarrel with your paraphrasing, Mr. Dash.
Mr. Chairman, could I say a word at this point? Would it be helpful? I understand the point Mr. Wilson makes to be that he wants to see the document that is the source material from which questions are asked. Would it be helpful to have a clean, expurgated copy of this document deleting those sections designated as national security interest supplied to you so that you can be interrogated on those portions?
What concerns me, Mr. Vice Chairman, is that according to Mr. Ehrlichman's last answer, the paraphrase which Mr. Dash gave just now does not fit the text.
Well, why don't we go back one step and not paraphrase, and I don't want to get in the argument about where you were or weren't, but why doesn't somebody pick up that document and read it and then ask the question?
Well, I may be able to shorten this up, Mr. Vice Chairman. Apparently what Mr. Dash is doing here is charging me with somebody's opinion in this document without having first laid the foundation that I've ever seen the document before or participated in the promulgation of the opinion. And
Mr. Ehrlichman, I asked you a question. Mr. Wilson, please. Mr. Wilson.
Excuse me, Mr. Chairman. As I understood it, when the gavel was used just then, Mr. Ehrlichman was in the middle of an answer. I don't think it's unfair to let the witness... Excuse me, Mr. Dash, may I finish? To let the witness answer the question, and then if it's inappropriate or unresponsive, to resolve the matter then.
Mr. Thompson, I don't want to get in debate with you, but so far we've not had answers. We've had speeches. And
well, that's your conclusion, Mr. Dash, and we're not here for your conclusion.
Well,
we're here to listen to the witness.
I want an answer, and I don't want counsel to interfere with the answer.
Wait a minute. I think the chap can straighten up all of this controversy. and then we can get along a little faster. The chair has read all of the documents referred to. The documents cover the fields of foreign intelligence and domestic intelligence. And without disclosing anything, they apply the same certain principles to both. We excised the references to foreign intelligence in the interests of national security at the request of various intelligence gathering bodies. And the documents relating to both things recommended that present restrictions should be modified to permit the use of this technique that is surreptitious entry. Use of this technique, the document states, is clearly illegal. It amounts to burglary. It is also highly risky and could result in great embarrassment if exposed. However, it is also the most fruitful tool and can produce a type of intelligence which cannot be obtained in any other fashion. Now, that's what the record shows.
Now, can I ask, the question, Mr. Ehrlichman, was not that I was charging you with the knowledge of this, nor charging you with the reasoning behind it. I merely asked you the question, were you aware that the President of the United States had been informed through this plan that this technique was illegal, clearly, and amounted to burglary? That was the simple question I asked, and again you jumped ahead and asked that I charged you with a particular thing.
I was
now,
not.
Were you aware?
No, sir.
Now, I take it also that when such plans are made, and these were made through an interagency group involving the CIA, the FBI, and other security groups that are ultimately presented for the action of the President of the United States, that such plans are carefully researched and evaluated. Would that be a fair assumption?
Mr. Chairman, that's not the way we're going to conserve time. I think what we're going through right now is evidence that this committee is in fact tired. But that's the question of whether it's evidence or not is something that we'll pass on. And I frankly am not interested in what this witness thinks about whether it is or is not evidence. I am interested in what he knows or doesn't know. I respectfully recommend that we move on to hard evidence.
Well, the witness has stated that he knew nothing about these documents, and the documents in evidence, and the committee can draw such conclusions from the documents. I don't believe that the witness ought to be compelled to testify about matters that he says he knew nothing about.
But you did testify, Mr. Ehrlichman, that in March of this year, you spoke to the President and discussed this particular entry, and he said that he knew that it was legal and justified for national security. Did he mention to you that he had received any kind of a contrary advice at any other time?
Well, now that question makes an assumption, not an evidence, Mr. Dash, that the President said he knew it was legal. I don't believe I've ever testified to that. Maybe some other witness has, but I don't know where you got that idea. I couldn't answer the question with that assumption in it.
I thought that was your testimony. I asked you the question earlier whether or not in March you talked to the President, and the President said that he believed it was legal and justified for national security. I thought you answered in the affirmative.
I certainly would not want to give you the impression that the President had given me a legal opinion on this at that time. What the President said was that he felt that it was important, that it was necessary, that in the context of the massive thefts and the turnover to the Russian embassy and all the context of that operation, that he certainly could not criticize the men who had undertaken this in good faith, believing that they were responding to the urgency of the circumstances.
All right, then just leaving the testimony that you do leave with the committee is that your own personal evaluation as to its legality was a recent one after advice of counsel.
Well, I certainly wouldn't want to leave that impression either, Mr. Dash, and I would simply stand on my actual answers.
Well, the record will show. Now, you testify that you met, in fact, your log shows that you met twice with Mr. Dean on June 19, 1972, which was 2 days after the break-in at the Watergate. Once at noon, alone, and again at 4 p.m. with Mr. Clausen, Mr. Colson, Mr. Curley. Now, at the noon meeting with Mr. Dean, can you give us your recollection as to what that meeting was about, whether you were discussing then the Watergate break-in?
Yes, I believe we were, and I believe that it was basically to determine between us the inquiries which I felt he ought to make in order to try and determine what had taken place.
Did he not at that time report to you that he had spoken to Mr. Liddy?
No, I don't believe so.
He made no report at that time to you as to any of the investigations he had made during the day of the 19th.
Well, I have the impression that Mr. Dean hadn't been at work very long at that time, and that he was just getting started.
All right. Now, at 4 p.m., what was the purpose of the meeting with Mr. Dean, Mr. Clausen, Mr. Colson, and Mr. Curley?
The principal purpose, as I recall, was to be in a position to answer inquiries, which I guess Mr. Clausen was getting, or the press people were getting, about Hunt's White House status, whether he was still an employee of the White House, if not, when he had terminated, and under what circumstances, and so forth.
And isn't that why Mr. Curley was brought up and to check the record? Would Mr. Curley have the record of that?
Mr. Curley was the staff secretary and would have to be involved in any discussion of that kind. There was another subject or two discussed at the time, but as I recall, that was the precipitating question.
Well, aside from Mr. Hunt's on the payroll, wasn't a focus at that meeting the question of Hunt himself, Hunt's status at the White House, and also the question that Mr. Hunt had a safe at the White House and that the safe ought to be open. Wasn't that part of the discussion?
Yes, it was, as I previously testified.
Yes. And actually, that safe was opened that evening, sometime that evening on the 19th.
I don't know. I think it must have been either that evening or the next morning.
Now, what was the concern, and who brought up the concern of what the contents of Mr. Hunt's safe would show?
I don't recall, Mr. Dash. Somebody at the meeting. I think the way it came up was not so much a personal concern as it was an inquiry by the investigation, either the Metropolitan Police or the FBI, as to whether Hunt had any belongings in the White House.
Now, on June 20, 1972, you met at 9 o'clock with Mr. Haldeman and Mr. Mitchell, joined by Mr. Dean at 9:45, joined by Attorney General Kleindienst at 9:55, and then at 10:30 you had a meeting with the President. Was that also a follow-up to find out what was going on in terms of the Watergate?
I think this was the process of trying to get everybody together who might know anything to try and get a picture of what the investigation was going to be, whether there might be other people involved, just to try and get the campaign director and the head of the Department of Justice and everybody together in one place to ask questions.
Now, by that time, Mr. Dean has testified that he interviewed Magruder, Liddy, and that he's also testified that he told you about Liddy's activity, about the fact that Liddy had stated that Magruder had pushed him into the break-in, and he's also testified that he briefed you on the earlier meetings in Mr. Mitchell's office on January 27 and February 4, 1972. Now, did Mr. Dean give you all of that information at that time?
No, he did not give me all of that information. He gave me some of it.
What part of it do you acknowledge that he gave you?
By the time he came in at 9:45 that morning, or at what time?
During that meeting.
Oh, during that meeting. I don't believe that Mr. Dean contributed very much affirmative information at that meeting. I think that meeting was more for the purpose of hearing from Mr. Mitchell and Mr. Kleindienst what the progress of the investigation was and what was known at the time. My impression is that Mr. Dean told me about his conversation, or part of his conversation with Mr. Liddy, at some other time.
You know when?
No, I don't, but the best recollection I have is that it was at some time more remote to his conversation with Liddy than this, if in fact it occurred when you say it did.
Now, the meeting at 10:30 that you had with the President, did you report to the President what you had learned from the parties who attended the earlier meetings?
I told Senator Baker, I believe, the other day that Watergate was not discussed at that meeting, and since then I have rechecked what sketchy notes I have, and I find I was in error on that. I'm sure there must have been some discussion of the Watergate with the President on that occasion on the 20th. There were three principal subjects covered at that meeting. One of them was government wiretapping, and it's obvious to me that there must have been some Watergate discussion that led into this discussion, in which I took an assignment from him to get some statistics for him about the incidence of federal wiretapping in domestic foreign situations, that is, situations involving U.S. citizens and foreign governments, which was a statistic he did not have and which he wanted. Now, I'm surmising and reconstructing, but because I have no direct notes on this, but I'm just certain that we did discuss Watergate at the outset of that meeting.
Well, now, on the 23rd, there's no indication that you met with the President between the 20th and the 23rd of June. Now, on the
yes, I met with the President in the company of others on the 21st at 12:38 and at 5:20 on the 22nd.
Did you meet alone on the 22nd?
No.
President? Oh, I know, and I mean by yourself.
I see.
And the reason I ask that is that on the 23rd, you did have your meeting with Mr. Haldeman and Mr. Helms and Mr. Walters. And since the President, in his May 22nd speech, specifically says he told both you and Mr. Haldeman that he was concerned about the CIA problems and asked you to see to it that the investigation didn't uncover these things, did on the 20th, when you met with the President give you such instructions or raise these questions with you?
No, those instructions came through Mr. Haldeman and were given to me, I think, the morning of the day of the meeting, which would have been the 23rd.
So actually the President's statement on May 22nd that he instructed Mr. Ehrlichman and Mr. Haldeman really should have been he instructed Mr. Haldeman.
Well, no, because he instructed me to attend the meeting, but he instructed me through Mr. Haldeman, and a great many of my requests from the President would come either from the staff secretary or from Mr. Haldeman or possibly someone else. It was not always face-to-face.
Now, all right, Mr. Hunt's safe was opened in the evening of June 19th, according to the testimony we received, and Mr. Dean met with you on June 21st. Mr. Dean has testified that prior to that meeting he had examined the contents of the safe, which were placed in his office. And at this time, did he inform you of the contents of the safe on the 21st?
Well, your question, of course, assumes that Mr. Dean knew the contents of the safe. I've heard him testify both ways. Maybe I'm wrong, but I thought his testimony was that he did not know the contents of the safe, but that Mr. Fielding had inspected the contents of the safe. I recall only one conversation with Mr. Dean about the contents of the safe in any sort of descriptive terms, and I'm sorry I can't tell you whether it was on that occasion or the following week, but what he described for me was simply that there had been papers, a gun, some electronic equipment of some kind, which I've heard described variously as a tape recorder and other kinds of electronic equipment, and that he reported to me that Fielding felt that some of the papers were very politically sensitive. Now, that was the full report, and when he gave that to me, whether it was the end of the week of the 19th or sometime the beginning of the week of the 26th, I'm not able to tell you.
Did he not, when he reported to you about the contents of the safe, indicate it also included a forged cable involving the President Kennedy and the so-called Diem assassination?
No, he did not.
Now, Mr. Dean has testified, and whether it was on this day when he reported to you on the contents or at a later day, that when he told you about the contents, with regard to the briefcase, which apparently had some electronic equipment in it, that you said or told him to deep six the contents. Now, did you tell him to deep six the contents when he gave you a description of the contents of the safe?
Well, I testified in response to Senator Gurney's question on that. In point of fact, Mr. Dash, what Mr. Dean testified to here, you're confusing one of his press leaks with his testimony, I think. He testified here that I told him to get rid of the briefcase, not the contents. You probably read in one of the news magazines the other version, but the fact is that I never gave him any suggestion or direction to do either one.
I think Mr. Dean did testify that to deep six the briefcase and certainly not take the contents out before he deep sixed it. But you say you never gave him that instruction.
No, sir.
And do you use that term, deep six?
Do I use it?
Yes.
Well, I've used it quite a bit since it was suggested to me.
Prior to that time.
Prior to that, I don't think that's a familiar part of my lexicon.
Well, apparently Mr. Dean didn't seem to understand either what you meant, and when asked, his testimony, that you mentioned the fact that he goes over the bridge and he could drop it into the water. Do you recall that testimony?
No, I recall some testimony. Do I recall the testimony?
Yes.
Yes, I recall hearing him say that here.
Now, do you recall having told him that?
No, I didn't tell him that. I do recall a conversation with Mr. Dean about the river, because just at this time, Mr. Dean's house was in the process of being flooded by the Potomac. And we had quite a bit of discussion about the fact that he was away from work several days, sandbagging his house and moving the furniture and so on. And we were discussing that in the context of his having held this material from the FBI for what he was concerned might be considered to be an inordinate period of time.
And so he may have got mixed up your question about his house and the river
No.
with the contents? Is
No.
that your suggestion?
No. I don't think Mr. Dean's at all mixed up. I think he knows exactly what he's trying to do.
What he's trying to testify to. Now, Mr. Fielding testified in the depositions in the Democratic National Committee suit on May 15, 1973. It was Mr. Dean's testimony before this committee that after he alleged...
Mr. Fielding testified that it was Mr. Dean's testimony?
No, I haven't finished my question, please.
Well, I'm already mixed up.
Fine.
Could we start over?
Yes, Mr. Dean testified after you had instructed him to deep six or drop the briefcase in the water, that he went to see Mr. Fielding and reported back to Mr. Fielding that that was the instruction and they were concerned about it, primarily because too many people had actually seen what had come out of the safe. Now, Mr. Fielding has given his deposition in the Democratic National Committee suit on May 15, 1973. And let me read you what Mr. Fielding states in that deposition. In question concerning the conversation he had with Mr. Dean, his answer was, I would say it was closer to the 20th than the 27th. I'm afraid I can't really pinpoint it much more than that. In the course of the conversations that we had, John indicated that there was a lot of concern about this material, and we had a discussion about it. I would have said, this is not a quote, that it would be unfortunate if some of this stuff leaked out or is revealed to the press. By the same token, it all has to be turned over. It is all evidence, even though obviously some of it is totally unrelated to the break-in. In the context of that kind of conversation, Mr. Dean indicated to me that Mr. Ehrlichman had suggested to him this was in the context of a conversation about the briefcase, that he deep-sixed the briefcase. Now, this is Mr. Fielding's deposition recalling what Mr. Dean told him. Now, I just raised that to you on the basis that Mr. Dean testified that he had gone back to tell Mr. Fielding that you had told him that, and Mr. Fielding has so deposed that he has.
Well, Mr. Dash, it's perfectly silly to suggest that I would go to the elaborate lengths that I did in making sure that the Secret Service and Curlie and the GSA and somebody from Dean's office was present at the opening of the safe, and that I would give instructions for taking custody of the contents, and then make a suggestion like that. I mean, I think you have to give me credit for understanding the importance of evidence in a case of this kind, and I did understand that, and on the 19th made darn sure that that evidence was preserved in a way that if there were a subsequent trial, the evidence could be identified and placed in evidence carefully.
It was Mr. Dean's testimony that he had to so instruct you that that was the problem, that so many people had seen it, that it would be inadvisable.
Well, why don't you ask Mr. Colson, Mr. Curlie, and Mr. Clausen, who were also at that meeting, who it was that established the process by which the integrity of that evidence would be preserved, and then perhaps you'll get some independent view on this.
Isn't it true that you did seek to ask Mr. Clausen and Mr. Colson, certainly, and a telephone call concerning whether or not you had made such a statement to Mr. Dean? And you have copies of the... I'm now referring to a transcript of a telephone call that you had with Mr. Clausen, which your attorney has provided under subpoena to us. There's no date on this transcript.
It's a date on mine.
I have no date on mine. What date do you have, Mr.
April 17.
April 17th does appear on the Colson transcript. Now,
for some reason, they excised the date from your copy.
Yes. Now, I can read it's short and I can read it, but I will refer primarily. You were asking Mr. Clausen to recall being at a meeting and where the question of Hunt's safe He alleged.
Mr. Fielding testified that it was Mr. Dean's testimony?
No, I haven't finished my question, please.
Well, I'm already mixed up.
Fine.
Could we start over?
Yes, Mr. Dean testified after you had instructed him to deep six or drop the briefcase in the water, that he went to see Mr. Fielding and reported back to Mr. Fielding that that was the instruction, and they were concerned about it, primarily because too many people had actually seen what had come out of the safe. Now, Mr. Fielding has given his deposition in the Democratic National Committee suit on May 15, 1973. And let me read you what Mr. Fielding states in that deposition. In question concerning the conversation he had with Mr. Dean, his answer was, I would say I was closer to the 20th than the 27th. I'm afraid I can't really pinpoint it much more than that. In the course of the conversations that we had, John indicated that there was a lot of concern about this material, and we had a discussion about it. I would have said, this is not a quote, that it would be unfortunate if some of this stuff leaked out or is revealed to the press. By the same token, it all has to be turned over. It is all evidence, even though obviously some of it is totally unrelated to the break-in. In the context of that kind of conversation, Mr. Dean indicated to me that Mr. Ehrlichman had suggested to him, this was in the context of a conversation about the briefcase, that he deep-sixed the briefcase. Now, this is Mr. Fielding's deposition recalling what Mr. Dean told him. Now, I just raised that to you on the basis that Mr. Dean testified that he had gone back to tell Mr. Fielding that you had told him that, and Mr. Fielding has so deposed that he has.
Well, Mr. Dash, it's perfectly silly to suggest that I would go to the elaborate lengths that I did in making sure that the Secret Service and Curlie and the GSA and somebody from Dean's office was present at the opening of the safe, and that I would give instructions for taking custody of the contents, and then make a suggestion like that. I think you have to give me credit for understanding the importance of evidence in a case of this kind, and I did understand that, and on the 19th made darn sure that that evidence was preserved in a way that if there were a subsequent trial, the evidence could be identified and placed in evidence carefully.
It was Mr. Dean's testimony that he had to so instruct you that that was the problem, that so many people had seen it, that it would be inadvisable.
Well, why don't you ask Mr. Colson, Mr. Curlie, and Mr. Clausen, who were also at that meeting, who it was that established the process by which the integrity of that evidence would be preserved, and then perhaps you'll get some independent view on it.
Isn't it true that you did seek to ask Mr. Clausen and Mr. Colson, certainly, on a telephone call concerning whether or not you had made such a statement to Mr. Dean? And you have copies of the, I'm now referring to a transcript of a telephone call that you had with Mr. Clausen, which your attorney has provided under subpoena to us. There's no date on this transcript.
It's a date on mine.
I have no date on mine. What date do you have, Mr.
April 17.
April 17th does appear on the Colson transcript. Now,
for some reason, they excised the date from your copy.
Yes. Now, I can read it's short, and I can read it, but I will refer primarily. You were asking Mr. Clausen to recall being at a meeting and where the question of Hunt's safe had been discussed, and which Mr. Curlie and Mr. Colson and Mr. Dean were present. Now, that meeting took place clearly on the 19th of June. And towards the bottom there, you say, well, it's interesting, because he says he had a vague memory, and he doesn't recall the details. And you say at the bottom, well, it's interesting because Dean, who, as you know, has talked to the United States attorneys at great length, cites some comments of mine in that meeting as evidence of corrupt attitude on my part, and I'm looking for anybody who can help me to recall what took place there. And Mr. Clausen says, that's a hell of a note, John. And you say, I agree. Mr. Clausen says, well, if you want me to be forthwith and straightforward with you, I'll recollect anything you want me to.
Yeah, that's what I testified to the other day.
Mr. Ehrlichman says, well, no, let me tell you what my problem is, and then you can. I've got to tell what I recall. What I don't recall, he alleges that I said two things at that meeting. One, that we ought to deep six the contents of the safe, quote, unquote, and two, that we ought to get Hunt to leave the country. Now,
go on.
All right, I'll read. I could listen, John, if anything like that, if either one of those two things were said, that would be vivid in my mind. And Mr. Ehrlichman,
I think the word is recollection. Vivid in my what?
Vivid in my mind is what I have here.
That's funny. Mine says recollection.
Oh, I wonder why we have a different trade. This we got, all we got from your attorney. We did not retype this. Let me read on and see if we have any other differences. Mr. Ehrlichman, I would think so. I would think so. Mr. Clausen, and that's objectively. Mr. Ehrlichman, now in point of fact, Dean phoned Liddy and asked Liddy to have Hunt leave the country. Clausen, that's new news to me. Ehrlichman, yeah, but you see this, and what he's doing is saying, well, I was just being a good German and carrying out orders. Mr. Clausen, no, I would have absolutely no trouble in remembering either one of those two things if they had been said. Mr. Ehrlichman, well, okay. Mr. Clausen, I would just remember that. Mr. Ehrlichman, yeah, that's a fairly dramatic event. Okay, thank you very much. Awfully sorry to have bothered you. I just don't understand. Mr. Clausen, if there's anything I can do in this thing, please let me. And Mr. Ehrlichman, I will, thank you, can. All right. Now, why, if the only meeting that Mr. Clausen attended with you during that period of time was on June 19th, during the day, prior to the time the safe was open, why would you be asking Mr. Clausen if he could recollect whether you had said anything about Mr. Dean about deep sixing, anything about the safe? Because obviously, on the meeting of the 19th, when the safe had not yet been opened, such a conversation could not have occurred yet.
Well, this was the version which was reported to the President as having taken place at this meeting on the 15th or 16th by Mr. Peterson, who in turn was reporting what Dean was alleging to the U.S. attorneys. So the President confronted me with this. And I said, when is this supposed to have happened? And he said, well, what they tell me is that it happened at this meeting where you all discussed Hunt and his safe and all this business. So that's why I focused on that meeting as the time that Dean alleged this was supposed to have happened. That's the best information I had at the time.
But it's quite obvious that since the safe had not been opened yet, taking what you say to be true, Dean certainly wouldn't be claiming that you were telling him to deep six something on that day.
Mr. Dean has had so many versions of these stories that I don't think you can assume that any one of these would be more reasonable than any other. I appreciate your situation vis-a-vis Mr. Dean and the committee, but I think you have to recognize that there are many, many versions of this story that have been floated to you and the prosecutor, and all in the interest of immunity.
Mr. Dean has testified that whatever discussion took place about deep six took place after the safe was open, and therefore...
Well, I submit...
He's testified here on the road.
Oh, well,
all right.
Here.
Now. And therefore, what I suggest to you is that Mr. Clausen wouldn't be a person who might have recalled it, even though you may have thought that was the date that was relevant at the time.
If you accept that version at this time. Now, the thing that I said to you, Mr. Dash, was you get Mr. Clausen and ask him who it was that hedged the contents of this safe about with several witnesses and with a procedure to guarantee the integrity of the evidence in that safe. And I think he'll tell you that I was the one who insisted upon that procedure at the meeting on the 19th.
All right. Now, you again called Mr. Colson on April 17th, in which you made a similar inquiry.
Yes, sir.
Concerning that. Now, your conversation with Mr. Colson is you say that two quick questions after the preliminary introductions where you say hello. The transcript of April 17th conversation between Mr. Colson and Mr. Ehrlichman.
Does the witness have a copy of this?
Yes.
I have a copy. I find that the transcript of the other conversation I had did not jive with Mr. Dash.
Were there any other, when I was reading, were there any other...
I don't know, Mr. Dash. I was more interested in your assertions than
I was just reading
anything
at the time.
else.
I wasn't asserting, I was reading.
Assertions, not insertions.
No, I said I was reading, not asserting. Now, you say 2 quick questions. So I think it's the first time you get into subject matter. One thing I should tell you, and it is a great find last night, really started accelerating. Our great find last night really started accelerating. Something coming out this morning, Dean involved. Now I noticed something coming, now I noticed the LA Times has it this morning, but the people that Shapiro has been getting information from, you know, the town is buzzing with, is alive with the story, so I don't think we have a hell of a lot of time. By the way, could you tell us what that great find was last night that was coming out in the LA Times? Or?
No, sir.
Right.
I sure can.
All right. Mr. Colson says, I just thought I'd let you know that. Mr. Ehrlichman, I appreciate it. Mr. Colson, did he, when he went over there, was he given any immunity? Mr. Ehrlichman, not yet. What they've done, apparently, Mr. Colson, they shouldn't give it to him. Mr. Ehrlichman, I know it. What they said to him is that unless he turns up corroborated evidence against Haldeman and me, Mr. Colson, is that who he's trying to make? Mr. Ehrlichman, sure. Colson, who Dean is? Mr. Ehrlichman, yep. Mr. Colson, that's John Mitchell again. And I guess I'll read this. Son of a bitch. Mr. Ehrlichman, unless he does that, he doesn't get immunity. Now, my grapevine tells me that you are going to be summoned over there today. Who is your grapevine, by the way, Mr. Ehrlichman?
At that point in time, I don't know. I don't know who that would have been.
Would it have been Mr. Peterson?
No, Mr. Peterson wasn't my source for anything at that time.
All right, Mr. Colson says, oh, really? And you say, yep, and that they're going to ask you about a meeting in my office, which Dean has highlighted as a central gemstone. It's an interesting term used then. Was it any purpose for using it? In the case against me. And so just in case you get hauled over there before 11 o'clock, maybe I'd better tell you about it. It was a meeting that Curlie, Clausen, you, Dean, I had here. Mr. Colson, I wasn't there. Mr. Ehrlichman, in my office. Mr. Colson, I was not there. Dean tried this one out on me Friday night, and I said the only thing I can ever recall, John, is I once told you I thought it was a stupid goddamn thing for Hunt to be unavailable. Mr. Ehrlichman, well, that's the meeting where supposedly I ordered him to tell Hunt to leave the country. Colson, never heard that, and I will so state under oath. Mr. Ehrlichman, or that I admonished everyone that we ought to figure out some way to deep six the contents of Hunt's safe. Mr. Colson, no way. I was the one who said to get Hunt safe and to be sure it's preserved for the FBI. Mr. Ehrlichman, right. Mr. Colson, A, and I take it A is earlier answer, and B, it's stupid to get another country. But that was in my office, not yours, and you weren't present. Mr. Colson, I can handle that one easily. Mr. Ehrlichman, but you were not in a meeting here. Mr. Colson, well, I may have been, but I sure don't remember that. Mr. Ehrlichman, that's the way, okay. Mr. Colson, all right, I can handle that. Mr. Ehrlichman, thank you, I'll see you at 11. Mr. Colson, there's a couple of things you and I need to do to protect each other's flank here, but we'll talk about that. But no, I'm serious. Mr. Ehrlichman, fair enough. Mr. Colson, let's get it clearly understood that that son of a bitch doesn't get immunity. I want to nail him. Mr. Ehrlichman, well, I'm doing my best. Mr. Colson, no, I want to nail him. I'll take immunity first. Mr. Ehrlichman.
Mr. Maddox. Mr. Dash, if you'll suspend for just a moment. The chairman admonished me before he left to take care of other business. To tell the audience and all those present that he is entirely serious about maintaining decorum in this hearing room. It is inappropriate for the audience to respond in any way to the statements made by the witness, by counsel, or to anything else. On the express and explicit instructions of the chairman, I caution the audience that the committee will not permit demonstrations.
Well, I think that's just about, I think you say okay, he says all right, and there's a thanks at the end. Now, Mr. Colson, in that discussion, indicated to you that he didn't recall being at least at the meeting with Mr. Clausen, Mr. Curley, you and Mr. Dean. But it is true he recalls that a discussion concerning getting Hunt out of the country was in his office and you weren't there. But again, Mr. Colson claiming not being present at the meeting or on the 19th, could Mr. Colson in any way verify for you that you had not said to Mr. Dean to deep six the contents?
Well, I'm satisfied that Mr. Colson was present. I have an office log system that logs people in and out of my door on an actuality basis, so to speak. Only the people who actually go in and out are logged, and they're logged at the time that they do go in and out. So it would be, there's always room for some error, but I think it a practical certainty that he was there in fact. And I was much more interested in whether or not he had any recollection of such a conversation. I think there are two important things in that conversation, Mr. Dash, that you kind of skipped over. One was the fact that Mr. Dean tried this story out on Mr. Colson, which goes to my answer to Senator Gurney the other day, that at a point in time, right around this second and third week in April, Mr. Dean was very busily engaged in planting stories here and there as he attempted to plant this story with me that I supposedly ordered him to have Hunt leave the country. Second thing is, on the matter of immunity, I had been consistently taking the position since the 22nd of March that no one in the White House should seek immunity in any forum whatsoever, that it was extremely inimical to the interests of the President and the White House for someone in the White House staff to in any way seek to be excused for his actions under any circumstances. And my efforts, and I should have said this in response to Senator Gurney's question of a few minutes ago with respect to what we were talking about during the days April 15 to 30. One of the things that we were talking about was the public policy that might be involved in anyone in the White House seeking to be immunized from the consequences of his act as an inducement to testify. And I felt strongly then, and I was continuing to feel strongly at this time, that was a wholly improper procedure.
I just had this following up on that, just one or two quick questions on the immunity. Is it true, Mr. Ehrlichman, that you called Mr. Kleindienst sometime before April 14th and expressed the same view that nobody should be offered immunity?
Prior to April 14th?
Prior to April 14th, yes.
Well, I recall
about a week
calling Mr. Kleindienst on about the 28th of March and inquiring of him about the procedures involved in securing immunity, and then at some point in time I conveyed to him the President's decision that no one in the White House should be extended immunity.
But the question is whether you personally
I conveyed that
not the President's position, but you personally suggested to Mr. Kleindienst that
as a personal point of view?
Yes.
Well, it's not out of the question because I was strongly stating that point of view consistently through this period of time.
And did you participate in the preparation of the President's statement of April 17th, in which he stated that nobody at the White House will be offered immunity in the criminal investigation?
Yes, I did.
At this point, Mr. Chairman, as I see the time, I have a number of other questions, and perhaps this would be the time to recess.
I suggest we run 10 minutes more and recess at 12:30.
Now, Mr. Mitchell has testified that on June 21st, he was debriefed by Mr. Marty and LaRue on their talk with Mr. Liddy. And this is the first time that he heard about Liddy's operations, which we referred to and mentioned earlier to you, that he called the White House horrors. And they included the Ellsberg break-in, the DM cable, the spiriting out Dita Beard from the town, certain wiretapping activities. He listed a number which he called White House horrors and identified them as so-called Liddy operations. And this is the first time that he learned about them, he said, on the 21st. I know you've testified that maybe Mr. Mitchell's memory isn't correct, but are we really agreeing on the same thing? I think your testimony, when you refer to your diary and had certain meetings with various persons concerning the operation of the Special Investigative Unit. At that time, did you, when you had those meetings, discuss with them, and especially Mr. Mitchell, the break-in of the Ellsberg psychiatrist's office?
That's a very complicated...
Let me put it much more clearly. You have testified that Mr. Mitchell's statement on to us that the first time he heard of the White House horrors and the plumbers' activities involving Mr. Liddy, that he said the first time he heard about was on the 21st, was an error, because you had reported sometime earlier to Mr. Mitchell on this Special Investigative Unit. Is that not correct?
Well, you see, we get into problems now. Just, for instance, in that question, the first time I discussed the so-called plumber's activities and Mr. Liddy with Mr. Mitchell would be quite different than the first time I heard of or discussed these other things.
Right, that was the question I was trying to clarify.
Well, I'm not sure that...
Because the question...
You see, what I testified to in answer to a question was that the existence of the special unit and its function, its purpose, as the President conceived it, and the charter which he gave to Mr. Krogh on the 24th of July was discussed with several agency heads and cabinet officers almost immediately thereafter. Now, I don't think I was asked the question whether or not I ever discussed the Ellsberg break-in as such with Mr. Mitchell. I don't recall ever doing so.
Well, the question that came up was Mr. Mitchell's testimony, not that he learned of the plumbers on the 21st when Mr. Marty and debriefed Mr. Liddy, but learned of Liddy's operations involving the break-in, the DM cable, and the other things. And he said he first learned of that, what he called White House horrors, on June 21st. Now, on the next day, on June 22nd, you met with Mr. McGregor, Mr. Colson, and Mr. Mitchell at 9, and then you had a second meeting with Mr. Mitchell alone at 11:45. I know you've been asked about that meeting at 11:45 because apparently there was a phone call in between. And the question I put to you is whether or not Mr. Mitchell, at that meeting, told you about what he learned from Mr. Mardian, because he has so testified that he did report to you what he heard, and he reported about the so-called White House horrors and talked to you about the need to keep the lid on to protect the election.
As I've told Senator Gurney, I can't recall specifically the reason that Mr. Mitchell called or I called him and we got together at 11:45 on the 22nd. I can say this, though, with great assurance. I never knew until the other day, when it was testified to here, that Gordon Liddy had had some part in the Dita Beard business. I had just never heard that from anyone. Nor had I heard about this cable until it was either discussed in the press as a leak from your staff or else in the testimony here, one or the other. But contemporaneous with all of this, I was not aware of either of those events at all.
Mr. Mitchell never informed you of that?
No, sir.
By the way, if, in fact, Dita Beard had been spirited out through the help of Mr. Liddy or Mr. Hunt, and if, in fact, Mr. Liddy had something to do with the DM cable forgery, and they were not plumber's work, who else had access to Mr. Hunt and Liddy's time and services while they worked for Mr. Krogh under you?
Well, of course, they ceased to work for Mr. Krogh under me on the special unit around the 20th of September. And I don't know the dates of those events, but my hunch is that they were later than that. And I would just be speculating then. I don't have any idea.
Mr. Hunt still was working at the White House at that time, during these periods of time.
Well, no, I can't tell you that of my own knowledge.
Well, do you recall when you were attempting on the 19th to fix a time when Hunt had left, that what time you did fix?
No. As a matter of fact, on the 19th, I don't think we did fix. I think there was still a lot of confusion, and I think Mr. Curley was going to go back and check some records.
Now, despite your claim, Mr. Ehrlichman, that you had so many things to do that Watergate was really not central in your focus. You do seem to have been busy on Watergate matters, since on the very next day, June 23rd, you and Mr. Haldeman met with Mr. Helms and General Walters, and we've had, and I'm not going over that testimony because I think that's been fairly clearly covered, but you did meet with Mr. Haldeman and with Mr. Helms and Mr. Walters, and the topic of the conversation there was the question of whether CIA involvement was involved. Was that not so?
Well, Mr. Dash, I'd like to go back to the preamble to your question, because any answer that I might give might seem to adopt its assumptions. There isn't any dispute in the evidence that in the 12 days before I left Washington and went to California, that I had a number of meetings with regard to Watergate, both with Mr. Dean and on this occasion with Helms and Walters. I have never put a contention to the contrary. But if you'll look at my log and you'll look at the other records, you will see that once the 26th of June came and I left town, or whatever that date was, let's see, 29th of June came and I left town, that my frequency of contact with this subject dropped off practically to zero. So I wouldn't want the little lead-in to your question to give anybody the false impression that you apparently have entertained.
Well, the impression, at least I want to leave, that you're leaving also is that right after the break-in, you were heavily involved.
Oh, I've testified to that 2 or 3 times, and the reason that I was, I think you know. Now, once we get to this Helms-Walters meeting, again, I think you know, that meeting was convened by the President because of a very strong concern he had about the jeopardy of the CIA's integrity, secrecy of its operations. And he wanted to be absolutely sure that this all-out FBI investigation could go forward without jeopardizing that secrecy.
But you have characterized, at least so testified concerning that meeting meeting is which you were making an inquiry as to whether or not there was CIA involvement, and that actually Mr. Helms and Mr. Walters were going to make a check on that. As a matter of fact, Mr. Walters has testified, and Mr. Helms, that they had already, in fact, Mr. Helms had a meeting the day before with the acting FBI director, Mr. Gray, in which he told him there was no CIA involvement.
Well, I hope you get a chance to ask him about that CIA letter of July 6th and why it was that it was not then for another 6 days until the CIA gave firm assurance to the FBI that there was no CIA exposure.
Well, do you know that, as a matter of fact, the reason for that is that after Mr.
Are you going to testify now,
no,
Mr. Dash?
No. Their testimony will come forward. And that as a matter of fact, based on your, and Mr. Walters has to testify, that based on your direction, or Mr. Haldeman's direction, he did in fact go and tell Mr. Gray something different than what Mr. Helms had told him the day before.
Well, you're confusing.
Mr. Chairman, just one
minute,
Mr. Ehrlichman, if you will. We're going to continue these hearings past August 3rd, it would appear, and that's going to be over my firm objection and maybe even beyond the scope of my energy and resources. But we're not surely going to serve the purpose of trying to expedite this thing if we not only do not inquire of the witness about what he's testified to or what other witnesses have, but what future witnesses may testify to. Now, I haven't heard Walters or Helms testify. And if it's necessary to call this witness back and to ask him questions about the Helms and Walters testimony, I think we ought to do it. But just in the pure interest of time, Mr. Chairman, I'd like to suggest that our inquiry, all of us, including me, that we limit our inquiry to what this witness has said or what other witnesses on this record have said on the same subject matter.
Mr. Chairman, I agree with that, of course. But it was this witness who was constantly referred in his testimony to Mr. Walters' July 6th statement. And it was in response to that the question was put.
Well, I'll just suggest that counsel rephrase his question and ask the witness to testify what he said and what Mr. Walters said.
I think that's
That'd
fine.
be perfectly
I think that's
proper.
Very good.
Mr. Chairman, just the time Senator Baker spoke, I was in the process of pointing out to counsel that you have 2 different subjects here. One is direct CIA involvement in the break-in, and the other is possible unrelated CIA activities which might be disclosed by a vigorous FBI investigation. Now, I think you have to be very careful in defining what it was that Director Helms and Mr. Gray discussed the previous day, and what it was we discussed at this meeting, and how the thing was narrowed down at this meeting, and what it was that General Walters was going to go talk to Mr. Gray some more about.
I think in the...
Maybe this be an appropriate time to recess for lunch.
Mr. Chairman, may I inquire about the scheduling? Mr. Haldeman is also our client, and I'd like you to suggest whether he should be here at 2 o'clock. He has a statement which will take him, hopefully, not over 2 hours to read, and I would like to have him do it on the same day, the whole thing.
Well, I would suggest that he come in at 3 o'clock. I hope that we can finish with Mr. Ehrlichman by that time. I don't know whether we can or not, but I hope.
Today's break for food gave the senators and council a chance to cool their tempers a bit. Public television coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As the hearings resume, Sam Dash has more questions about John Ehrlichman's contacts with CIA officials.
Committee will come to order. Council resume the interrogation of the witness. I forgot to turn on the loudspeaker.
Mr. Ehrlichman, following the meetings that you had, or the meeting that you had on June 23rd with Mr. Walters and Mr. Helms and Mr. Haldeman, did you instruct Mr. Dean to contact Mr. Walters and follow up on the June 23rd meeting?
No, sir. I simply notified Mr. Dean that there had been a meeting, that General Walters was going to be talking with Mr. Gray, and that we had indicated to General Walters that Mr. Dean would be his contact from that point forward.
And did there come a time when General Walters did call you and ask you and tell you that he was going to have a meeting, or that Dean had contacted him, and was it all right for him to speak to Mr. Dean?
It either happened that way, or I told him at the time of the meeting on the 23rd that Dean would be his contact, one or the other. But I am quite sure that I indicated to General Walters that Dean was the White House man who was looking after this whole subject.
And were you aware that Mr. Dean, in fact, did meet with General Walters on June 26th?
No, I was not aware of those meetings, which
a series of meetings.
Yes, I understand there were, and I was not aware of that series of meetings until just recently.
And Mr. Dean did not report to you on them?
No, he didn't.
Now, on June 28, 1972, you met with Mr. Dean and Mr. Gray, and we've had some testimony on that, and that on that same day you had two earlier meetings with Mr. Dean. Do you recall what the two earlier meetings were before the meeting with Mr. Dean and Mr. Gray were about?
Not specifically. I surmise that one of them was simply an informational meeting, knowing that I was about to leave town for an extended period of time. As I recall, there was a conversation, and whether it was by meeting or whether it was by telephone, I can't recall. But on the same day that we met with Pat Gray, I'm quite sure we had a conversation about turning over the contents of Hunt's safe to Mr. Gray.
All right. Then you had your meeting with Mr. Gray, and I think you've already testified to the circumstances under which a particular packet or envelope was turned over to Mr. Gray.
Right.
And we don't need it. I think we've had full testimony on that. Now, by the way, did you know at the time that that packet of materials were turned over to Mr. Gray what was contained in the packet?
No.
Had you been told by Mr. Dean that they were sensitive materials, politically sensitive materials?
Yes.
Now, I think you testified in a response to a question from Mr. Gurney on page 5438 of the testimony. Did you have, Senator Gurney asked you, did you ever have any communication with Mr. Gray about these documents after that meeting? I'm referring to the June 28th meeting. And you answered yes, sir. And Senator Gurney said, and recounted the committee. And your answer was, that was in April of this year. We had a conversation. The President asked me to telephone Mr. Gray. It was a Sunday night, and it was the 15th of April, about 10:15 p.m. I was in the President's EOB office, and he had a meeting that day with Mr. Kleindienst. The subject of these documents came up at that meeting, and then you were asked to call Mr. Gray, and I just want to, you referred to that telephone call. You said, I told him at that time that the delivery of the documents to him, to Mr. Gray, had been the subject of this conversation between the Attorney General and the President, and that Mr. Dean apparently had told the prosecuting attorney about the fact that he had made the delivery. Mr. Gray said, quote, well, he can't do that, unquote. And I said, quote, well, he did say that, unquote. And he said, quote, if he says that, I will deny it, unquote. And I said, quote, well, Pat, it isn't a subject for denial. Obviously, it's not something you can deny. I recall the episode very clearly, unquote. And well, he says, quote, you have got to back me up on this. And then he went on to say, I destroyed the documents. And I think at that point you said you were nonplussed about it, and you hung up, and then you decided after talking to the president that perhaps you had made it clear that you were not going to back him up, and you called him back, and without rereading the testimony, you made it very clear to him that if you had to call to testify, you would tell the truth about that. Now, isn't it true, Mr. Ehrlichman, that that was not the next time or that you had a conversation with Mr. Gray about those documents? That the April 15th meeting, didn't Mr. Gray get in touch?
Next time?
Yeah, the question put by Senator Gurney was that after the June 28th meeting, did you again or have an occasion to talk about those documents to Mr. Gray? And your answer,
I see.
Your answer was the April 15th phone call.
You're referring to the rather oblique reference in Mr. Gray's phone report to me about his confirmation hearings, perhaps, and that's correct.
Yeah, on March 7th and 8th.
We discussed it in a much less specific way in terms of what he was testifying to in the confirmation hearings about whether he had delivered all of the, or whether Dean had delivered all of the documents to the FBI in a package or in parcels.
Well, Mr. Ehrlichman, actually, although it was, as you put it, perhaps in a more oblique way, but the conversation really was pretty much the same, only this time Mr. Gray, in his telephone call, and I'm referring to the transcript of the telephone call that you had with Pat Gray on March 7th or 8th, 1973.
That's the one that I testified at length
Yes.
with Senator Weicker
Yes.
about.
And what I'm referring to is that at this time, wasn't the conversation somewhat different? And let me just read. Mr. Gray, towards the bottom of the first page of that transcript, says, another thing I want to talk to you about is that I'm being pushed awfully hard in certain areas, and I'm not given an inch. And you know those areas that I think you've got to tell John Wesley to stand awful tight in the saddle and be very careful about what he says, and to be absolutely certain that he knows in his own mind that he delivered everything he had to the FBI. And don't make any distinction between, but that he delivered everything he had to the FBI. And you say, right. And then he says, and that he delivered it to those agents. This is absolutely imperative. And you say, all right. And he says, you know I've got a couple of areas up there, and I'm hitting hard, and I'm just taking them on the attack. You say, okay, I wanted you to know that. And you say, good, keep up the good work, my boy. Let me know if I can help. And he says, all right, he can help by doing that, meaning I'm taking John Dean. And you say, good, I'll do it. And at that time, by the way, in your telephone call with Mr. Gray, when he suggests that to you, and this is before Mr. Dean has gone to the U.S. Attorney's Office and made any statement that such a delivery was made to Mr. Gray, you do not, do you, tell Mr. Gray, as you did when you were calling from the President's office, well, that didn't just happen that way, Mr. Gray. I was there, and I saw that it was delivered to you. It wasn't all turned over to the FBI. Why didn't you tell him then, instead of saying, okay, all right, why don't you then catch him up there and say, well, the truth is, Pat, you did get them?
Well, the conversation with Gray, as I read it, that you just quoted, was Gray saying to me, I'm saying that the FBI got all these documents, which is true, but I'm not making any nice distinction about the fact that it came in two parcels. Now, I suppose that from a hindsight standpoint, there was a hint there that he had some other problem with these documents, but I didn't pick up that hint. I didn't understand what he was concerned about. And so I took it that what that was all about was simply Mr. Gray saying to me that that is the manner in which he was testifying, and that he certainly wouldn't want Dean to volunteer anything that in any way would disrupt that testimony. It would keep integral or protected the fact that, in fact, they had come to the FBI in two parcels instead of in one parcel.
Well, as a matter of fact, Mr. Ehrlichman, didn't you really pick it up and identify it? Because you called Mr. Dean shortly afterwards, immediately following, according to the transcript. And the conversation is as follows with Mr. Dean. Mr. Ehrlichman, Mr. Dean. Mr. Dean, hello. Mr. Ehrlichman, hi. Just had a call from your favorite witness. Mr. Dean, which is? Mr. Ehrlichman. Patrick J. Gray. Mr. Dean, oh really? Mr. Ehrlichman. And he says to make sure that old John W. Dean stays very, very firm and steady on his story, and he delivered every document to the FBI, and he doesn't start making nice distinctions between agents and directors. Mr. Dean then says he's a little worried, isn't he? And you say, well, he just doesn't want there to be any question. He says he's hanging very firm and tough, and there's a lot of problem around. Now,
probing around.
Probing around, excuse me.
Yeah.
Now,
Well, that's exactly
so
what I
you
said.
do is you actually carried out Mr. Gray's request. Far from telling Mr. Gray, when he called you, that as a matter of fact, there were 2 deliveries. He did really receive something personally, as he was trying to tell you later in his discussion when you were calling him from the President's office. You did call Mr. Dean. You did call Mr. Dean. And you did you did carry that message to Mr. Dean, and you did tell Mr. Dean that Mr. Gray wants Mr. Dean to be sure to stand tight and make no distinction between FBI agents and directors that all went to the FBI. And therefore, weren't you in fact participating in the covering up of that situation in which a packet was given to Pat Gray, which later was destroyed? Now, you didn't know it at that time.
Didn't know it.
Well, you didn't know it at that time.
As far as I was concerned, there was a perfectly proper way of going about delivering these documents to the FBI. Having the concern that we did, that either the field office or the lower echelons of the FBI were leaking this stuff all over, that to put it in the hands of the director was a perfectly appropriate device.
But why did you think...
There was no cover-up in that, and I don't apologize for it for a minute.
But why...
The cover-up that I was invited to participate in the call from the President's office was of quite another nature. And this was Pat Gray suggesting to me I never got them, and I'll deny I ever got them, and that kind of thing, which I just couldn't.
Well, isn't he saying the same thing in the earlier call?
No,
He's saying let's not make a distinction, and let's make it clear that it went to the FBI so that nobody would ever think I ever got them.
Now, I don't think you can read that into it.
Well, why did you ask him? Did you ask them, or did it occur to you then, if you didn't see anything there, well, what's the problem, Pat?
Oh, I wish I had. Believe me.
What's the problem? Why would Mr. Gray
ask
you to tell John Wesley to stand tall and make no distinction? What would it came into your mind that it would be concerning him?
Well, if he had testified, it came in 2 parcels, and I have the one parcel, and it has nothing to do with Watergate, but I'm holding this one parcel. That they would zero in on that as they had zeroed in on other aspects of this thing and attempt to open it up and get at the politically embarrassing documents and exploit that.
To that extent, then, you were assisting him in preventing that from happening.
Well, I hope so. That was the whole idea of delivering it in 2 parcels. As far
And
as
therefore, you were carrying out that, and again, well, you may disagree with my term, but carrying out at least a cover-up of this delivering to Mr. Gray the separate, sensitive political documents so it wouldn't be exploited.
Well, there was no intent here to, in any way, do away with those documents or keep them from persons who had a proper right to them. The thing that disturbed me in the April conversation, of course, was his invitation to me to side in with him in the story that he never got the documents in the first place, against the background of his having destroyed them. And after hanging up the phone, I thought, well, I've got to just make this as clear as possible to him that I'm not in this. And
but at that point, Mr. Dean had already gone to the prosecutors and let it out of the bag. It was clear now that Mr. Gray had got the package.
It did not come to the President from the U.S. Attorney that the documents had been destroyed. So far as I know, that was discovered in this phone conversation with Mr. Gray for the first time. Now, I heard testimony here to the effect that I knew back in January or sometime that these documents had been destroyed, and that is totally incorrect. In point of fact, had I known anything about the destruction of the documents back at that time, I dare say that my recommendation to the President with regard to Mr. Gray's nomination would have been very strongly negative.
Well, my question, to make it very clear, does not go to your knowledge of the destruction of the documents at that time, but it goes to the question of your knowledge that he did receive the packet and that you did, in fact, carry out Mr. Gray's request to tell Mr. Dean to stand tight in such a way that he shouldn't make the distinction between FBI agents and directors. And,
just as it
right,
says there.
Just as it says there, and as you've indicated, to keep from any politically embarrassing matters from being exploited.
Leaked.
Or leaked. Now, on July 26th, you did, you have your diary shows that you met with Mr. Kalmbach. And by that time, you had already okayed, I take it, Mr. Dean's use of Mr. Kalmbach for raising funds for legal defense of the Watergate defendants. Now, how did that come about? Did Mr. Dean come to you and say that he wanted to be able to contact Mr. Kalmbach for this purpose?
Well, I wouldn't want to answer this question in any way that might seem to adopt the lengthy preamble that you've just delivered. I have testified a couple of times about the conversation that I actually had with Mr. Dean in this connection. And very simply, as I recall, it was a phone call, or it may have been at one of these information meetings. He said, "I wish you'd back me up. John Mitchell feels very strongly that he's got to try and recruit Herb to do this defense fundraising, and I'm going to ask him to do that." It was just about that much.
And on that alone, you allowed Mr. Kalmbach, at least Mr. Dean, to go to Mr. Kalmbach and ask him to do it.
I didn't allow anybody to do anything. I mean, it wasn't up to me to grant permission to anybody to do anything under those circumstances.
Well, I think you have told us when we had our interview, and I think Mr. Kalmbach has testified that, and I think you used the term during our interview, that you had a sort of a lock on Mr. Kalmbach, and I think your testimony is that in order to protect Mr. Kalmbach from being imposed upon, that you would say that after he had done his original work that they couldn't come to him and ask him to do other fundraising without getting any approval through you or Mr. Haldeman. Isn't that right?
Well, I couldn't possibly agree to that very long question, Mr. Dash. There are so many things wrong with it. What actually happened, as I, again, testified a couple of times to, is that when the April 7th campaign financing law was coming into effect, Mr. Kalmbach let us know, or let me know, that he didn't want to do any more fundraising in the campaign. Maury Stans was pressing him hard to help him. It was a very tough job. Herb wanted to be relieved of that, and he wanted to do some other kinds of chores in the campaign that he would find more interesting. And so we agreed that if either Mr. Mitchell or by then I think it was, well, let's see, I guess it was Mr. Mitchell still then, and Mr. Stans approached Herb, that Herb could use me and Bob Haldeman as an excuse that he was working for us, and that we would back him on that.
Now, what's that? That's what I thought I'd asked you. Maybe my question wasn't that clear. I thought I said that you had made an arrangement with Herb to protect him.
Well, you have a way of festooning your questions, Mr. Dash, with facts that apparently are only in your knowledge.
Well, we won't go back and forth on this. I think we'll go to and follow up on the questioning. Now, did you know at all how much money would be involved?
No.
You didn't inquire?
No.
Did you know how the money was going to be raised?
No.
And did you inquire?
No.
Now, you knew...
You're speaking now as of the time of my conversation with Mr. Dean.
With Mr. Dean, yes, with Mr. Dean. You knew, of course, that by this time that Mr. Hunt and Mr. Liddy were defendants, or among the defendants who would be assisted by this.
I assume so. I'm not certain of that, but I assume so.
I think the newspapers and the public record at least would have brought that to you.
I can't relate the two.
Now, again, didn't you have a special purpose to assist in the paying of their legal defense funds?
I didn't have any purpose, general or special.
Well, here was your same Mr. Hunt and Liddy, who had been involved in the Plumbers activity and the Ellsberg break-in, now being involved here. Were you concerned that unless they were paid their legal defense fees, that they might well cause some trouble?
Now, as I recall, the context in which this was discussed was primarily a Cuban emigre stimulated defense fund, which John Dean told me about, that was being created in Florida and would be the vehicle for this. And so, if anything, my focus would have been on those participants in this, in that particular conversation.
Well, then why did they need Mr. Kalmbach?
To bring money in, I assume. And this
Because
was, again, I didn't question this at all. It was something that was just brushed over in passing.
In other words, and you didn't think at this time that this money would go to pay Mr. Hunt's lawyers or Mr. Liddy's lawyer?
It just was not a question that I addressed myself to one way or the other, either affirmatively or negatively.
And this is the kind of thing that you did treat that lightly?
Yes, sir.
Now, having, as you indicated just now, treated it as lightly as you did when Mr. Dean came, you did meet Mr. Kalmbach on the 26th. I know there's a dispute in your testimony concerning what the purpose of that meeting was. Mr. Kalmbach has testified here, and he testified that because of the clandestine manner in which he was being asked to have this money dispersed, he really became concerned, and that he really wanted to check on Mr. Dean's authority, and he trusted you so much that he came to you. And I think we've had with his testimony of his dramatic confrontation with you, which involved look into my eyes and I'll look into yours. Do I really have to do it? And a later telephone call which spoke about that meeting. Now, is it still your testimony that Mr. Kalmbach did not come to you and express deep concern about his carrying out this defense-raising money, and wanted to come back and ask you whether or not it was proper and should he really do it and do it secretly?
Would you restate the question,
well,
please,
on the 26th of July, did Mr. Kalmbach come to you and, as he's testified before this committee, express his deep concern about the propriety of his continuing and raising this money, and ask you to tell him it's all right, that he should keep doing it?
Mr. Dash, I have no recollection of any conversation with Mr. Kalmbach, be it on this date or on the 14th when we met and I believe discussed this same subject, in which he asked me to vouch for the propriety of what he was doing. As I explained before to Senator Gurney, I would be very, very slow to assure Herb Kalmbach of the propriety of any undertaking unless I myself were satisfied of it, because Herb is the last fellow in the world that I would want to involve in something that was improper. So I just don't recall that happening, and I doubt very seriously that it ever did happen in those kinds of terms. Now, your previous question or attempt had something in it about John Dean's authority, and that's the reason that I wanted you to repeat the question. I'm not aware of any possible question of John Dean's authority to ask Mr. Kalmbach to do something as being an issue between us at any time. It doesn't make sense. It's not related to our true relationship in any way. In other words, for someone to come to me and say, does John Dean have authority to ask me to do this, is out of whack with what was our real relationship, which was that Herb Kalmbach could do anything he wanted to do, but that if he wanted an excuse, we'd be his excuse not to do it. And as it developed, he agreed to do this, and he was well down the road, you see, starting back in June, and here we're talking about the third week in July, and he's been doing this all this time. That is more characteristic, it seems to me, of our true relationship, which was that he was a free agent to do anything he wanted to do, but if he was looking for an excuse, we'd be his excuse not to do it vis-a-vis Mr. Mitchell or Mr. Stans. So this business of John Dean authority is what really got me kind of doubtful about your other form of question.
Well, the question was based on Mr. Kalmbach's testimony on oath here, in which he testified that he had come to you to check on that authority. That when Mr. Dean, he said, asked him to do something, or you, that he felt such people so high up in the White House that it was like coming from the president, and that he would follow these instructions because he wanted to be of service. But
well, let me comment on that, if I may, Mr. Dash. Our relationship with Herb Kalmbach was never one of principal and agent, where we simply issued instructions to him when we wanted him to help out. It was always very much on a peer relationship, where if there were a project that we were interested in having him help on, of one kind or another, be it legal work or anything else, we requested him. And if he didn't feel comfortable with it, or he had an adverse relationship in the office, in his private practice, or if he just didn't like the sound of it, he felt very free to say no, thank you. And this business of his marching to orders from the White House just doesn't ring true to me.
Well, all right. Now, may I refer you to your telephone conversation with Mr. Kalmbach on April 19, 1973, and ask you to look to page 4, at page 4. And I'll read whatever you want me to read, but let me start with Mr. Kalmbach's statement, or I can begin with yours. Mr. Ehrlichman, somewhat down the line. But I think the point that which I will make in the future, if I'm given the chance, that you were not under our control in any sort of slavery sense, but that we had agreed that you would not be at the beck and call of the committee. Mr. Kalmbach. And of course, too, that I act only on orders, and you know, on direction. And if this is something that you felt sufficiently important and that you were assured it was altogether proper, then I would take it on, because I always do it and always have. And you and Bob and the President know that. And then you reply, yeah, well, as far as propriety is concerned, I think we both were relying entirely on Dean. Mr. Kalmbach, yeah. Mr. Ehrlichman, I made no independent judgment. Mr. Kalmbach, yep. Mr. Ehrlichman, and I'm sure Bob didn't either. Mr. Kalmbach, no. And I have just the feeling, John, that I don't know if that's a weak read, is it? And you ask who, Dean? You say, no, I mean, are they still going to say, well, Herb, you should have known? Now, you've testified, one, that it was not on orders, that he didn't act that way, and two, that the question of propriety never came up. But here's Mr. Kalmbach talking to you, and you're certainly not disagreeing with him, that he's stating that I act only on orders, and you know on direction, and if this is something that you felt sufficiently important and that you were assured it was altogether proper, then I would take it on, because I always do it. Now, at that point, you say that the propriety issue, you based it on Dean's judgment, made no independent judgment, and neither did Bob Haldeman make any independent judgment. Now, I take it that that's where the testimony rests.
What is your question, Mr.
Well, the question is that when Mr. Kalmbach calls you on this particular date, on the 19th of April, he is reminding you that he was acting on orders.
Well, what did I remind him, Mr. Dash?
That you're reminding him then. You're reminding him then is that you relied on the propriety issue on Dean.
What I'm reminding him is that you were not under our control in any sort of a slavery sense.
Well,
and that is precisely what I've just been testifying here. Principal, agent, or master, servant, or whatever you want to call it.
Not a slave, but he says, I take orders, and if you direct me, I do it.
You've been highly selective, Mr. Dash, and I'll stand very flatly on all four corners of that conversation.
Well, I think you have, and it's obviously what you're telling now, Mr. Kalmbach, is that you made no independent judgment on the propriety.
Well, that's what I testified to you.
I know, and when Mr. Kalmbach has come and testified to us that he counted so much on your reassuring him that it was proper, and you told him, according to Mr. Kalmbach's testimony, that yes, it was important that he do it, and that it had to be secretive, and that if they didn't do it that way, they might have their heads in the lap. But
well, as you see, my recollection before he testified is the same as it is now.
Now, in August 1972, White House that it was like coming from the President, and that he would follow these instructions because he wanted to be of service. But
well, let me comment on that, if I may, Mr. Dash. Our relationship with Herb Kalmbach was never one of principal and agent, where we simply issued instructions to him when we wanted him to help out. It was always very much on a peer relationship, where if there were a project that we were interested in having him help on, of one kind or another, be it legal work or anything else, we requested him. And if he didn't feel comfortable with it, or he had an adverse relationship in the office, in his private practice, or if he just didn't like the sound of it, he felt very free to say no thank you. And this business of his marching to orders from the White House just doesn't ring true to me.
Well, all right. May I refer you to your telephone conversation with Mr. Kalmbach on April 19, 1973, and ask you to look to page 4, at page 4. And I'll read whatever you want me to read, but let me start with Mr. Kalmbach's statement, or I can begin with yours. Mr. Ehrlichman, somewhat down the line. But I think the point that which I will make in the future, if I'm given the chance, that you were not under our control in any sort of slavery sense, but that we had agreed that you would not be at the beck and call of the committee. Mr. Kalmbach. And of course, too, that I act only on orders, and you know, on direction. And if this is something that you felt sufficiently important and that you were assured it was altogether proper, then I would take it on, because I always do it and always have. And you and Bob and the President know that. And then you reply, yeah, well, as far as propriety is concerned, I think we both were relying entirely on Dean. Mr. Kalmbach, yeah. Mr. Ehrlichman, I made no independent judgment. Mr. Kalmbach, yep. Mr. Ehrlichman, and I'm sure Bob didn't either. Mr. Kalmbach, no. And I have just the feeling, John, that I don't know if that's a weak read, is it? And you ask who, Dean? You say, no, I mean, are they still going to say, well, Herb, you should have known? Now, you've testified, one, that it was not on orders, that he didn't act that way, and two, that the question of propriety never came up. But here's Mr. Kalmbach talking to you, and you're certainly not disagreeing with him, that he's stating that I act only on orders, and you know on direction, and if this is something that you felt sufficiently important and that you were assured it was altogether proper, then I would take it on, because I always do it. Now, at that point, you say that the propriety issue, you based it on Dean's judgment, made no independent judgment, and neither did Bob Haldeman make any independent judgment. Now, I take it that that's where the testimony rests.
What is your question, Mr.
Well, the question is that when Mr. Kalmbach calls you on this particular date, on the 19th of April, he is reminding you that he was acting on orders.
Well, what did I remind him, Mr. Dash?
That you're reminding him then. You're reminding him then is that you relied on the propriety issue on Dean.
What I'm reminding him is that you were not under our control in any sort of a slavery sense.
Well,
and that is precisely what I've just been testifying here. Principal, agent, or master, servant, or whatever you want to call it.
Not a slave, but he says, I take orders, and if you direct me, I do it.
You've been highly selective, Mr. Dash, and I'll stand very flatly on all four corners of that conversation.
Well, I think you have, and it's obviously what you're telling now, Mr. Kalmbach, is that you made no independent judgment on the propriety.
Well, that's why I testified to you.
I know, and when Mr. Kalmbach has come and testified to us that he counted so much on your reassuring him that it was proper, and you told him, according to Mr. Kalmbach's testimony, that yes, it was important that he do it, and that it had to be secretive, and that if they didn't do it that way, they might have their heads in the lap. But
well, as you see, my recollection before he testified is the same as it is now.
Now, in August 1972, you then, well, we've had testimony on this, but I'm just raising this on the question.
Testimony on all this.
Well, I know, but right now it's a question of bringing some of this down to a little more finiteness than we've had it. When you called Mr. Peterson and asked that Mr. Stans not go to the grand jury, you did that in August 72. And I think we've had plenty of testimony on that.
Do we know that? I wasn't able to fix that date. What date do you have for that?
Sometime in August of 1972.
I'm not able to say.
I don't have a specific date. Now, do you recall meeting Mr. Kalmbach again on August the 8th? It's in your diary that you did.
Not with regard to any specifics that were discussed in the meeting. I see it on the log, and I have no doubt that it took place.
All right. Now, Mr. Kalmbach's recollection was that after he had that meeting with you, he then went out and made he obtained some private funds from a private contributor, $75,000, and that when he saw you on the 8th, that he just reported to you that he was able to raise $75,000 from a private campaign contributor for this defense fund. Do you recall his reporting to you that he was able to raise that money at that time?
I had the impression that that was what he was telling me July 14th out in his office, because we discussed his use of Tony Ulasewicz to carry money, and my impression was that he was carrying that from the West Coast to the East Coast. I never did know the amount that he raised until I talked to Mr. Kalmbach in April of this year while I was conducting this inquiry. And I don't recall his ever telling me who it was that he raised the money from, although I heard him testify to the effect that...
Did he tell you how much he raised?
I think in April he did, yes. I think he told me $70,000.
Well, I mean earlier. I'm talking about sometime in August.
No, I don't think I knew about it before April of this year.
Did you know at all that he raised it from a private campaign contributor?
Campaign contributor?
Yes, somebody who had been given campaign funds to the president for the reelection of the president.
I think he described to me that it was a business. My impression was two people, and they were in business in California. And that was all the description that I think I had.
And did that raise any problem in your mind that maybe Mr. Kalmbach was going to campaign contributors?
No, I didn't. I didn't connect the two, I don't believe.
All right. Now, after June 17, the date of the break-in, what information did you have, Mr. Ehrlichman, about Mr. Magruder's involvement in the Watergate shortly after?
There was a lot of suspicion shortly after, and I would put this in the first 6 weeks after the break-in. A good deal of suspicion of Mr. Magruder, largely based on what Mr. Sloan was saying to people. And so there was a good deal of speculation that I can recall during that period of time, and it culminated in the conversation which Mr. Dean and I had with the Attorney General on the 31st of July, where this was specifically discussed, that is Mr. Magruder's involvement. The Attorney General said, based on the FBI interviews and the prosecuting attorney's examination into Mr. Magruder's involvement, that it appeared that any involvement that he had related to money. And there was a square dispute between Mr. Magruder and Mr. Sloan as to the truth of the assertion about Mr. Magruder's involvement, and that the Attorney General anticipated that Mr. Magruder might possibly be going to take the Fifth Amendment before the grand jury. Now, that remained the open question, so far as I knew, until Dean or someone told me that Magruder had in fact testified to the grand jury. And then, as matters unfolded, he testified at the trial, and he was considered to have told the truth, and he came out of the shadow at that point.
All right, but were you aware that during this period of time, in the end of June, July, and August, that Mr. Mitchell, Mr. LaRue, Mr. Mardian, Mr. Magruder, Mr. Dean were in frequent meetings, daily meetings, discussing the fact of Magruder's involvement?
No.
And the fact that Magruder was going to tell a particular story to the grand jury?
No, I was not.
Mr. Dean has testified that he acted as a liaison, and he did inform you.
Yes, well, that's not correct.
Yeah. As a matter of fact, if he had, it would not be inconsistent with a meeting in the presence of the Attorney General, where the Attorney General would be reporting that there was nothing with Mr. Dean's being silent. Because if in fact Dean was involved in a cover-up, I take it he would not have let the Attorney General know about it.
Would you repeat that question?
Well, I was saying that you said that the only time you had any clear understanding, or at least the Attorney General's understanding of Mr. Magruder's involvement, is when he met with you and Mr. Dean and told you that there was no involvement. Is that true?
When Mr. Magruder met with Mr. Dean and me?
And the Attorney General.
Mr. Magruder and the Attorney General met with Mr. Dean and me?
Yes.
I don't recall any such meeting.
Well, you did say that the Attorney General reported to you concerning Mr. Magruder, did you not?
Yes.
And what did he tell you then?
Just what I've just testified, that they considered it an important conflict in the evidence as between Sloan and Magruder, and the way it looked to the Attorney General at that point in time, Mr. Magruder might take the Fifth Amendment.
Now, you were aware that on September 15th, the indictment came down on the so-called the 7 defendants.
Yes.
You had a meeting with Mr. Haldeman on September 15th. Did you discuss the indictment at that time?
Well, I didn't have any extraordinary meeting with Mr. Haldeman on the 15th. That would have been just the ordinary morning staff meeting, I assume, which would have included all of the department heads of the White House.
What time was that meeting?
Well, it would be at 8 or 8:15 in the morning.
I think the diary that we have from you shows a meeting at 11 o'clock in the morning. Does your diary show that?
Let me check. You're correct. I don't know the purpose of that meeting, Mr. Dash. I haven't any idea. The indictments, however, the market around the White House has sort of discounted that September 15th action, so to speak, by reason of the Attorney General's announcement on September 12th to the President and the Cabinet and to some of us assembled that the 7 suspects were the only ones who would be indicted. So I don't think that the announcement, the formal announcement on the 15th was in fact any news to us.
When did you first learn of Mr. Segretti's activities and the possible role of Mr. Chapin in those activities?
I think that was at the time that it first began to be talked about in the press. I had not heard of Segretti as an individual prior to that time.
And then did you hold any meetings involving that incident?
Involving what incident?
Mr. Chapin's role in the Segretti matter?
There were a number of meetings to determine what the White House news position or press position should be on that, yes.
And did you, as a result of those meetings, learn about Mr. Chapin's role with Mr. Segretti?
Well, I'm not sure as I learned about them in those meetings as such, but I did begin to learn more in the end of October and the first couple of weeks of November, yes.
And did you make any, did you participate in the preparation of the public statements concerning Mr. Chapin's role?
Yes, I did.
And isn't it true that those statements did not, in effect, acknowledge Mr. Chapin's role in either employing Mr. Segretti or having Mr. Segretti work for the campaign?
You say did not, in effect, acknowledge?
Did not acknowledge.
Did not acknowledge? Well, I was under the impression that the material that was being worked on, and you have an exhibit that I think has my handwriting on it, had a couple of depositions that were, or affidavits that were proposed to be attached, which did make rather full and complete acknowledgement. Unfortunately, those were not released. But that would have been the form of release that I would have preferred.
Was it your statement that you recommended that there be a full release of Mr. Chapin's involvement? Now, do you recall in September 1971 traveling with the President? I think you indicated you traveled with the President to Japan at that time. Did you?
No, sir.
When did you go with the President to Japan?
The President went to Hawaii to meet the Japanese Prime Minister in September. Is that what you mean?
Well, yes.
Yes, I did.
Did you accompany him then?
Yes, sir.
Now, did you stop on your way at the Benson Hotel in Portland?
Well, we did sometime, and I can't remember whether it was on that particular trip or not. My recollection is we went
let's see. No, we went right straight out and right straight back to Hawaii. Went out on the 30th, direct to Hickam, and we came back from Hickam direct to El Toro on September 1.
When, Mr. Ehrlichman, did you first become aware that Mr. Hunt was seeking executive clemency?
I'm not sure that I was ever aware, in the terms that you just framed your question, that Hunt was seeking executive clemency in those flat terms. I became aware after Mr. Colson had had his conversation with Mr. Bittman that Mr. Bittman had attempted to open a conversation with Mr. Colson on that subject, which Mr. Colson says he refused to engage in. Now, that is as far as that ever went in behalf of Mr. Hunt, so far as I know.
And you don't know of any assurances that Mr. Bittman or Mr. Hunt received from Mr. Colson concerning executive clemency?
Well, Mr. Colson stated to me precisely the opposite, that he had been very careful in not making any assurances to them.
Now, I think your diary shows that you did meet with Mr. Colson and Mr. Dean on January the 3rd. Then you met with the President and Mr. Haldeman on January the 4th, and again with Mr. Dean and Mr. Colson on January the 5th. This is approximately the time that Mr. Dean has testified that the request or the issue came up concerning Mr. Hunt's desire for executive clemency, and that Mr. Colson and Mr. Dean, according to Mr. Dean's testimony, spoke to you about it, and that you said, according to his testimony, that you would check with the President and came out and said that no commitment should be made, but that some assurance should be given to him. Do you recall that? Not the testimony, recalling doing that.
Doing what, Mr. Dash?
Being asked by Mr. Colson and Mr. Dean to raise the question of executive clemency for Hunt with the President.
All right, stop right there. They didn't do that. Now go ahead.
All right. You're checking with the President whether or not it would be possible to give Mr. Hunt executive clemency.
That would be on the 4th of January in the company of Dr. Kissinger and Mr. Haldeman. Is that right?
Sometime around.
Pardon me?
Around that.
That meeting of at 3:02 on the 4th. Is that the meeting you're suggesting?
Well, you met with the President a couple times during that period of time, but the 4th
No,
you did meet
no,
with
I
the
didn't.
President.
As a matter of fact, I met with the President one time on the 4th at 3:02 in the company of Mr. Haldeman and Dr. Kissinger. Is that the time you're suggesting that I asked the President if we could give Hunt executive clemency?
Did you meet with the President on the January the 5th?
Not according to my records. Oh, excuse me. Yes, Dr. Kissinger and I had a 10-minute meeting with the President at 4:55 on that day.
Did you at any time meet with the President and discuss executive clemency?
Yes.
When?
In July of 1972.
Now, why in July of 1972 would you be discussing executive clemency with the President?
Because it occurred to me as an original proposition that sooner or later somebody was going to raise this issue. And I thought it would be a very good idea to talk it through with the President before it came up in any specific context and find out exactly where we stood.
Well, that time the indictments hadn't come down.
That's correct.
It was shortly after the break-in. Why would it even come to your mind that any of the defendants would have raised the question of executive clemency?
Why? Because you had a defendant who was an employee of the committee to reelect the President. And it seemed to me just a very natural thing that inferences would be raised at some time in the future.
Well,
we had a long walk on the beach on that particular day, and we talked about a lot of subjects, and this was one of the subjects we talked about.
Had you had any discussion with Mr. Colson or Mr. Hunt at that time about it?
At that time?
Yes.
Not that I can recall.
It seemed unlikely that you would, and it just is somewhat surprising that so early after the break-in you would even be talking about executive clemency to the President.
Who did it surprise, Mr. Dash?
I said it does seem surprising.
To you?
To me. That you, in July, shortly after the break-in, before any indictments, that you would be discussing executive clemency. But that's your testimony that you did.
Not only that, that's what happened.
Now, and you never did after having any discussions with Mr. Dean later on in January.
I'm sorry, I didn't hear the first
And you
part.
never again discussed that with the President after talking with Mr. Dean about executive clemency.
Never again, no. I think that there were discussions in March and April of this year about the allegations that Mr. Dean was
I'm
making.
referring back earlier to the January period because just before, actually to put the point in time accurately, just before Mr. Hunt pleaded guilty is when Mr. Dean...
Mr. Dean's original story was, of course, that I jumped up from the meeting and ran downstairs and popped into the Oval Office, which, of course, was nonsense. So then he contrived this other story, and neither one of them are true, Mr. Dash.
Now, on February 10, 1973, you, Mr. Haldeman, Mr. Dean, and Dick Moore did meet in La Costa, did you not?
Yes, sir.
Could you tell us what the purpose of that meeting was?
Yes, that meeting was called because the President had asked who was handling the preparation of the White House case for the Senate Select Committee hearings and what planning was being done and what was the White House position going to be on matters like executive privilege. And there were no answers to those questions. We had just come from the inaugural. Everybody had been very busily occupied up to that point. And frankly, there wasn't anybody handling that. And so one of us, and I forget who, called John Dean and asked him to come out and sit down and talk through this whole subject of White House response, so to speak, to the upcoming hearings of the Senate Select Committee.
Well, did the discussion include just not only the White House response in general or executive privilege issues, but did it also include what steps you might take in terms of affecting the resolution authorizing this committee, what steps you might take in obtaining a minority counsel that would be helpful, an evaluation of members of the committee, as has been testified by Mr. Dean before this committee?
Well, it was a little bit like attorneys meeting before a trial to talk about the upcoming trial and what the selection of the jury would be like and the kinds of jurors that you would prefer to have in a case of this kind and what opposing counsel was like and so on and so forth. It was a sort of a general brainstorming session on the subject, and all those subjects that you mentioned came up, as did a whole raft of other subjects relating to these upcoming hearings.
Now, are you aware of then what assignments were given to anybody to follow up on this discussion?
Yes. Mr. Dean was given an assignment to attempt to prepare a general statement of Watergate in its broadest aspects: money, Segretti, planning and execution of the break-in, the widest kind of a preliminary statement, because it was decided that rather than to die by inches in terms of having questions asked and tiny bits of fact come out in answers through the process of the hearing, it would be much better if the entire story were laid out in a comprehensive statement in advance. So Mr. Dean was given that assignment. After a number of hours of discussion, it was sort of the consensus of the meeting that the best possible management entity would not be the White House or government people, but would be the committee to reelect. And so the thought was that the committee to reelect, with John Mitchell stepping back into the management of it, would be an ideal focal point for all kinds of the various management problems associated with these hearings. And Dick Moore was going to go and talk to John Mitchell about this idea. I heard the testimony about Dick Moore going up to talk to him about money. That had to do, as I recall, with a specific aspect of this. Mr. Dean raised the point that these defendants in the break-in case, many of them either had cases that were pending sentencing or were on appeal or in some kind of an interlocutory stage, and that they might have the right to have their rights protected by seeking a judicial delay of the committee hearings. it was recognized in the course of passing that that was going to obviously require the services of attorneys, and those attorneys would have to be paid. And so that was, as Dick Moore testified, a rather passing subject, but nevertheless it was noticed as a money problem that could not be satisfied out of campaign funds, and that he should also talk to John Mitchell about that.
But why would you, Mr. Ehrlichman, and Mr. Haldeman, Mr. Dean, with your positions at the White House, concern yourselves over the criminal defense lawyer's case that might have some impact on delaying this committee? Was it a strategy issue?
It was in the nature of a strategy issue, and it was a passing strategy issue. I wouldn't want it to get out of proportion and have you focus on it as being sort of a central strategy issue here. It was really a very, very glancing blow or passing reference to an aspect of this which Mr. Dean raised as a legitimate part of the strategy question.
Taking it as a passing blow or something, and not certainly a central theme, it was considered as a strategy to keep this committee from going forward with its hearings.
This meeting covered dilatory tactics. It covered a wide variety of subjects, including dilatory tactics, but certainly not limited to them.
Well, what did you have to be afraid of?
Sir?
What did you have to be afraid of?
Well, I think it was conceived that the attack would be highly partisan, that it would be strongly anti-administration, anti-the president. Senator Ervin was then believed to be a very partisan man, and I think there was strong concern that this whole process of this select committee would have worked to the serious disadvantage of the administration. There was certainly no acceptance of the thought that the undertaking was totally benign.
This was on February 10th, the La Costa meeting we talked about. Then I take it, have you had an opportunity, and I don't want to take any time on it, to see the agenda items that Mr. Dean testified that later went into the President concerning discussion with Senator Baker and on also minority council issues?
Yes, I did. I think that the suggestion that somehow relates to the La Costa meeting is badly overdrawn and overemphasized. I think Mr. Haldeman is your better witness on that, but from what I know of what took place at the La Costa meeting, the relationship between the two is much more tenuous than Mr. Dean attempted to draw.
I would agree with you that Mr. Haldeman is, but really a follow-up of La Costa rather than La Costa.
No, even that. I think the proximate relationship is doubtful.
By the way, let's go back briefly because perhaps your diary is not as accurate as the White House log. On January 4, 1973, when you indicated that you perhaps wouldn't take up in the presence of Dr. Kissinger the issue of executive clemency.
No, I didn't say that. I just asked you if that's the meeting you were relating to.
On the 4th of January 1973, does your diary show that you met with the President from 3:02 p.m. to 4:44 p.m., and that you were with Mr. Haldeman in that meeting from 3:02 to 4:44, which is the full period, Mr. Collins from 3:04 to 3:05, and 4:18 to 4:49, and Dr. Kissinger 4:30 to 5:15.
Well, I don't have all those refinements in my diary, but I show that Dr. Kissinger was in the meeting I was in for approximately 45 minutes, of a total of about an hour and 40 minutes, something of that kind.
There was a time when you were with the President and Mr. Haldeman and yourself alone.
I assume so.
Now, in March 1973, did you become aware, and I think you testified that you did, of the increased demands for Hunt for money, so-called Hunt's blackmail?
Well, I wouldn't use the word increased because I think I didn't have any frame of reference in which to identify this as an increase. I certainly am familiar with the blackmail.
Of a demand, the blackmail. Who informed you of this?
Mr. Dean.
And did it raise a question in your mind, at least at this time, again, having recalled that money was paid for defense, of the propriety of paying this money when such a demand was being made?
Oh, certainly. Well, now, let me separate out all of the the testimony that you just inserted in that question, and maybe you could restate the question without all the embellishments.
Well, just the same question. You had found nothing wrong, and as a matter of fact, just beforehand, on the February 10th meeting, again had discussed making certain payments or going up to Mitchell, having Mr. Moore go see Mr. Mitchell about raising some funds for the defendants. And now in March 1973, sometime in March, you become aware of a demand. Mr. Hunt, would you just call it blackmail?
The difference between the two is dramatic. There was no suggestion at La Costa that any money be paid in consideration of anybody's silence or anything of that kind. The money we were talking about at La Costa was to compensate attorneys who would file motions in behalf of the defendants, and as far as I'm concerned, that would have been a completely legitimate undertaking, privately raised funds for that purpose.
Well,
this was a flat-out blackmail attempt. If money was not paid, then Hunt would say so-and-so, but if money were paid, he would not say so-and-so. That's the first time I encountered anything of that sort in this entire, what would that be, 10 months.
Well, were you aware that back in November, Mr. Hunt had a telephone conversation with Mr. Colson, and Mr. Colson taped that conversation with regard to Mr. Hunt's wanting money and wanting to, being very unhappy that he wasn't getting the kind of money he was.
Well, now I've heard testimony about that, and that I'm supposed to have heard that tape.
Yes, did you hear that tape?
I don't recall ever hearing that tape. I recall Mr. Dean coming to Camp David on one occasion during the 2 months we were up there. We've repeatedly, since he testified to that effect, we've repeatedly tried to get a transcript or a copy of that tape without success from your staff. But I would certainly like to see it, because I just draw a blank.
I don't. Mr. Wilson, have you requested the copy of this?
I or Mr. Strickler asked Mr. Hamilton for it.
Well, Mr. Hamilton, yeah.
Well, in any event, the answer to your question is that I just really draw a blank on that. It doesn't relate to anything that I can recall.
Well, may we have it now?
Yes.
Good.
I have a copy, and if someone will take it for you to peruse it, maybe it'll either refresh your recollection or won't. If it does, I'd like you to respond. If it doesn't, you can't respond.
Fine. May we keep this?
That's my only copy.
Sir?
It's my only copy, but I'll make a Xerox copy for you.
While John Ehrlichman, as attorneys, examine the script of the Colson conversation with Howard Hunt, we're going to take a short break. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As we go back to the hearings, Chief Counsel Sam Dash has asked John Ehrlichman if he'd heard the recording of a conversation between Howard Hunt and Charles Colson.
Counsel, I don't recall ever either seeing this transcript
Mr. Wilson, would
or
you like
hearing
a copy
this.
of that?
Please.
Yes. If you could return it, we'll see that you do get a copy. And you stated a little earlier, prior to my showing you that document, that Mr. Hunt was making a demand, either I get so much money or I'll tell this or that. What conceivably could Mr. Hunt have told?
The way John Dean explained it to me, the threat was in terms of he would tell seamy things about what he did at the White House for Mr. Krogh and me. Now, I took that to refer to the California break-in, which is the only thing I could think of that would that he ever did at the White House for me, that of any kind, for that matter. Now, and I asked Mr. Dean if he knew what this was about, and he said he assumed that that's what it was about.
Now, did you recall a meeting with Mr. Dean and with Mr. Mitchell? I think March 22nd probably would be the date, where did you ask Mr. Mitchell whether or not Hunt's demands had been taken care of?
I heard that testified. In point of fact, my recollection of that is that conversation was between Mr. Dean and Mr. Mitchell, and it was Mr. Dean saying, just, is that matter taken care of, without reference to Hunt or anybody, and Mr. Mitchell sort of grunting and saying, maybe, or I guess so, or something very vague.
Did you learn about that time that, in fact, Mr. Hunt's demands had been taken care of?
No. In fact, it wasn't until the testimony here that I was aware of that.
And did you have any knowledge or awareness of Mr. Fred LaRue's role in making those payments? Did you, by the way, tell the President concerning at least the blackmail demands?
By the time I discussed it with him, he already knew of it.
Now, it appears from certainly the White House logs that we have received that after the La Costa meeting, sometime after February 10th, Mr. Dean's meetings with the President increased really significantly, because he had very few meetings prior to that time, and then they were quite frequent after. Could you explain, to your knowledge if you have, why that occurred?
Yes, sir, I think I can. At our next joint meeting, Mr. Haldeman's and mine, with the President, he said, well, how did the weekend go, or words to that effect, and when can I expect that statement, meaning this broad statement that Mr. Dean was to prepare? One of us, and I think it was I, said, I don't think you're going to get that statement. And he said, why not? And I said, well, John Dean has a lot of reasons why such a statement should not be released. And they related to the rights of defendants and to the civil suit that was pending and to the problems of executive privilege and so on. And the President expressed considerable impatience and began to lean on me pretty hard. And I said, well, Mr. President, I'm in the middle on this, and I would be very grateful if you would have a personal conversation with John Dean about these problems, so that you would get a first-hand feel for the objections that he is raising to the request that you've been making. And he said, all right, I'll do that. And it was very soon after returning to Washington that I have a note in one of my meetings with him that he wanted to see John Dean immediately that day. And he did, and that was the first meeting of this series. But I think it was, and about that same time, the President said, I want you to stay out of this, to me. He got me started on a massive so-called surrogate operation of sending the cabinet and administration people into the country on questions of impoundment and overspending and budget cuts and things of that kind. And I have very explicit instructions in my notes to the effect that I am to discontinue any further
devotion of time to the whole Watergate subject. The dean has it, that the president is satisfied that he's in charge, and from that point forward, I'm out of it.
Well, did you or anybody in your presence ever recommend to the president that it might be a good idea to have a number of meetings with Mr. Dean if executive privilege was going to be raised with regard to Mr. Dean's appearance?
You mean attorney-client privilege?
Well, or executive privilege.
No.
That prior to that time, this came up during the Gray hearings, and the issue of Mr. Dean being subpoenaed down or invited down, the question would be that if he didn't meet with the president very much, whether there could be very much executive privilege or attorney-client privilege. And to your knowledge, I'm only asking whether or not either you advise the president or in your presence anybody advised the president that would be a...
You'll remember, Mr. Dash, that I testified that when I first got into this matter on the 30th of March again, that one of the great remaining open questions was this whole business of how attorney-client privilege worked vis-a-vis the president and counsel to the president. And I had to call for a lot of briefing on that. It was still an open question, but I was not well versed in the subject prior to that time, and relied entirely on Mr. Dean to preserve that relationship in whatever way it should be preserved.
All right, now, we've had the testimony from Mr. Dean.
Mr.
Yes.
Dash, may I interrupt you a moment to address the chair? Mr. Chairman, again on the question of scheduling, it's obvious that the examination of Mr. Ehrlichman will not be completed as we had hoped in time. And I want to mention again that Mr. Haldeman's statement will require at least 2 hours to read. I wouldn't like him to start it this afternoon and not complete it. If Mr. Dash, and I don't want to limit Mr. Dash, if he goes for another hour, could I either have the assurance of the committee that Mr. Haldeman could read his whole statement before we recess this evening, or that we will begin in the morning?
Mr. Dash has just assured me that he has only about 15 minutes more. There'll be a question. The other interrogator will be Mr. Thompson. And
I'm about finished, Mr.
we could certainly complete a statement today, because the committee decided this morning to start the meeting at 9:30 in the morning and run till 5 or 5:30, and even to expedite these things, because I think the country would like to get the investigations over, in particular this phase.
I'd be in favor of some night meetings.
Well, we'll certainly see that Mr. Haldeman gets to read his entire statement without today, and I hope that we can complete the examination more, notwithstanding the fact that I'm just a little tempted to confess that at the time Mr. Ehrlichman was testifying about a while ago, I'm sorry the conclusion was drawn that I was sort of partisan. I was partisan to the Constitution because I was fighting for the congressional view in respect to impoundment, and also for the idea that the Constitution requires the confirmation of such important officers as direct and deputy director of the Office of Management and Budget. And I was also calling attention about that time to the fact that the Supreme Court had held that when witnesses were subpoenaed to appear before a congressional committee, if they didn't appear, they could be arrested and brought before the Senate. And that was in direct opposition to the theory that there was an executive privilege that entitled a former or present White House employee or aide from appearing before any congressional committee. And I'm sorry that that caused the feeling that I was sort of partisan, because I doubt whether there's a Democrat in the Senate that voted more to stand under the president's position on economic issues and on war issues. And just the other day I voted against the War Powers bill because I thought it encroached on the constitutional domain of the president. Excuse the interruption. No, we'll finish it.
Mr. Chairman, it ought to be noted that time will be deducted from council's time.
I think we've had testimony on the March 21st meeting from Mr. Dean, and Mr. Dean testified that he gave a full story to the president concerning who might be involved, and that in the Watergate, either in the break-in or the cover-up, and that you did have an afternoon meeting with Mr. Haldeman, Mr. Dean, and the President on the 21st. Mr. Dean's testimony is that at that afternoon meeting, he stated both to you and Mr. Haldeman that all three of you, Mr. Dean, Mr. Haldeman, and Mr. Ehrlichman, were indictable. Did Mr. Dean so state to the President?
I have no recollection at all, Mr. Dash, of that being said at that time. As a matter of fact, it was several weeks after that before we had a conversation with Mr. Dean in which he finally alluded to my relationship with Mr. Kalmbach as presenting some embarrassment to me, but certainly nothing that would be indictable. But back on the 21st of March, I don't believe that Mr. Dean's theory of the case had crystallized yet.
Well, of course, on March 22nd, I think you've always testified, you met with the President, Mr. Haldeman, Mr. Dean, and Mr. Mitchell,
yes.
And I think your view of it was that if the President knew anything at that time, he was, your guess was that he probably was not letting it out because he was still in the midst of his investigation. Because it appears from your testimony, Mr. Mitchell's testimony, Mr. Dean's testimony, that the President did not confront any of the parties at that meeting with any of the charges.
That's correct. That's correct.
Now,
that is correct without adopting all of the preceding 11 sentences in your question.
Well, I took your testimony.
Well, I know you paraphrased, but right. And I do not adopt your paraphrase.
All right. Let the record stand as to what as was the actual testimony. On March 28th, you called Mr. Kleindienst. Now, if in fact, certainly on March 21st, and go back to March 21st, the President has referred in his May 22nd and I think in his April 17th statement that he learned new facts, serious facts.
Charges, I believe he said. Charges is
charges
I think the word.
On March 21st. And Mr. Dean has testified as to what, at least so far as he was concerned, what charges he made. Now, you weren't at that meeting, to be sure, on March 21st. And yet, when you called Mr. Kleindienst, you stated in that call that the President said to me to say to you that the best information he had and has in this is neither Dean, nor Haldeman, nor Colson, nor I, nor anybody in the White House had any prior knowledge of the burglary. He said well, then he went on, and that you were going to, if he was to give more information. Now, I take it that if the President had received information from Mr. Dean, that, for instance, say Mr. Strawner himself had information on March 21st, he would not be instructing you to call Mr. Kleindienst to give that message, would he?
Well, I certainly am not going to respond to that question, Mr. Dash. It involves your own personal hypothesis, and it invites me to join you in it, which I am not willing to do. I've stated what my hypothesis is with regard to the President's conduct after March 21st, and I don't happen to agree with yours.
Well, I take it perhaps maybe the best evidence of what occurred on March 21st between Mr. Dean and Mr. President might be the tapes that recorded that conversation.
Or someone else who was present.
Now,
like Mr. Haldeman.
We would still have the tapes also that might corroborate that discussion. Now, did you, did Mr. Dean ever show you a list, a handwritten list actually on his part that he had made up after he had gone to see the prosecutors, in which he had listed various people who he claimed, based on information he was getting from the prosecutors and information he was giving to the prosecutors, would be indictable or were for criminal charges?
Is that this exhibit that you have in
yes,
your...
the exhibit...
No, he never showed that to me.
Did he ever show you that?
No.
He has so testified that he did, and I guess that, again, you would say would be untrue on his part.
That's correct.
You've also testified that you were asked to make an inquiry on March 30th by the President. I think
yes.
That inquiry is what it was, and that you reported to the President on April the 14th.
Yes.
And the President came out with a statement on April the 17th. Now, in between that time, on the 15th of April, were you aware of the fact that Mr. Kleindienst and Mr. Peterson met with the President and reported fully to the President as to what information they were getting in the grand jury investigation?
Well, I precipitated that meeting, yes, Mr. Dash.
How did you precipitate it?
By calling Mr. Kleindienst at 5:15 on the afternoon of the 14th at the President's request and advising him of my report to the President that morning and also my interviews with Mr. Mitchell and Mr. Magruder. Then, after that call, as you know, the Attorney General had an all-night meeting with his U.S. Attorney and his prosecuting attorneys. He then made arrangements to see the President after church on the morning of the 15th.
And would you say that actually the President's statement on April 17th was based on the meeting with Mr. Kleindienst and with Mr. Peterson?
You mean exclusively?
Not exclusively, but to a large part.
How large?
Well, all right. You have testified frequently to questions put to you concerning your inquiry, and you've indicated that you wouldn't call it an investigation.
Well, I'm very modest about it because I don't consider it to be a total investigation.
Right. And
of the subject matter.
And you said it was hearsay on hearsay, and different people were coming in, and you were taking notes. Mr. Kleindienst and Mr. Peterson, at least, were able to give the President a fairly complete report on what they were getting in the grand jury, which was both testimony under oath, probably, and also information they were getting from the prosecutors.
Well, as I testified, I think, to Senator Montoya's question, there were really a number of converging lines at this point, and I certainly didn't intend, and matter of fact, I hope I expressly disclaimed any credit for cracking the case or anything of that kind. But you had the grand jury effort. You had the prosecuting attorneys working along with the grand jury on the one hand. You had the Department of Justice effort, and then you had this sort of subsidiary inquiry that I was making, all of which contributed to the President's fund of knowledge on this subject. Now, the statement on the 17th was not intended by any means to cap it. The inquiry went on after that. And so I think you have to see this as a convergence of a number of different efforts that finally has brought this thing into the open.
And I think you've testified that you participated in the preparation of that statement of the 17th.
Yes, sir.
By the way, did you, although you had left the White House, did you participate in any way in the statement of May 22nd of the President?
No.
By the way, Mr. Ehrlichman, have you ever received, either directly or indirectly, since the 1st of January 1969, any campaign funds for any purpose?
Any campaign funds for any purpose? I had some expenses reimbursed at the convention, which were not legitimate government expenses and which were reimbursed to me by the committee to reelect. And I've forgotten what those were. They were quite nominal, as I recall.
They were nominal?
Yes.
Would that be the extent of it?
Well, it is possible that I was still receiving reimbursement of expenses from the 68 campaign in January 69. I'm not prepared to say without.
But if so, would that be a nominal amount or would it be a large
amount? No, it would be, I would think, fairly extensive because at that time I was in the 68 campaign I was the tour director and I was racking up a fair amount of personal expenses in that process.
I'm not asking
But I'm just not able to recall whether those kept coming in that late or not. They were pretty slow.
Yeah. No, I'm just talking about after the 68 campaign, 69 thereafter. I'm not asking.
As I say, they were.
Mr. Chairman, I want to raise a question of relevancy with respect to this date that Mr. Dash is relying upon. May I say with great respect, I think your resolution does not reach this far, sir.
I don't think the resolution reaches anything that except the presidential election of 1972 and any campaigns which preceded that which were relevant to the selection of candidates to run in 1972.
Which would be the primaries.
Yes, well, it'd be the primaries, all the campaigns of the candidates prior to the primary. I don't think it would reach 1969.
Yeah, well, it would Well, the day after the 68 election, if the funds that were received in 69 were funds used for the 1972 campaign, because the campaign began the day after the 1968 election.
Well, that wasn't your question, but I want to adjust myself to that question also.
All I asked was, and I think I received an answer, whether or not from 1969 onward, Mr. Ehrlichman received any campaign funds.
Well, I don't believe we can go back now. If he received any funds that were collected in 1968 campaign that were turned over to the committee for use in 1970, I think that would be valid, but...
Well, let the question include that premise then, sir. Well, the way the question is asked, it's simply...
Well, I frankly don't think that what he received in 1969 would be within the purview of our resolution.
You and I agree there.
Mr. Chairman, there's one other point, and I don't mean to belabor it since the chair has already ruled, but if there is information that the staff has on some aspect of the matter in that respect, I understand it has not been brought to the attention of the minority, so I'd like to request that the majority staff might do that before they pursue the question.
I'm not pursuing the question any further. I just asked the question.
Could I be sure?
Well, Mr. Dash, I reiterate my request, and I'm sure the chairman will agree that the understanding is that the information will be equally shared. So if there is a point, I'd like to have it.
In other words, my tentative ruling, unless it's upset with the committee, is that we have no jurisdiction to investigate anything connected with campaign funds which were left over from the other 68 election, unless those funds were used in connection with the 72 election.
The chair has ruled, and I agree with him for whatever that's worth, and I think we ought to go ahead.
Right. Now, in preparation for your testimony, Mr. Ehrlichman, have you had access for your records at the White House?
It's what I suppose you would call limited access. I can go in and look at records, but I can't copy, I can't take notes, and I'm not allowed to take them from the room.
How long did you stay in the White House after April 30 when you tendered your resignation?
About 2.5 weeks.
Did you have access at that time to your records?
Yes, I did. I had, excuse me, I did not have custody of my records at that time. My custody ceased on the 30th of April, so that then I was subject to the limitations which were then imposed by the Office of the Counsel there from that day forward. I literally physically gave up custody and possession of the records on the 30th of April.
Now, based on the President's latest statement concerning our efforts to get what might be relevant documents that are not covered by executive privilege as considered by the President, that we would have to ask for it specifically and describe the record specifically, would you be willing to assist the committee in identifying certain of your records still in the White House which we might feel necessary to ask for by description and with specificity?
I'd want to take counsel on that before I responded to that, Counsel.
Right. Now, have you, prior to your testimony before this committee, discussed your testimony with Mr. Haldeman?
Discussed my testimony with him?
Yes.
You mean how I was going to answer questions?
Yes.
No, we've discussed the subject matter very extensively, but I've not discussed my testimony.
Well, in other words, you discussed the subject matter of your answers, but not the testimony as such.
Not the subject matter of my answers. The subject matter that's at issue here, I have discussed with him, both during and since.
Mr. Dash, Mr. Chairman, may I ask would you permit Mr. Ehrlichman to describe how the preparation for this hearing was pursued and the preparation of their individual statements?
Yes, if he wishes to make a statement on that.
Yes, because that's my last question, and if he wants to finish with that, I have no further questions.
Well, as you know, several weeks ago, I would imagine 5 weeks ago or so, Mr. Haldeman moved. I have not seen him to consult since then, except for perhaps a total of 20, 30 minutes maximum. My opening statement in this matter was prepared personally
and without any consultation with Mr. Haldeman, as I assume his was, because I've certainly not had any consultation with him on his. I have spent virtually every day since my termination at the White House 2.5 weeks after the 30th in attempting to get straight the dates, the places, the times, the persons present, the subject matters covered, and to go back into the White House records and take a look at my records to try and refresh my recollection as to what has taken place in the premises. From time to time, prior to his departure, Mr. Haldeman and I have discussed aspects of this matter, but certainly not in terms of testimony here, only in terms of what actually took place in that research effort.
Well, I take it that those times you did discuss it, it was in anticipation of both of you appearing before this committee.
Mr. Dash, you are not the only girl in town. There are lots of other inquiries going on.
Anticipation of testimony to all the other girls. I have no further questions, Mr. Chairman.
Mr. Chairman, I believe Senator Wacker has a question on this very point. I'd like to yield to him at this time. Thank you very much. Mr. Ehrlichman, do you assume that your testimony is in complete accord with that of Mr. Haldeman when he appears before this committee, and that there exists no conflict between both of you with regard to all the events this committee has covered?
No, I don't assume that, Senator.
Well, under those circumstances, may I ask then how it's possible that you're both being represented by the same attorney? Isn't this a potential conflict of interest in the event that Mr. Haldeman disagrees with your recollection of the events in question?
Mr. Chairman, may I answer that question? I'm the one who is the subject of that question, and I'd like to answer it from
I'd like to hear the answer, because I think Mr. Ehrlichman's answer is quite clear. There is the potential of a conflict between the two of them.
There's no really potential conflict at all. I don't understand.
Your client has answered that there is. That's what his answer.
I don't assume that there is a coincidence.
Mr. Senator Weigel, let me say something to you, sir. To suggest that I'm involved in a matter where there is a conflict between two clients is the same as to suggest to me I'm that sensitive that I'm guilty of some fraud when I sit here.
I would have the clerk reread the question that I asked to Mr. Ehrlichman and have Mr. Ehrlichman's response to my question.
Yeah.
Mr. Ehrlichman, do you assume that your testimony is in complete accord with that of Mr. Haldeman when he appears before the committee, and that there exists no conflict between both of you with regard to all the events that this committee has covered? Answer no, I don't assume that, Senator.
Is that your testimony, Mr.?
I don't make an assumption on that.
In other words, I repeat
may I
again,
continue
the same question your client answered. He said no. In other words, that there possibly could be a conflict.
No, he didn't say that at all.
I did not. I said I made no assumption. That was the question you asked me.
In other words, that it could be in conflict.
No,
There couldn't be no conflict that I'm aware of, sir.
I asked your client the question.
No, but I'm entitled
question, and if he wants to finish with that, I have no further questions.
Well, as you know, several weeks ago, I would imagine 5 weeks ago or so, Mr. Haldeman moved. I have not seen him to consult since then, except for perhaps a total of 20, 30 minutes maximum. My opening statement in this matter was prepared personally and without any consultation with Mr. Haldeman, as I assume his was, because I've certainly not had any consultation with him on his. I have spent virtually every day since my termination at the White House 2.5 weeks after the 30th in attempting to get straight the dates, the places, the times, the person's presence, the subject matters covered, and to go back into the White House records and take a look at my records to try and refresh my recollection as to what has taken place in the premises. From time to time, prior to his departure, Mr. Haldeman and I have discussed aspects of this matter, but certainly not in terms of testimony here, only in terms of what actually took place in that research effort.
Well, I take it that those times you did discuss it, it was in anticipation of both of you appearing before this committee.
Mr. Dash, you are not the only girl in town. There are lots of other inquiries going on.
Anticipation of testimony to all the other girls. I have no further questions, Mr. Chairman.
Mr. Chairman, I believe Senator Wacker has a question on this very point, so I'd like to yield to him this time. Thank you very much. Mr. Ehrlichman, do you assume that your testimony is in complete accord with that of Mr. Haldeman when he appears before this committee, and that there exists no conflict between both of you with regard to all the events this committee has covered?
No, I don't assume that, Senator.
Well, under those circumstances, may I ask then how it's possible that you're both being represented by the same attorney? Isn't this a potential conflict of interest in the event that Mr. Haldeman disagrees with your recollection of the events in question?
Mr. Chairman, may I answer that question? I'm the one who is the subject of that question, and I'd like to answer it from Mr.
I'd like to hear the answer, because I think Mr. Ehrlichman's answer is quite clear. There is the potential of a conflict between the two of them.
There's no really potential conflict at all. I don't understand.
Your client has answered that there is. That's what his answer.
I don't assume that there is a coincidence.
Mr. Senator Weigel, let me say something to you, sir. To suggest that I'm involved in a matter where there is a conflict between two clients is the same as to suggest to me I'm that sensitive that I'm guilty of some fraud when I sit here.
I would have the clerk reread the question that I asked to Mr. Ehrlichman and have Mr. Ehrlichman's response to my question.
Yeah.
Mr. Ehrlichman, do you assume that your testimony is in complete accord with that of Mr. Haldeman when he appears before the committee, and that there exists no conflict between both of you with regard to all the events that this committee has covered? Answer, no, I don't assume that, Senator.
Is that your testimony, Mr.?
I don't make an assumption on that.
In other words, I repeat
may I
again,
continue
the same question your client answered. He said no. In other words, that there possibly could be a conflict.
No, he didn't say that at all.
I did not. I said I made no assumption. That was the question you asked me.
In other words, that it could be in conflict.
No,
there couldn't be no conflict that I'm aware of, sir.
I asked your client the question.
No, but I'm entitled to answer the question because you are assailing my integrity.
I am not assailing your integrity. I am questioning your client. I question. Let me get an answer from him again. Let me ask him the same question. Do you assume that your testimony is in complete accord with that of Mr. Haldeman when he appears before this committee?
I make no assumption, Senator. I have no way of knowing whether his testimony is going to coincide with mine or not.
So that it is possible that there would be a conflict.
I say there isn't.
I'm asking your. I'm asking, Mr. So it is possible that there would be a conflict.
We're the ones.
Mr. Wilson, now, I think...
Mr. Chairman, you parliamentarians have a phrase that I want to use. I want to rise to a point of personal privilege.
Well,
I'm a very sensitive person about this, and I don't want Mr. Senator Weick or anybody else to insinuate that I'm representing two clients who have conflicts. Now, Mr. Strickler and I know definitely there's no conflict between these two gentlemen. I want to say also that I
was proceeding on the theory that Senator Weicker was merely addressing this particular question to your client and not to you. Now, he did address one question to you, and you denied there was any conflict of interest, and I don't believe that this is a matter that the committee ought to pursue as to the conflict of interest of lawyers.
Thank you. Otherwise, I'd like to speak for about a half hour.
In other words, Mr. Ehrlichman, there is no conflict. No, if there is no, I'm asking your client, not you, Mr. Wilson. Mr. Ehrlichman, in other words, there is no conflict between your testimony and the testimony of Mr. Haldeman.
You told me earlier that you couldn't
wait a minute. Let Senator Weicker complete his question, including putting a question mark after it.
Where does that leave me?
Well, we'll let your client answer it first, and then if you want to address the statement to the chair, I'll be glad to receive it.
Great length. Go ahead, Senator Weicker. Ask my client the question.
That there exists, I'm asking you the question as to whether or not there exists or could exist conflict between both of you and Mr. Haldeman, with regards to the events that this committee has covered as far as testimony is concerned. Or let me repeat the question right from the outset, again from the clerk's tape, but I've got it in front of me. Do you assume that your testimony is in complete accord with that of Mr. Haldeman?
Well, Senator, I don't like to make rulings on questions, but I don't see how the witness can possibly answer that until Mr. Haldeman testifies.
But unless he has talked to Mr. Haldeman, Mr. Chairman.
Oh, yes, you can ask the witness, be quite competent to ask the witness. He and Mr. Haldeman have gotten together and compared notes and agreed to testify in like manner, or whether they got there, the witness consulted Mr. Haldeman for the purposes of refreshing his recollection about matters. You can go into that whole area. But I just think you can't, till Mr. Haldeman testifies, I don't believe the witness could say whether his testimony conflicts with Mr. Haldeman's testimony, which has not yet been given, but you can certainly ask them whether or not they got together and
I am satisfied
and agreed on what testimony they're going to give.
I'll be glad to ask that, although I must confess that I am completely satisfied with the statement made by counsel that there is no conflict between the testimony of Mr. Haldeman and Mr. Ehrlichman.
I say that without qualification, on the basis of more years of practice of law than any one of you sitting on that committee, including the chairman.
That there is no conflict between the testimony of Mr. Haldeman and Mr. Ehrlichman.
Well, I think you're operating here on really two levels of inquiry.
Prophetic power, and I'll have to admit, I think we lawyers do sometimes acquire some little prophetic power as to what our clients are going to testify.
Well, because we know what the two are going to testify to, and we're not aware of any material conflict. I mean, there may be a little variance in an incident, just like two people seeing an accident on the street, but there is no material conflict. In my knowledge, I give you my professional assurance of that.
That answers my question.
Thank you.
Mr. Thompson.
I don't think there's any way that I can pursue a couple of lines of questions I had in mind and still get on with the business at hand as we all want to. So I'll forego any questions of Mr. Ehrlichman at this time. I would like to say this, and I don't know whether it's appropriate, but I feel compelled to say this. That I'm a lawyer and I'm used to courtroom procedure, and this witness has been the subject of moans and groans from the audience, hisses, applause, sustained applause on some occasions and other demonstrations. And as far as I know, he's the only witness that's been subjected to all of these things. I think it's unfair to the witness. I don't think it does the work of this committee any good. It's not that you, Mr. Ehrlichman, are to be treated any better than any other witness, but you shouldn't be treated any worse.
doesn't go to the weight of your testimony or its credibility or whether we believe it or not, but I think this goes to a matter of common decency and courtesy, which all witnesses are entitled to. I think that situation has been rectified now, at least I hope it is, and I just wanted to state that I, for the last few days of testimony, have regretted this situation and find it personally embarrassing. Thank you.
Are there other questions of this witness?
Mr. Vice Chairman, I think under the rules I'm entitled to make a brief closing statement, and I'd like to avail myself of that privilege if
You
I
are
might
indeed,
at this
and you
time.
may proceed, Mr.
Thank you. Mr. Vice Chairman and members of the committee, I prepared for this hearing with just two objectives. First, to state the truth as nearly as recollection and research could enable me to do, and thereby to establish the falsity of the charges made against me by your star witness. For nearly 5 days, I've submitted to your cross-examination to permit a test of the truth of my testimony. In my opening statement, I listed a number of questions which I asked you to inquire about because I believe they are central to this matter and because I have some information about them. In the past 5 days, a great deal of time has been spent mostly on a few of them. As a result, there is now remaining one matter which I believe is important enough to mention in passing to the committee. I did not have an opportunity to review with the committee my notes of my second interview with Gordon Strachan. I think it is important to the committee to know that as you read those notes, the question which I continually put to Mr. Strachan all the way through was, is there anything else? Are you giving me the whole list? Are these all the people in the White House who are involved? And have you told me everything you know about their involvement? In other words, the list you see in the Strachan notes is intended, as I recall the interview with Mr. Strachan, to be an exclusive list. And that does not appear on the face of the notes, and I think it's important for you to have that. My secondary objective here was to be prepared to raise a voice for the President, who is unrepresented here. As your questions developed, I had no opportunity to do so as his advocate. I only shed some light on facts which disproved a few of the false allegations which have been advanced against him here. I do not apologize for my loyalty to the President, any more than I apologize for my love of this country. I only hope that my testimony here has somehow served them both. I could not close without commenting on Gordon Strachan's answer of the other day to the question, do you have any advice for the young Americans who are expressing their disenchantment with government and the political process? Gordon said, stay away, and your gallery laughed. But I don't think many other Americans laughed at that answer. I certainly didn't, nor do I agree with Gordon's advice. Our political system and our real governmental institutions are not just the buildings and the laws and the traditions that one sees here in the city of Washington. Our government and our politics are only as idealistic, as honest as the people in those buildings who administer the laws and run the campaigns and fulfill the traditions. If some young Americans know that their ideals or ideas or motives are sounder or purer than those of the people now in politics or government, then I think Gordon should have said to them, come and do better. Don't stay away. Somehow in politics and government, it seems that there's always someone to fill the job. If you don't take it, you can be sure that somebody else will. We are either going to have highly motivated, able people running the political campaigns and filling the offices in government, or we will surely have seat warmers and hacks who will fill these places, and the country will be the worse for it. People must be attracted who will come here to fight for what they believe in and to work long hours to get things done. I hope good young people don't stay away. I hope they come here and apply their idealism and their enthusiasm and their high moral principles. I hope they come and test their ideas and their convictions in this marketplace. I hope they do come and do better. But young Americans, if you come here, come with your eyes wide open. If you go to work for the President in the executive branch, there are very few in the Congress or the media that are going to throw rosebuds at you. If you favor change in what our government is and what it does in our society, you'll have to fight for it. No such change has been won here by default, at least not recently. And be prepared to defend your sense of values when you come here, too. You'll encounter a local culture which scoffs at patriotism and family life and morality just as it adulates the opposite. And you'll find some people who've fallen for that line. But you'll also find in politics and government many great people who know that a pearl of great price is not had for the asking, and who feel that this country and its heritage are worth the work, the abuse, the struggle, and the sacrifices. Don't stay away. Come and join them and do it better. Mr. Vice Chairman, this Select Committee has an awesome responsibility to find the truth. Such a search cannot be made by one whose eyes are clouded with preconception or partisanship. It can only be found by those with open minds, free of bias and unfairness. I am confident that the truth is there to be seen. It only needs the seers. Thank you, Mr. Vice Chairman.
Mr. Ehrlichman, thank you very much. As with other witnesses, I express the gratitude of the committee for your appearance and testimony. I'm sure that you understand, as other witnesses do, the functions of this committee are manifold, but that one of the functions of this committee is to develop what I've referred to as a definitive statement on Watergate and the other matters that were mandated to us by the Senate to inquire into. We will take your testimony, we will weigh it against the testimony given us by other witnesses, against circumstance, against documentation, and against whatever relevant information we can find in order to arrive at the truth. As I've also indicated, as the Chairman has indicated from time to time, we are not here with defendants. We are going to find no one guilty or innocent of specified crimes, but we are going to try to find what happened, when, and who knew about it. You've given us a great volume of information, and we thank you for it. If I may take the brief privilege of adding an addendum to your advice to young people. I, too, was concerned about Mr. Strom's advice. I feel, for instance, that I feel very certain that one of the gravest consequences of Watergate, so-called, or of these hearings, would be that young people drop out, or that the citizens of America are disillusioned and drop out of the political system. I very much hope they drop in, and that at the next and succeeding elections we have more people participating in the elective process than we've ever had before. Because truly and surely the system of government of the United States is examining itself, and that's a proof of its strength and not of its weakness. Are there other questions of this witness? Thank you very much. Would counsel call the next witness, please?
Mr. Haldeman, and we understand, Mr. Chairman, that the statement is just coming up now. It was given to us yesterday evening, and we were just able to start reproducing it. And we have part of it on its way. And
would you prefer to have a recess?
Perhaps, Mr. Chairman, if you could call a short recess, we'll have the statement.
In the light of that situation, and in light of the fact that the chairman has not yet returned from the last roll call vote, the committee will stand in brief recess, subject to the call of the chair.
While the committee shifts its focus from the President's number 2 aide to his number 1 man, we're going to take a short pause. Public television's coverage of the Senate Watergate hearings will continue after this break for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As President Nixon's former chief of staff takes the witness stand, he is about to read his version of Watergate events.
You swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Suppose you give us your address for the record, your full name and your address for the record.
My name is Harry Robbins Haldeman. My current address is 24 Harbor Island, Newport Beach, California.
Mr. Wilson, suppose you state your name and address again for the record.
I thought it was no secret that Mr. Strickler and I are representing Mr. Haldeman too. The address of both of us, we're partners, is 815 15th Street Northwest, Washington, D.C.
As I understand it, Mr. Haldeman, you have a prepared statement which you would like to read before any interrogations are made. Is that right?
I do, Mr. Chairman.
You may proceed.
Mr. Chairman, may I say
Yes,
what I said in respect to Mr. Ehrlichman? Let the record show that he is here pursuant to a subpoena.
That is true. He is here under a compulsory subpoena process issued by the committee.
Thank you, sir. Mr. Chairman and members of the Senate Select Committee, as you know, I met voluntarily with the Senate committee staff on 2 occasions for lengthy interviews to answer any questions they might want to ask of me, and I requested nearly 3 months ago an early opportunity to appear before this committee. I have also appeared before and cooperated as fully as I could with another committee of the Senate, a committee of the House of Representatives, the United States attorneys, the grand jury, and the attorneys taking depositions for the Democratic National Committee in their civil suit, all in regard to the matters before this committee. In all of these appearances, I have never taken the Fifth Amendment, and I have never sought immunity or any other kind of deal. During the 3 months since I resigned from the White House staff, I have scrupulously avoided discussing any substantive aspects of the Watergate case or related matters in the press, despite enormous pressure. I have carefully avoided leaking any information, expressing any opinion or conclusion, answering any charges, or commenting on any testimony by others. As I have stated countless times to reporters and to the TV cameras, I will cooperate fully with the appropriate judicial and legislative bodies involved in this case. I feel they are the proper and appropriate forums in which to present complete explanation and answer fully all questions. On each of these occasions with the press, I have further stated to the press that I have full confidence that when the entire truth is known, it will be clear to the American people that President Nixon had no knowledge of or involvement in either the Watergate affair itself or the subsequent efforts of a cover-up of the Watergate. It will be equally clear, despite all the unfounded allegations to the contrary, that I had no such knowledge or involvement. I had the rare privilege for 4 years of serving on the White House staff under one of America's greatest presidents, and with the most outstanding, dedicated, and able group of people with whom I have ever worked. Those who served with me at the White House had complete dedication to the service of this country. They had great pride in the president they served and great pride in the accomplishments of the Nixon administration in its first 4 years. I can't imagine anything more satisfying than to have had the opportunity to play a part in the first Nixon administration, which brought about the end of America's longest and most difficult war, the end of the Cold War, which had been a fact of life for as long as many of us can remember, the opening of communication and dialogue with the leaders of the Soviet Union and the leaders of the People's Republic of China, the building of a structure that can well lead not to just one but many generations of peace, the start of the return of the power of government to the people by revenue sharing and federal reorganization, the whole new approach to domestic programs designed to bring those programs into line with the real needs and desires of the people. We all felt and still feel that the first 4 years was a time of laying the groundwork for even greater accomplishments in the second term, and we have complete faith that that promise will be met. One of the great tragedies of our time is that, for the moment at least, a cloud hangs over the accomplishments of the past 4 years and the promise of the next 4 years because of Watergate, its aftermath, and related matters. This has spawned an unceasing barrage of charges and countercharges, allegations, innuendo, hearsay, rumor, speculation, and hypothesis, which I devoutly hope these hearings and the concurrent work of the Justice Department and the Special Prosecutor will bring to an early and definite conclusion, so that the nation and its leadership can again turn their thoughts and their efforts to more productive enterprises. During this period, with its intense concentration on every aspect of Watergate and everything related to it, the sense of proportion regarding the time period under study becomes grossly distorted. In looking at the year 1972, it is important, especially now during these hearings, to try to keep a sense of perspective as to where things fit. The harmless eye of a fly viewed under a microscope can become a terrifying object in spite of its actual insignificance. Likewise, Watergate, viewed under the microscope of this hearing and the intensive coverage of all of its aspects, can become a terrifying sight if one loses track of the perspective in which it should be viewed. This is in no way an attempt to minimize the importance of the problems posed by Watergate or the necessity to get to the truth and to take the necessary actions to deal with the facts and prevent a recurrence. During the transition period in 1968, I had the opportunity to meet with and receive some very valuable advice regarding the office of the presidency from a man of great experience on that subject, President Dwight Eisenhower. He made the point to me very strongly that the greatest responsibility I would have over the next 4 years would be to make sure that President Nixon had the time and the opportunity to concentrate on the few overridingly important matters that would come to his attention during that time, and that he be spared the interruptions and temptations to divert himself to day-to-day trivia that would get in the way of the really major accomplishments. President Johnson gave me exactly the same advice. President Nixon was also a man with strong views on the office of the presidency, having observed the conduct of that office for 8 years from one step away as Vice President of the United States. Our concern was to try to set up the staff and the operation of the White House office so that President Nixon would have the opportunity to achieve the goals that he had set for himself, to concentrate on the painstaking, step-by-step actions that were required in order to achieve those goals, and to avoid being diverted by matters which could be handled as well or better by others. The staff system for the White House was set up with this objective in mind and was developed with the President's full concurrence. The decision facing the President was whether to watch all the details, see whomever wanted to see him, read everything that was sent to him, or to delegate that authority, and by the exercise of major self-discipline, spend his time on the largest issues that confronted the people he was elected to represent. The easy decision would have been to follow the first course, because that course would have made him popular and accessible and show what has been called charisma or the nice guy. President Nixon elected to follow the second course. Some have called it isolation, but he viewed it as doing what he was elected to do. He had pledged to the American people that he would search for a generation of peace, which, despite the efforts of many people, is a goal that had never been accomplished within this century. President Nixon took that pledge seriously, and he has come a long ways towards achieving it. If his time during the first term had been obscured by partisan political matters, or by visiting with all of the people who wished to see him, or by reading the entire content of all of the multitude of memos written to him, there would have been no beginning of a road to a generation of peace, because the one irreplaceable thing that the President had available to him, his own time, would have been taken from him. This in no way implies that President Nixon spent 100% of his time on matters relating to international affairs. He carefully planned and divided his time so as to cover all of those matters that required his attention. But he carried out an extensive delegation of authority to other members of his administration and his staff to see that all matters were handled properly and thoroughly, but only those which the President himself had to deal with actually came to the President. President Nixon also was very much concerned that he receive a wide range of views, opinions, and information as to what was being reported in the press and the news media. Consequently, he did not limit himself to reading one or two newspapers, but directed that a comprehensive summary of all news media be prepared for him on a daily basis. He read this carefully each day, in addition to reading a number of newspapers. He insisted that when a matter was brought to him for decision, the full range of options and the full range of viewpoints regarding those options be presented to him, rather than just the arguments of the exponents of one particular side. He saw the staff's responsibility as being that of ensuring that this was always the case. In the selection of his personal White House staff, the President emphasized the qualities of integrity, intelligence, and initiative. He urged that we bring in young people, men and women with the great energy and enthusiasm of youth, to provide those qualities along with the wisdom and experience of the more senior members of his administration. As the first term progressed, many changes were made in the staff structure and in the staff system, constantly adapting to the ongoing needs of the office of the President. The atmosphere at the White House was one of great enthusiasm, great dedication, great cooperation, and great satisfaction as progress was made toward many of the President's goals. At the same time, there were, of course, many disappointments and many frustrations, as the progress wasn't as fast as all of us would have liked in all directions. But a review at the end of the first term provides the basis for the conclusion that the whole thing worked very well. As we started the year 1972, the year in which the President would be up for re-election, we also approached the critical time of culmination, or at least of major steps towards the accomplishment of several of the President's major goals: the end of the war in Vietnam, the opening of relations with the People's Republic of China, the achievement of agreements to limit nuclear arms, and the other agreements with the Soviet Union. President Nixon's concentration was, of course, on these extremely important matters. He started the year concentrating on the planning for the trip to the People's Republic of China, which took place in the latter part of February, and which, because of the enormous amount of painstaking planning ahead of time, was a tremendously successful trip. Following that trip, there were several months of intense concentration on steps to try to bring the war in Vietnam to a conclusion and to plan for the negotiations with the leaders of the Soviet Union. The months of March and April were almost totally dedicated to those two efforts, with a number of other activities intervening, such as a trip to Canada to meet with the leaders of that government. On May 8th, the President announced one of the most difficult decisions he had had to make: the decision to mine the harbors and to bomb targets in North Vietnam. And that announcement preceded by less than 2 weeks the departure for the meetings with the leaders of the Soviet Union in Moscow. Most of the month of June was occupied in activities following up on the Soviet trip, and then the President spent a good part of July at the Western White House in San Clemente, where he had the opportunity for long and detailed meetings with Henry Kissinger on foreign policy and on the negotiations to attempt to end the Vietnam War, and with John Ehrlichman on initiatives in the area of domestic policy. The first part of August was spent mostly at Camp David, preparing for the acceptance speech the President was to give at the Republican Convention later that month, and on developing plans and positions for the campaign that would follow. Immediately after the convention, the President went to the Western White House in San Clemente to prepare for his trip to Hawaii to meet with the leaders of the Japanese government. He returned to Washington right after Labor Day and concentrated during September on the ongoing business of the government, with a few brief trips to various parts of the country for campaign appearances. As the Vietnam negotiations intensified in October, they required a great amount of the President's time and attention, although he had many appointments and meetings on domestic matters in that month also, and made 2 or 3 trips for campaign appearances. Much to the consternation of the opposition and the press, he did not drop the business of government and turn to the political campaign, but rather made the decision that he would concentrate his attention on the conduct of the office of the presidency, with confidence that the voters would make their decision on the basis of his conduct of that office. November, December, and January were probably the 3 most demanding months of the entire time that I served in the White House. The Vietnam negotiations were up and down, on and off, and the need for daily concentration on developments in that area was intense. In addition, this was the period in which the President and a number of the key staff people were engaged in a total reorganization of the structure of the office of the President and of the executive branch of the government, as well as a complete review of the staffing of the entire executive branch. There was, of course, also the need to prepare for the activities of the inaugural and for the President's inaugural address on January 20th. After the Vietnam ceasefire in late January, there was still a need for considerable attention to that area. And the work of restructuring and restaffing the executive branch of the government, as well as developing new program approaches in the domestic area, continued at an intensive pace. It was not until late February that President Nixon devoted any substantial amount of attention to the Watergate case and matters related to it. In the last few days of February, he started a series of meetings with his counsel, John Dean, originally concentrating primarily on the problems of separation of powers and executive privilege that were raised by the creation of the Senate Select Committee, and a few weeks later by the request of the Judiciary Committee that John Dean testify in connection with their hearings on the nomination of Mr. Gray to be Director of the FBI. From mid-March through the month of April, the President spent a considerable amount of time and attention on Watergate, in spite of the fact that he was also dealing with the restructuring of his branch of government, with serious matters in the domestic economy, and meeting with a number of foreign leaders, including President Thieu of South Vietnam and Prime Minister Andrade of Italy. I've reviewed this picture, Mr. Chairman, as a means of pointing out to this committee and to the American people the fact that the specifics of Watergate and the activities of the investigation following Watergate were not a principal focus of interest in the White House or by the President during the period from June of 1972 up to March of 1973. My own notes on meetings with the President during that period indicate very few and very brief references to Watergate. It was not only not the principal matter occupying the attention of the President and his senior staff, but it was a matter which rose only occasionally and only briefly. In my role as the President's Chief of Staff, I concentrated my attention and activities each day on those matters on which the President was concentrating his attention and activity. I did not maintain an independent schedule of appointments or activities of my own. I traveled with the President when he was out of Washington, and I concentrated on those matters that were of concern to the President at any given period of time. The fact is that the Watergate case was not a matter of concentration on the part of the President at any time until March of 1973, and therefore was not a matter of concentration on my part either. And the atmosphere at the White House through this period was, as it had been for the entire first term, not one of fear or repression, but one of excitement, extremely hard work, dedication, and accomplishment. At the outset of the Nixon administration in 1969, it was our general intention to have a group of assistants to the President who would all function as generalists with no specific areas of responsibility, each available to move into whatever area had a need at any given point in time. Inevitably, however, the requirements of the office caused a more specific delineation of areas of responsibility. My role as White House Chief of Staff was administrative rather than policy-making. I worked directly with the President in the planning and execution of his daily schedule, in providing for him the information he wanted from the members of his staff and the rest of the administration, and in disseminating from him to those people his instructions and opinions. Henry Kissinger served as assistant to the President for national security affairs and was responsible for the development and implementation of White House policy in the area of foreign policy, national defense, and national security. John Ehrlichman, as assistant to the President for domestic affairs, had similar responsibilities in the development and implementation of domestic policy. At various times during the first term, there were other principal assistants to the President for specific responsibilities. There was a very substantial difference between the roles of Dr. Kissinger in the formulation and implementation of foreign policy and Mr. Ehrlichman in the formulation and execution of domestic policy versus my role in the administration and operation of the White House staff and the President's personal activities. They were each department heads with areas of policy responsibility They worked directly and frequently with the appropriate cabinet officers and agency heads. They worked directly and frequently with the President. By delegation from the President, under clear guidelines, they acted for the President in the process of developing policy and carrying it out. On the other hand, I worked only very rarely with anyone outside the White House staff. I spent a great deal of time with the President, and the rest of the time preparing for meetings with the President, transmitting his instructions and guidance to others for implementation, and, when necessary, following up on performance. My working day was totally unstructured. I had no independent schedule. I was at the call of the President at all times. I was born, raised, and spent most of my life in Los Angeles, California. After serving 2 years on active duty in the Navy V-12 program, I completed my college education at UCLA and then joined the J. Walter Thompson Company advertising agency. I was with J. Walter Thompson for 20 years in their Los Angeles, San Francisco, and New York offices, and in 1961 became a vice president of the company and manager of the Los Angeles office. In addition to my business career and my participation in politics and government service, I spent a great deal of time and worked with a number of educational and community organizations in California. Included among these activities was service as chairman of the Board of Trustees of the California Institute of the Arts, member of the Board of Regents of the University of California, member of the California Coordinating Council for Higher Education, vice president of Junior Achievement, trustee of the Coro Foundation, member of the Board of Directors of the Better Business Bureau, and president of the UCLA Alumni Association. Even after joining the federal government, I had the opportunity to serve as a trustee and member of the executive committee of the Kennedy Center for the Performing Arts and as vice president of the Ford's Theater Society. My association with Richard Nixon began in 1956 when I took a 3-month leave of absence to be an advance man in his campaign for re-election as Vice President of the United States. I performed a similar function in 1958 when Vice President Nixon traveled the country on behalf of candidates for the House and Senate. In 1960, I took a year's leave of absence to serve as Chief Advance Man and Campaign Tour Manager in Vice President Nixon's presidential campaign. In 1962, I again took a year's leave of absence, this time to manage Mr. Nixon's campaign for Governor of California. In 1968, I was Chief of Staff for Mr. Nixon in his campaign for the presidency, and then joined the White House staff as Assistant to the President. These opportunities for community service and political participation have been very gratifying to me. The high point of my life, of course, has been the opportunity to serve for 4 years as Assistant to President Nixon and to have had a part in the truly outstanding accomplishments of his first term. Mr. Chairman, my statement and testimony before this committee will be based on my best recollection after a careful review of logs, notes, etc., to try to reconstruct the facts as best I can. I'm severely limited in this effort because, despite the intense focus of attention today on each minute event of last year, at the time they happened, most of these things were not of great importance and were not recorded in any detail, if at all. This is especially true for the period prior to March 1973. From that time on, my presidential notes regarding the Watergate case are much more voluminous because the President was then directing a great deal of his attention to the Watergate matter, whereas he had not done so earlier. I have had access, under the supervision of a Secret Service agent, to my handwritten notes regarding conversations with the President, which are in the President's files. I have not been permitted to make copies of them or to take notes from them. I have been under exactly the same restrictions as Gordon Strachan described. My files are in the same room as his. I kept no records of my own. All my records are in the President's file. I might mention that my handwritten notes on sheets of yellow paper from June 1972 through February 1973 make a stack about 8 inches high. All of the pages in that stack on which there is any reference or any note regarding Watergate during that period add up to less than 1/8 of an inch. In other words, my Watergate notes amount to no more than 1% of my total notes during that period. Until March, I made very few notes regarding conversations with John Dean, because these conversations were not reported to the President except in a general summary form. They consisted of details regarding his investigation, which were of no concern to the President, except, of course, the assurance always that no one in the White House was involved. Through the period of March and April of 1973, I have quite detailed notes regarding Dean conversations, because at that time he was giving me information for the President. Turning to the question of security problems. It's been alleged that there was an atmosphere of fear at the White House regarding security matters. I can state categorically that there was no climate of fear at all. There was, however, a healthy and valid concern for a number of matters in the general area of national security and for a number of other matters in the general area of domestic security. This was a rational concern, and it was of sufficient import to require that considerable thought be given to steps to combat the actual problems and potential dangers that existed. With regard to leaks of information, especially in the national security area, it became evident in 1969 that leaks of secret information were taking place that seriously jeopardized a number of highly sensitive foreign policy initiatives that had been undertaken by the administration, including the ending of the war in Vietnam, the Middle East crisis, nuclear arms limitation, and the establishment of new relationships among the great powers. These initiatives were closely interrelated. Leaks about any one of them could seriously endanger all of them, and such leaks were taking place. In order to deal with these leaks, a program of wiretaps was instituted in 1969 and continued into early 1971. The President has stated that each of these taps was undertaken in accordance with procedures that were legal at the time and in accord with long-standing practice in this area. This program was authorized by the President of the United States, and the wiretaps were determined by coordination between the Director of the FBI, the President's Assistant for National Security Affairs, and the Attorney General of the United States. In 1970, the domestic security problem reached critical proportions as a wave of bombings and explosions, rioting and violence, demonstrations, arson, gun battles, and other disruptive activities took place across the country, on college campuses primarily, but also in other areas. In order to deal with this problem, the President set up an interagency committee consisting of the directors of the FBI, the CIA, the Defense Intelligence Agency, and the National Security Agency. This committee was instructed to prepare recommendations for the President, which they did. The report they submitted included specific options for expanded intelligence operations, and Mr. Houston, the White House staff man for this project, was notified by a memorandum from me of the approval of the President. As has been reported, Director Hoover expressed opposition to parts of this program, and as a result, the agencies were subsequently notified that the approval had been rescinded. This approval was withdrawn before the plan was implemented, so the net result was that it never went into effect. Instead of this program, an Intelligence Evaluation Committee was created in December of 1970 that included representatives of the White House, CIA, FBI, NSA, the National Security Agency, and the Departments of Justice, Treasury, and Defense, and the Secret Service. The mission of this committee was to improve coordination among the intelligence community and to prepare evaluations and estimates of domestic intelligence. In mid-1971, the New York Times started publication of the so-called Pentagon Papers, which had been stolen from the sensitive files of the Department of State and Defense and the CIA, and which covered military and diplomatic moves in a war that was still going on. The implications of this security leak were enormous, and it posed a threat so grave as to require, in the judgment of the President and his senior advisors, extraordinary action. As a result, the President approved creation of the Special Investigations Unit within the White House, which later became known as the Plumbers. John Ehrlichman was responsible for supervision of this group. Mr. Krogh and Mr. Young of the Domestic Council and National Security Council staffs were the two principal staff members. While I was aware of the existence and general purpose of this unit, I was not familiar with any of its specific activities or assignments. Also, in mid-1971, to deal with the general problem of leaks throughout government departments and agencies, the President directed me to set up a program of spotting these leaks and reporting them to the department head involved. He announced this in a cabinet meeting, unfortunately dubbed me with the dubious honor of Lord High Executioner. That was his phrase, not mine. The purpose of this program was to make department heads throughout the government conscious of the leak problem and aware of their responsibility to deal with it in their departments. This involved no investigations on the part of the White House. Turning to 1968 surplus campaign funds. During the interim period between the 1968 elections and the start of the 1972 campaign, Herbert Kalmbach was custodian of a large cash fund, which I understand was a surplus from the 1968 primary elections. In addition, he undertook to raise funds from supporters of the President to aid congressional and senatorial candidates in the 1970 elections. Also, in 1971, Mr. Kalmbach raised a substantial fund as the startup for the 1972 campaign. I am not familiar with all the specifics of sources, amounts, or disbursements of these funds, although Mr. Kalmbach did keep me periodically posted on his activities in this area. As he has indicated, he looked to me, as well as to other people from time to time, for direction or approval as to the disbursement of the 1968 surplus funds. I requested or approved use of these funds for such purposes as the continuing polling that we did during that period, for campaign support to a candidate for governor in Alabama, and for funding Donald Segretti. It is my understanding that these funds were also used for other purposes, such as the funding of Mr. Ulasewicz's operations, with which I was not familiar. The Alabama campaign funds were in support of the candidate for the Democratic nomination for governor, who was opposing former Governor George Wallace. It was the belief of some of the President's friends and advisors on the Southern political scene that Mr. Wallace might very well become a third-party candidate in 1972 and thus raise again the potential problem of an indecisive election that might be turned to the House of Representatives. They felt that the best way to avoid this eventuality was to defeat Governor Wallace in his bid for the gubernatorial nomination in Alabama. This was the reason for providing campaign financial support to his opponent. Turning to the Segretti matter. Early in the pre-campaign period, I agreed with an idea that was suggested to set up a man functioning independently of the White House, the Committee to Re-elect, and the National Committee, for the purpose of generating for our side the same kind of campaign activities that were so ably carried out over the years for Democratic candidates and in 1972 for Senator McGovern by Dick Tuck, a man who has been widely praised by political writers as a political prankster whose basic stock in trade is embarrassing Republican candidates by activities that have been regarded as clever and acceptable parts of our political tradition. The repertoire of the political prankster includes such activities as printing up embarrassing signs for the opponent, posing in trainman's clothes and waving the campaign train out of the station, placing an agent on the opponent's campaign train to produce witty newsletters mocking the candidate, distributing opposition signs at rallies for use by members of the crowd, encouraging band leaders to play rival songs at rallies, and so forth. The activities we had in mind and for which we drew careful boundaries specifically excluded anything remotely connected with the Watergate type of activity. Moreover, the pranksterism that was envisioned would have specifically excluded such acts as the following: violent demonstrations and disruption, heckling or shouting down speakers, burning or bombing campaign headquarters, physical damage or trashing of headquarters and other buildings, harassment of candidates' wives and families by obscenities, disruption of the National Convention by splattering dinner guests with eggs and tomatoes, indecent exposure, rock throwing, assaults on delegates, slashing bus tires, smashing windows, setting trash fires under the gas tank of a bus, knocking policemen from their motorcycles. I know that this committee and most Americans would agree that such activities cannot be tolerated in a political campaign. But, unfortunately, the activities I have described are all activities which took place in 1972 against the campaign of the President of the United States by his opponents. Some of them took place with the clear knowledge and consent of agents of the opposing candidate in the last election. Others were acts of people who were clearly unsympathetic to the President, but may not have had direct orders from the opposing camp. So far, there has been no investigation of these activities and very little publicizing of them, either those which were directly attributable to our opponent or those which certainly served our opponent's interest but did not have his sanction. There is no question that the 1972 campaign was not a classic in decorum for either side. In any event, having agreed to the suggestion of a Dick Tuck for our side, I was told by Dwight Chapin and Gordon Strawn that they had a former college friend they felt would be a good man for this project. They may have told me his name was Don Segretti, but it would have meant nothing to me. I have never met or had any personal communication with Mr. Segretti. I agreed that if this man wanted to take on this activity, Herbert Kalmbach should arrange for his compensation and expenses from the 1968 campaign fund surplus. It was my clear understanding that Segretti would act independently and on his own initiative within the broad guidelines outlined above. It was also my clear understanding that he was to engage in no illegal acts. Mr. Strawn has told me that he was so advised and that he understood that. I had no specific knowledge of Segretti's activities or the details of how or with whom he worked. I do not believe that there was anything wrong with the Segretti activity as it was conceived. I have only limited knowledge, and that acquired only lately, as to how it was actually carried out. If, as alleged, he or those under his direction were responsible for the letter which falsely defamed Senators Muskie and Humphrey, then, on behalf of everyone associated with the Nixon campaign, I would like to and do apologize to both of those men. That act was clearly outside the bounds within which he was to work. The President and all of us at the White House were determined that the campaign organization and operation should be set up outside of and independent of the White House. And this was the reason for the development of the Committee to Re-elect the President. The committee operated autonomously under the direction of John Mitchell and later Clark McGregor, but of course with close liaison and communication with the White House at many levels. The President looked to me as his basic contact with the campaign organization, and I maintained communication with John Mitchell in this regard until July 1972, and then with Clark McGregor. I did not function as the White House liaison with the Committee to Re-elect the President. This function was handled by various people at various levels with regard to specific areas or projects. For example, John Dean on legal matters, John Ehrlichman and his staff on substantive domestic policy, Chuck Colson on group support, and so on. I had no official relationship with or position on the Committee to Re-elect the President or the Finance Committee. Gordon Strawn on my staff handled the day-to-day liaison with the committee for me, and virtually all my contact with the committee, except for that with Mitchell or McGregor, was through Strawn. He received copies of committee materials and memoranda, sat in on many of their meetings, and stayed in touch with key people. I met with Strawn only about once every week or two during the campaign. Strawn periodically sent me general information on campaign planning, organization, and activities. He sent me, from time to time, the overall budget and various campaign materials. This was primarily for information purposes and usually took the form of a summary memorandum backed up by a huge amount of supporting material which I rarely read. In the specific case of advertising and promotional materials, the standard procedure required a final sign-off by me before the ads or materials were considered approved. Thus, in this particular area, I did, in effect, exercise approval authority. But even here, I did not have control over either the personnel or the policies involved in developing the material. I only had a final sign-off on the end product. Strawn also routed these materials to others in the White House who were concerned with them. I also had a particular interest in polls and in scheduling, and paid more detailed attention to these areas. I think it was very clear to all concerned that the committee was running the campaign, not the White House. I don't believe I had control over any funds at the committee, nor did I exercise any authority or direction as to the utilization of funds, except in a general sense. I never signed a campaign check. I was, to some degree, involved in the decision process regarding funds to be used for advertising and polling. The committee also allocated funds to pay for expenses incurred by the President or the White House that were clearly campaign expenses as contrasted to government expenses. This would include such things as cost of campaign travel, advance men, and so on. Some indication of my role in the campaign may be found in the fact that I visited the committee headquarters only once during the entire campaign period, and that was on the occasion of the President's visit to see the headquarters and meet the campaign workers. Also, I had very few meetings with any members of the staff of the committee to re-elect the President, except those with John Mitchell, which were on a frequency of about once a week during the time he was campaign director. In addition to that, I did sit in the semi-weekly campaign review meetings held in John Ehrlichman's office, and of course, as has been indicated, Mr. Mitchell and Mr. McGregor sat in the regular morning White House staff meetings, so that there could be full coordination between the White House and the committee on overall strategy. My contact with the campaign, in other words, was through fairly infrequent meetings with Mr. Mitchell and fairly infrequent meetings with Gordon Strawn of my staff, but I kept in general touch with campaign activities through Strawn's summary memoranda and the meetings described above. Turning to the $350,000. Prior to the April 7th date on which the new campaign spending legislation took effect, it was agreed by Mitchell, Stans, I believe Mr. Kalmbach, and me that $350,000 of the 1968 surplus cash funds should be set aside to cover possible needs for special private polling by the White House, apart from the regular polls conducted by the committee. This was in anticipation of a possibly hard-fought, close election. I understand from Gordon Strawn that he received the cash from Hugh Sloan on April 6th. He, in turn, arranged to have this cash held in a safe deposit box or safe by another individual outside the government. It is my understanding from Strawn that this transfer was made immediately and that the entire $350,000 was placed in safekeeping outside the White House. I did not feel we should keep such a large amount of cash at the White House, nor did I feel it was a good idea for it to be in the physical custody of a member of the White House staff, which is why these arrangements were made. I never at any time saw or handled the currency, and I must rely on Strawn's reports to me as to how it was handled. I've been informed by Strawn that there was one withdrawal in April or May of 1972 of $22,000 to pay for some advertising that was not directly related to the election campaign. This was at the request of Dick Howard of Chuck Colson's office. I think Strawn said the money was delivered directly to the advertising agency. The balance of $328,000 was not used. I instructed Strawn, after the election in November, to turn over the unused funds to the committee, since the White House had no further need for them. I told him to work out with Dean the means of doing this. Strawn has informed me that the funds were turned over in January 1973, although he incurred some difficulty in doing so after he took possession of the funds on November 28, 1972. In December, I became aware, probably via Dean, that there was some difficulty in turning over the cash to the committee, presumably because it posed reporting problems. At a later time, Dean mentioned to me the committee's need for funds for legal and family support for the Watergate defendants. I suggested to Dean that he try to work out a way of solving both the problems of our desire to deliver the funds to the committee and the committee's need for funds. Dean later told me that he had worked this out and that part of the cash, I believe $40,000, could be delivered immediately to the committee via Fred LaRue. He had Strawn do this, I'm told, and several days thereafter, Dean had Strawn deliver the balance to LaRue. To sum up, after my original instruction to Strawn to transfer the money to the committee, my involvement in the transfer of the funds was entirely through Dean. He told me of the problem in transferring the $350,000 to the committee. He told me he had worked out the problem. He told Strawn how, when, and to whom to make the transfer. He told me the transfer had been made. He did not, at any time in this sequence, advise me or imply that the transfer itself or the purpose of the transfer was to buy the Watergate defendants' silence or that it was in any way illegal or improper. It is my understanding that all this took place in the period of November to January, but I'm not sure of the timing. I have no recollection of any knowledge of the reported transaction on November 28th when Dean had Fred Fielding of his office pick up $22,000 in cash from Mr. Stans, ostensibly for the purpose of replacing the $22,000 that had been expended from the $350,000 in April. I do recall that one of Dean's problems in the process of transferring the $350 to the committee was the fact that 22 had been dispersed. So it is quite possible that he did have it replenished prior to having the cash turned over to LaRue. But I don't believe that he ever reported this fact to me. In fact, Gordon Strawn's report to me in April of 1973 was that the $22,000 had not been replaced and that he had delivered only $328,000 to Mr. LaRue and not the full $350,000. However, Strawn also told me after his grand jury appearance that he had told them, the grand jury, that he had delivered $350,000. I said that was contrary to what he had told me, and he said he had made a mistake at the grand jury. I urged him to correct it if that was the case. He told me later he had called Mr. Silbert about the mistake and was told he could correct it before the grand jury. When he appeared at the courthouse to do so, the U.S. attorneys would not let him do it, and instead warned him he had committed perjury, was in serious trouble, should start preparations to go to jail, and should hire a lawyer. Turning to Watergate itself, I had no knowledge of or involvement in the planning or execution of the break-in or bugging of the Democratic National Committee headquarters. To the best of my knowledge, I did not see any material produced by the bugging of the Democratic headquarters. After the June 17th break-in, I asked Gordon Strawn whether he had had any knowledge of such an operation. He said he had not, but that he realized, in thinking back, that there had been 3 intelligence reports received by him, identified by the code-name Sedan Chair, that said something to the effect that confidential sources report. He said he did not, at that time, know the identity of the confidential sources. He realized, after the June 17th break-in, thinking back, that these reports could have been based on Watergate or some other wiretap source. I have absolutely no recollection of seeing any such report, and it is quite likely that I did not see it, even if it was included in a Strawn transmission to me, since I rarely, if ever, read through or even looked at all of the materials that he sent in to me in these reports. I do not recall ever seeing any material identified by the name Gemstone. I have no recollection of giving Mr. Strawn instructions to destroy any materials, nor do I recall a later report from Strawn that he had done so, or that the files were clean. Mr. Strawn has made clear in his testimony that he destroyed materials not because he thought the contents concerned criminal activity, but because he felt if they ever became public, they would be politically embarrassing. He confirmed in his testimony that he had reread the contents many times and that they did not suggest any illegality or criminal activity. They suggested matters which, if they became public, would be embarrassing. I should point out that on 2 occasions in April 1973, once to me before his grand jury appearance and the other to John Ehrlichman, Strawn listed the areas of what he considered to be tough questions or trouble spots. On neither of these occasions did he mention to either of us that he had been instructed to destroy any materials or make sure files were clean. I think the effort to bring in my April 4 meeting with John Mitchell as in some ways significant with regard to intelligence is a little far-fetched. By his testimony, Strawn doesn't know what was discussed at that meeting. All he says is that in routine fashion, he put an item on the talking paper regarding the adequacy of intelligence. As a matter of fact, the meeting with Mr. Mitchell that day was in connection with a meeting of Mitchell and me with the President. My notes taken at the meeting with the President indicate the discussion covered the ITT Kleindienst hearings and a review of Mitchell's plans for assigning regional campaign responsibilities to specific individuals. They indicate no discussion of intelligence. Turning to the Dean investigation. John Dean, in his Camp David report, which is now Exhibit 39 before this committee, says that when he arrived in Washington on Sunday afternoon, June 18, he realized that the President would have to know everything that he could find out. He realized at that point that he would be asked to assemble all of the facts so that the White House could be fully informed as to what had transpired and how it would affect the President. But having been on an airplane for approximately 25 hours, he did nothing further that evening. The next morning, after reading all of the news accounts of the Watergate incident, he spoke with John Ehrlichman, who instructed him to get the facts together and report to him. He then called the Attorney General to get what facts he knew. He called Gordon Liddy and met with him. Dean asked Liddy if anyone at the White House was involved, and he told him no. During the days and weeks that followed, Dean discussed the incident with everyone who he thought might have any knowledge or involvement. The source of these facts is John Dean's report, or the start of it, which he wrote at Camp David in March of this year. There is absolutely no question in my mind, or I'm sure in the minds of anyone at the White House or at the Justice Department, that John Dean was, in fact, conducting an investigation for the White House regarding the Watergate as it might involve the White House. It is inconceivable to me that there could be any doubt in Dean's mind. Dean moved in immediately after the incident as sort of the Watergate project officer in the White House. This was in keeping with our usual procedure. The responsibility was his, and he had the authority to proceed. Dean kept Ehrlichman and me posted from time to time on developments, and through us, the President. He apparently did not keep us fully posted, and it now appears he did not keep us accurately posted. The President, Ehrlichman, and I were very much involved in many other vital matters through this entire period, and we made no attempt to get into the details of or in any way take over the Watergate case. The view of all three of us through the whole period was that the truth must be told, and quickly, although we did not know what the truth was. Every time we pushed for action in this direction, we were told by Dean that it could not be done. His concern, as I understood it, was that the case was complex. It involved rights of defendants and other legal complexities, the facts were not clear, and that nothing should be done publicly. As long as we were confident that the facts he told us were correct, we had to agree with this, since there was no proof of any involvement of higher-ups at the committee, and any premature speculation regarding any such involvement would have been unfair and damaging, especially since the top officials at the committee had denied any involvement. Thus, as it now appears, we were badly misled by one or more of the principals, and even more so by our own men, for reasons which are still not completely clear. At no time did I give Dean any instructions to cover up anything in this case. I did, however, occasionally receive his verbal reports of the facts and his intended actions, and relayed these to the President. None of these reports concerned a cover-up. I had no personal motivation to cover up anything because I had no personal involvement, and I knew the President had no involvement. I understood and believed that no one else in the White House was involved in the Watergate planning and break-in, and I still understand and believe that. It was obvious that some people at the committee were involved, but I had no idea who or how far up, and I still don't, because I don't know now whom to believe. I may add that, until the recent period, both John Mitchell and Jeb Magruder denied any Watergate involvement. The President raised questions as to the facts of Watergate from time to time during the period of June through the election. His interest, consistently, was to get the facts and get them out. He had some concern, especially in the early stages, regarding the possibility of compromising national security, and an interest, therefore, in seeing that the investigation was thorough with regard to Watergate, but that it was limited to Watergate and not extended into earlier, unrelated national security activities of some of the people involved. Throughout this period, Dean assured us that there was absolutely no evidence that anyone in the White House had been involved in Watergate in any way. He was sitting in on FBI interviews, reviewing FBI reports. He was in constant communication with officials of the Justice Department and the Reelection Committee, and was clearly staying closely in touch with all facets of the investigation and related matters. On or about August 27th, the President instructed me to ask Mr. Ehrlichman to give to Pat Buchanan the information that Buchanan would need for preparing the President's briefing book for an upcoming press conference on any questions that might arise regarding Watergate. I passed this request on to Ehrlichman and assumed that he carried it out. On August 29th, the President had a press conference, at which he stated the Dean investigation indicated that no one in the White House or in the administration presently employed had been involved in Watergate. I was not at all surprised to hear the President say this at the press conference, since it was thoroughly consistent with everything that Dean had told me, and I therefore find it hard to understand why Mr. Dean now professes to have had such great surprise when he heard this statement. In these hearings, and in the general discussion of Watergate, the word cover-up has come to have a broad and very ill-defined meaning. As John Dean said, the cover-up had a broad range. Anything that might cause a problem came within the cover-up. Definition by usage has now come to connote illegal or improper activities, although some steps were taken to contain the Watergate case in several perfectly legal and proper aspects. One, as the President has stated, was to avoid the Watergate investigation possibly going beyond the facts of the Watergate affair itself and into national security activities totally unrelated to Watergate. Another was to avoid, or at least reduce, adverse political and publicity fallout from false charges, hearsay, and so on, arising from various activities in connection with Watergate, such as the Justice Department investigation, the Democratic National Committee suit, the Common Cause suit, the Patman hearings, and the Irvin Committee hearings. A third was concern for distortion or fabrication of facts in the heat of a political campaign that would unjustly condemn the innocent or prevent discovery of the guilty. The containment effort, as I would use the term, did not contemplate or involve any acts in obstruction of justice. To the contrary, while hoping to contain the Watergate inquiry to the facts of Watergate, there was a concurrent effort to try to get the true facts of Watergate and get them out to the public. The President frequently cautioned against any cover-up of Watergate or even the appearance of a cover-up. On the basis of testimony now before this committee, it appears that there also was an effort to cover up as well as to contain. This cover-up appears to have involved illegal and improper activities such as perjury, payments to defendants for their silence, promises of executive clemency, destruction of evidence, and other acts in an effort to conceal the truth regarding the planning and commission of crimes at the Watergate. The critical question then becomes the determination of who committed these acts, who directed them, who was aware of them. I committed no such acts and directed no such acts, and I was aware of no such acts until March of this year, when the President intensified his personal investigation into the facts of the Watergate. I am convinced that the President had no awareness of any such acts until March of this year. The question is asked, how could the President not have known? Very easily. Reverse the question. How could the President have known? Only if he were directly involved himself, or if he were told by someone who was either directly involved or had knowledge. The fact is that the President was not directly involved himself, and he was not told by anyone until March, when he intensified his own investigation. Even then, he was given conflicting and unverified reports that made it impossible to determine the precise truth regarding Watergate or the cover-up, and at the outset at least, he was relying primarily on one man, John Dean, who has admitted that he was a major participant in the illegal and improper cover-up, a fact unknown to the President until March 1973. Any attempt on my part at this time to try to identify those who participated in, directed, or knew of the illegal cover-up would of necessity be based totally on hearsay. There was a concern at the White House that activities which had been in no way related to Watergate or to the 1972 political campaign, and which were in the area of national security, would be compromised in the process of the Watergate investigation and the attendant publicity and political furor. The recent public disclosure of the FBI wiretaps on press and NSC personnel, the details of the plumber's operations, and so on, fully justifies that concern. As a result of this concern, and the FBI's request through Pat Gray to John Dean for guidance regarding some aspects of the Watergate investigation because of the possibility of CIA involvement, the President directed John Ehrlichman and me to meet with the Director and Deputy Director of the CIA on June 23rd. We did so, and ascertained from them that there had not been any CIA involvement in the Watergate affair, and that there was no concern on the part of Director Helms as to the fact that some of the Watergate participants had been involved in the Bay of Pigs operation of the CIA. We discussed the White House concern regarding possible disclosure of non-Watergate related covert CIA operations or other non-related national security activities that had been undertaken previously by some of the Watergate participants. And we requested Deputy Director Walters to meet with Director Gray of the FBI to express these concerns and to coordinate with the FBI so that the FBI's area of investigation of the Watergate participants not be expanded into unrelated matters which could lead to disclosures of earlier national security or CIA activities. Walters agreed to meet with Gray as requested. I do not recall having any other communication or meeting with Walters, Helms, or Gray on this subject. I did not, at this meeting or at any other time, ask the CIA to participate in any Watergate cover-up, nor did I ever suggest that the CIA take any responsibility for the Watergate break-in. I believe that the action I took with the CIA was proper, according to the President's instructions, and clearly in the national interest. There were a number of newspaper stories and allegations raised during the period following the Watergate break-in that posed new questions regarding the facts of Watergate or related matters. Whenever any such questions arose, the President would again ask that the facts be ascertained and made known publicly as completely and quickly as possible. But there always seemed to be some reason why this could not be done. There was no effort on my part to direct my personal attention or take any personal action on these matters because the FBI and the Justice Department were responsible for and were conducting an extremely extensive investigation, and because Mr. Dean was responsible for White House liaison with all aspects of the investigation. I knew John Dean to be an extremely capable, thorough, hard-working, and intelligent man, and I had full confidence, as did the President at that time, that Mr. Dean was, in fact, carrying out this responsibility diligently and thoroughly. There is another aspect to the containment area. It must be recognized that this was the period of a political campaign. There were a number of attacks on the administration, the President, and the reelection committee arising out of Watergate and allegations in connection with it. These attacks were, of course, not helpful to the reelection cause, and there was a continuing effort to avoid any false accusations or allegations from being made in the public press and to answer any that were. There was also frequent discussion of the need for counterattack, the need to point out that while Watergate was not in any way an acceptable or excusable action, it also was not the only improper action by the two sides in that particular election campaign. I have cited earlier some examples of activities that were carried out against the President's re-election effort. Many of the campaign strategists felt that Watergate was getting all of the attention and the improper activities on the other side were being ignored. While there was no effort and no intent to try to impede the legitimate investigation of the facts regarding Watergate and any other criminal or improper activities, there was a concern about the exploitation of unproved charges and the sensationalizing of required appearances by various people for depositions in the civil suit, etc. I was told several times, starting in the summer of 1972, by John Dean and possibly also by John Mitchell, that there was a need by the committee for funds to help take care of the legal fees and family support of the Watergate defendants. The committee apparently felt obliged to do this. In March 1973, Dean told me that at some point in 1972, he, at Mitchell's suggestion, had asked me if it would be okay for him to contact Herb Kalmbach to ask him to raise some such defense funds. He says I agreed. He also says that he checked Ehrlichman on the same point. I do not recall such a request. I should also point out that at some times Dean has said that he checked with both Ehrlichman and me on this point, and at other times he has said only that he checked with Ehrlichman. Later, in March 1973, Dean raised the point that there was a potential problem with relation to the funds for defendants. He described this as a possible political embarrassment and indicated that it might even become a legal problem. The problem would arise if it was determined that these funds had been used to induce the defendants to refuse to testify. I emphasized my clear understanding that the purpose of the funds, as described to me by Dean, was for legal fees and family support, and that I had understood from Dean that both Mitchell and Dean felt this was a proper and important obligation to the defendants. Since all information regarding the defense funds was given to me by John Dean, the counsel to the President, and possibly by John Mitchell, and since the arrangements for Kalmbach's collecting funds and for transferring the $350,000 cash fund were made by John Dean, and since John Dean never stated at the time that the funds would be used for any other than legal and proper purposes, I had no reason to question the propriety or legality of the process of delivering the $350,000 to the committee via LaRue or of having Kalmbach raise funds. I have no personal knowledge of what was done with the funds raised by Kalmbach or with the $350,000 that was delivered by Strawn to LaRue. It would appear that, at the White House at least, John Dean was the only one who knew that the funds were for hush money, if in fact that is what they were for. The rest of us relied on Dean, and all thought that what was being done was legal and proper. No one, to my knowledge, was aware that these funds involved either blackmail or hush money until this suggestion was raised in March of 1973. To the best of my recollection, I had no meetings or discussions with Jeb Magruder regarding Watergate after our phone call of June 18, 1972, which has already been reported, until February 14, 1973. A review of my log confirms that I had no meetings at all with Magruder in 1973 until February 14th. We did meet on February 14th for about an hour and a quarter at Mr. Magruder's request in my office. The purpose of the meeting was to discuss his plans for the future. He felt that the Watergate matter was now settled as far as he was concerned, that his work at the inaugural committee was done, and that it was time for him to make his future plans. He said he was interested in the possibility of running for office in California, and he was also interested in the possibility of returning to a government post in Washington. He was especially interested in a White House position in connection with the bicentennial. I advised him that there was no possibility of a presidential appointment or a White House position until all of the Watergate matters had been cleared up, including the Senate hearings, which were, at that time, about to get underway. I believe that at this time he had just returned from a trip to California, where he had taken soundings as to the political possibilities and his job opportunities. I urged him, if he was interested in California politics, to go to work in private business out there and get himself reestablished in the state and then go into politics at a later point. I recommended that he not consider coming back into the federal government because, if his interests were in California, he now had the need to reestablish himself there. All of this was in the nature of political advice to a man who indicated his interests in running for political office. He said, however, that all of the people he had talked with in California had urged him to go back into government for a while, that he had strong family reasons for him